Okay. I declare open this meeting of the Education and Employment Legislation Committee on Wednesday, 16th of February 2022. The Senate has referred to the committee the particulars of proposed expenditure for 2021-22 and certain other documents for employment and industrial relations matters within the Attorney General's portfolio and the Education, Skills and Employment portfolio. The committee may also examine the annual reports of departments and agencies appearing before it. The committee has decided that answers to questions on notice will be required to be returned by close of business on Friday, 25th of March. The committee has resolved that written questions on notice should be received from senators by close of business Friday, 25th of February. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such an action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purposes of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I draw the attention of witnesses to an order of the Senate on 13th May 2009 specifying the processes by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones. Mobile phones should be switched to silent. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the additional estimates 2021-22 hearings are conducted in a safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. Today, the committee's focus will be on industrial relations matters under the responsibility of the Attorney General's Department. I welcome the Minister for Industrial Relations, Senator the Honourable Michaelia Cash. I'd also like to welcome all representatives from the Attorney General's Department, including Ms Catherine Jones, the Secretary. Minister Cash, do you have an opening statement?
I don't, thank you, Chair.
Ms Jones, do you wish to make an opening statement?
I don't, thank you, Chair.
Oh, good. Well, we will kick off and we are going to Senator Pratt,
Thank you very much, Chair. And we're going to begin our questions today with the Respect at Work report. Attorney General, Senator Cash, the government failed and you as Attorney General failed to fully implement all the recommendations of the Respect at Work report. And I refer to the answer provided by you at our last estimates that said once recommendation 16 had been implemented, you would be undertaking implementation of recommendation 28. So this morning I'd like to ask, please, what action you've undertaken with regards to implementation of recommendation 28, the express prohibition of sexual harassment in the Fair Work Act.
Thank you, Senator Pratt. And these questions were also canvassed, just so you do know, at length in the Attorney-General's estimates yesterday, but I respect the fact that there obviously are industrial relations elements as well. I will get Ms Hender to take you through what progress has been made, but Chair, just in opening and in particular for the committee's benefits, 42 of the 55 recommendations from the Respect at Work report have been either fully implemented or fully funded. I can confirm that work is underway on all remaining recommendations, and I'm sure the committee would be aware that the government did not say no to any recommendations. In terms of the public consultation process that you may have questions on as well, that is now commenced, and there is a consultation paper that has been released, and I'm more than happy to have that downloaded and provided to the committee in the event you'd like to ask questions on it.
I'd like to, yes, go through those consultations,
Yep,
but
we
at
might
the
see if we
outset
can
I
get
was
it.
asking about the implementation of recommendations.
No, I just wanted to give the overarching for you, because I know you will pursue this. Opened on the 6 outstanding legislative recommendations, so that is out for consultation now, and the department will be having a series of meetings with stakeholders.
With respect,
and I'll get Ms Hender to now
Chair, yes.
answer the question directly in
Thank
relation
you.
to those specific recommendations. That's just to give you, Chair, the overarching.
no, that's
to set the
fine.
scene.
I will ask you probably things that touch on the same things later. So, thank you,
Good
Ms
morning,
Hender.
Senator. Sharon Hunder, Assistant Secretary, IR Strategy Branch. In relation to Recommendation 28, the government agreed in principle to that recommendation and will review the Fair Work system once the impacts of the Respect at Work Amendment Act have been assessed. We're intending to undertake an impact assessment in November later this year, so 2022, to see how the amendments that were made in the Respect at Work Amendment Act have developed and how they've operated over the 12 months under which they've been operating. So you'll recall the Act was passed in September, commenced in October, and the provisions that relate to the Stop Sexual Harassment orders commenced in November. So that's why we're undertaking that review at that point.
Okay, so in terms of express prohibition of sexual harassment, of course, there's the stop orders, but there's also the recommendation for a duty.
Yeah, are you happy for us
but
to...
recommendation 28, can you step through the exact process you're undertaking to assess whether you will implement this relatively straightforward amendment, which is to have an express prohibition? You've referred to it as a work plan, and Senator Cashew touched on some consultation and a consultation paper. Is that in relation to specifically about recommendation 28?
The consultation paper is in relation to the 6 outstanding legislative recommendations, and I'm more than happy,
And that
as
includes
I said,
28, doesn't it?
No, it doesn't. So 28 is a separate issue.
Okay, that's what I'm asking about.
Yeah, Ms Hender was
Okay,
just
so who are you
referring to...
consulting with about 28?
So as I expressed, Senator, the department will undertake a review 12 months after the commencement of the Respect at Work Act to assess the impact of that and to assess whether to provide advice to government around the implementation of that recommendation.
Okay, so
Brilliant.
you're not consulting anyone at the moment?
No, Senator Pratt,
Not
and
in
that's
relation
not...
to...
No, in relation to 28 was my
but I
question.
think in relation
You
to...
are waiting to
Senator-
consult till
Senator
you've
Pratt,
seen the
Senator Pratt.
operation of
Senator
of
Pratt.
it.
Senator Pratt.
I'm getting confused.
No, Senator
sorry,
Pratt.
Chair.
The chair has the call here, please, now, and we are less than 10 minutes into questioning, and you have been repeatedly talking over witnesses. I would ask that you let the witnesses have an ample opportunity to answer your question. Happy for you to ask follow-ups, but it is not helpful for the over-talking that is occurring at the moment. Minister, did you
Yeah,
want to
thank
make a
you.
point?
And Senator Pratt, you're going to a number of issues and you're touching on a number of recommendations each time you ask the official a question. So the duty of care, as you know, is a completely separate issue.
I'm just asking about 28 now. Thank you.
Correct, but you were actually verballing what the official said in terms of the consultation. It was always the position of the government that we had made via our first legislative package several changes to both the Sex Discrimination Act and the Fair Work Act. In terms of recommendation 16, you need to, and the position always was, understand what the recommendation does on implementation before you go any further. Ms Hendra, I'll just get you to reconfirm that for the Hansard record.
That's correct, Senator. Minister.
Okay, so just to confirm, you want to understand the effect of 16 before, and you'll have a year before you consult on 28.
So, if I may.
Yep, thank you.
So, Martin Hare, Deputy Secretary, Industrial Relations Group. So, the response to recommendation 28 was clear in that the government identified that they wanted to see how the operation of the amendments to clarify the operation of sexual harassment under the bullying clause, amongst other things, how that actually operated. So to do that, we actually need some data, we need some time for the evidence to develop. We actually need to see how the Fair Work Commission and the courts actually operationalise the clarification. So, and the time frame for that, which is quite a common time frame within our reviews under the Fair Work Act, is to provide a year for the data to accumulate, for us to have the possibility of having a look at the case law, see if there's any issues arising from the case law, see if we're seeing a growth. I think numbers are quite slow at the moment, whether we see an increase, and have a look at a range of factors around that. At this point in time, we haven't identified whether there needs to be any consultation around that, but that's something we'll look at closer to the time once we see what the actual case law and data looks like. So at this point, we know the timing, but we'll actually have a look at what's occurring between now, or between November and probably September, which will give us a good idea of actually how we want to operationalise that review.
So, Chair, could I just, a very concise answer to your question, and I do really appreciate the information that has been given by both the DepSec and the Assistant Secretary. So a concise answer, just so we're all on the same page in relation to this. In terms of recommendation 28, the position of the government always was that we would review the Fair Work system once the amendments proposed under recommendation 16, and I think you know what those recommendations are, have been implemented, which they have, and their impact assessed. So we are in that process now. They've been implemented, they are now in play, we can then assess them, just to be very clear as to where we are.
So recommendation 28 is a preventative measure. It says that there should be a prohibition. I understand that you're waiting for 16 to be assessed, but it doesn't give me an underlying reason for the government to object to the implementation of 28 now.
Yep, so Senator Pratt, and that's why I gave you the overarching statement up front. And again, Chair, if I just could...
I don't think we're going to get any further.
No, but
Can I ask them...
You see, you verbaled me there. I said 42 of the 55 recommendations have either been fully implemented or fully funded. I said that work is underway on all remaining recommendations. I also said no recommendations have been rejected. But in terms of this particular recommendation, it is impacted by recommendation 16. We have made those legislative changes already in our first legislative package. We now need to understand the impact and give recommendation 16 time to play out, at which point in time we'll be able to better understand recommendation 28. So, Chair, that had always been the position of the government.
So what exactly have you learned so far about the impact of the changes that have been implemented so far to the Sex Discrimination Act? And what sort of time frame have you put on understanding this impact? A year, perhaps?
I think we'd already said
month?
that, Chair.
Yeah. So what have you learned so far?
Ms Hender?
Senator, the department's started to commence certainly the consultation process that will sit around some recommendations we're yet to implement, but has also been gathering data and setting assessing the data it would like to use to be able to assess the impact of those changes.
Okay, so what's
Senator.
the data telling you so far?
So, Senator, my understanding of the data is that there's not been a significant increase in activity. We might refer that to Fair Work Commission for the exact figures when they come up. But my understanding at this point is we haven't seen a significant increase in activity.
Why is that when the Respected Work report highlighted a pandemic of sexual harassment? Why aren't these provisions already being used?
So, Senator, there was, for this one, there was from the committee report, or if I recollect, there was actually a delay in implementation of these recommendations as a result of the recommendations from the committee itself. So this one has had less time to operate. Also, so November, I think, was the operation of this particular section. So quite early in terms of the operation of that. That's part of the reason we allow a year. It will take some time, I suspect, for greater use of this to occur, these particular clarifications to occur. So that's one of the reasons, or that's the major reason, that we actually will prefer to wait for a year before we actually have a look at that review. It is important that we actually allow practitioners, unions, other representatives to understand how it will be operationalised and to identify what matters they'd like to progress under this activity.
Okay, so in terms of the consultation, up until Monday, there was no consultation listed on the remaining recommendations on the consultation hub, but you have now highlighted that that's commenced.
Yep, and I'm just
that
Chair, I am
paper's
going to have
available
copies
there.
brought up for you.
And can I ask why this consultation did not commence until Monday this week, when your previous evidence to this committee said it would be concluding this month? And I think Ms Hender, I think you gave that evidence.
Senator Catherine Jones, Secretary, I might be able to help with that one. So the remaining legislative provisions, the department has been doing ongoing work, not just in the industrial relations group, but the part of the department that's responsible for the Respect at Work task force. It did take slightly longer for the department to do the analysis, given the complexity of the different legislative regimes that were impacted by those remaining recommendations. So if you, when we're able to provide you with a copy of the consultation paper, you'll see it draws out quite a lot of significant complex issues in relation to each of the 6 remaining recommendations subject to consultation in the paper.
Okay, I can download that from the internet, can't I?
You can, but we can also provide you with a hard copy through the course of the morning.
Thank you. Why does the consultation currently only exist of a survey? Where's the stakeholder consultation?
We'll take you through that.
So obviously the paper has gone out and does involve an online survey supported by the paper, which has analysis of each of the recommendations. It's then our intention that the online process will be supplemented by a virtual roundtable session with all the key stakeholders across different sectors that we'll need to consult in relation to that.
How many roundtables?
I'd need to take that on notice, but I'm
I'm
maybe able to get
assuming
back
you're
to you
going to
this
do
morning.
more than one virtual consultation, aren't you?
Yeah, no, the intention is that there will be several, given the number of different stakeholder groups across different sectors that are interested in this, in the various legislative amendments.
Okay. You've timed the consultation for the end of March, given Parliament resumes for a week at the end of that month. Can I assume that officers are drafting legislation for introduction in the final days of the parliamentary term before an election?
Senator, I think obviously we wouldn't want to preempt the outcome of consultation. As I said, and you'll see it when you see the consultation paper, there are some challenging issues in terms of implementing these recommendations. We will work through with stakeholders on the feedback that we get, and then we would need to work to commence drafting. So I can't give a specific date as to when drafting would be able to be completed.
Thank you, Chair. I'm going to hand to Senator Sheldon now.
Thanks, Chair. There's a lot of questions I want to get to just after this one, but
Is this the same topic?
same topic
Sorry,
at the
it is.
moment. I'll just ask a question on this. So you've had the report for 2 years, and I just sort of note last week at the National Press Club we heard from both Grace Tame and your former employee Brittany Higgins, who spoke passionately about the need for prevention. And Brittany Higgins referred specifically to the failure to implement the positive duty recommendation in the Sex Discrimination Act. But Recommendation 28 is also a preventive measure, which is obviously one of the critical issues. We want to prevent these matters happening and reducing the likelihood of concurrence rather than acting on matters after they've occurred. So I still struggle to understand what your objection to the recommendation could possibly be. I'm still not clear on that objection because it appears that prevention is almost a priority over some of the other steps.
Yep, I'm happy to address that in the first instance, Senator Sheldon, and then I'm more than happy for the officials to provide you with further information. And it's why I went to what the overarching response is when Senator Pratt asked her first question, and I will just repeat that so we are all on the same page. 42 of the 55 recommendations have been either fully implemented or fully funded. Work is underway on all remaining recommendations, and as I said to Senator Pratt, no recommendations have been rejected. In terms of recommendation 17, which is the recommendation you're referring to, the positive duty, this is one that we had always been upfront about, does require further policy consideration and consultation. I am going to have copies of the consultation report, the consultation paper brought to you, so you can have a look at that. And we'd always said, and it was an issue that was raised in the respect at work on the duplication of duties, etc. One of the things we need to properly understand is how such a duty would operate effectively alongside duties that already exist under work health and safety laws, and I won't take you through them because I know that you are familiar with duties under work health and safety laws, and the Sex Discrimination Act. We would need to be very, very careful to ensure that additional complexity is not then created for those seeking to use the protections. Because what we don't want is to implement something that then it actually becomes a barrier to people using it. Hence the staged response of the initial legislative package, work continues on other recommendations, the consultation paper, the understanding of some recommendations and how they might impact. So this one is now out for consultation. The other issue that is raised in terms of this recommendation is significant thought also needs to be given before providing the Commission with inquiry and regulatory powers for discrimination and harassment in addition to its existing dispute resolution function. In terms of getting the feedback from the consultation, it's important to ensure that any positive duty in the Sex Discrimination Act is carefully designed, as I've already stated, so that it operates as intended. And again, how does it actually sit alongside the positive duty that is already in work health and safety legislation? and doesn't then create confusion, uncertainty and act as a barrier. But I will get either Ms Hender or Mr Hare to provide you with some further information.
If you could just go to the question of recommendation 28, why I still appreciate the overview you've just given,
yeah.
but recommendation 28, because there's two issues at play here. One is there's a report that the government's had for 2 years. There's all these questions that have been raised about technicalities that seem to have been able to be dealt with in the last 2 years but haven't been. And now we're saying one of the most critical recommendations, which helps the prevention of sexual harassment at work, is having to wait even longer. So we may be looking at, under the time frame we've just been given, we may be looking for 3 years for an important preventive measure that was originally recommended to even be properly considered on whether it be put in place. So it's 3 years plus. It's very disturbing.
So, Senator, again, it's clear from the government's response that it always intended to review the impact of other recommendations before implementing recommendation 28. The recommendation, from my reading, says the Fair Work system be reviewed to ensure and clarify that sexual harassment using the definitions in the Sex Discrimination Act is expressly prohibited. So it's an ensure and clarify. So part of looking at that, we need to have a look at the operation and the other changes that were made. I take you to recommendation 29, which was to introduce a stop sexual harassment order equivalent to the stop bullying order. So clearly there is, and that recommendation was implemented as a clarification of the law. So it's clear the Fair Work Act does have the capacity to deal with sexual harassment. I'd also take you to recommendation 30, which again was implemented, that identified that the Fair Work Act should amend section 387 of the Fair Work Act should be clarified to ensure that sexual harassment can be conduct amounting to a valid reason for dismissal in determining whether the dismissal is harsh, unjust or unreasonable. And again, that was implemented. So there's no doubt that the Fair Work Act does have the ability to deal with sexual harassment. What we're interested in having a look at is having a look at changes both in the Sexual Discrimination Act, the changes already made to the Fair Work Act. What does a clarification look like? What is actually needed in there to make sure that we continue to improve the effectiveness of the system? So from my view, I think it's very clear the Fair Work Act deals with sexual harassment. The question of how do you actually amend or clarify, I think you need to take into account once you've seen these changes, these clarifications operationalised. So I don't think it's accurate to say the Fair Work Act doesn't deal and doesn't provide preventive measures. In our view, it does provide a framework where people know that sexual harassment is not acceptable behaviour, is not allowable behaviour in the workplace. But that doesn't mean, and the government's clear, the recommendation was accepted in principle, but with the review, and my understanding is that the response was clear and they said that review would be 12 months from the passage.
And the other issue, Senator Sheldon, it does go to a number of the comments that were made by Commissioner Jenkins in the report, sort of flowing through it when you read the different recommendations depending on what they're actually directed to. And I've just had this, that the existing sexual harassment framework should be amended to promote clarity, cohesion and consistency. Hence the first legislative package, that was a great step in terms of they could be implemented quickly. And then the next legislative package we need to get right so we do ensure that we're consistent with what Senator Jenkins said in terms of the clarity, cohesion and consistency, and not actually creating the confusion and then a barrier.
Thanks, Minister. Just taking into account the answers you've given, and I'm just going to go to ILO Convention 190, which I wanted to talk about in a moment. But just sort of, it does still raises the issue that this is now the steps that have been taken to bring in recommendation 28 is going to be more than 3 years after the report was first produced. So that's concern about the preventive measures that are necessary, that have been considered that will be necessary in 28 is very, very much delayed because this report took so long. So on the ILO Convention number 190, is the first international, which is as we're aware, first international treaty to recognise the right of everyone to a world free of violence in work, harassment at work, including gender-based violence and harassment at work. Of course, as we know, the Convention was adopted in June 2019 by the International Labour Conference of the International Labour Organisation and came into force on the 25th of June 2021. The last estimates, Minister, you indicated you were preparing legal advice was being prepared to the government on whether legislation would be required in order to ratify ILO Convention 190. Can you advise as to whether you have obtained that legal advice yet?
Senator, so it's actually quite a complex review. My team have received the preliminary analysis. It is quite complicated and detailed, and we will work with the Office of International Law in terms of working through that analysis. This is a process that is a very standard process, and we are currently running to the schedule that we had anticipated. We had identified that we'd received the advice in February, the preliminary advice in February, and that's when we received it. As you know, Senator, this is a process that Australian governments take very seriously, and they work through the laws in every jurisdiction, including the Commonwealth, to make sure that there are no barriers to ratification of the convention.
Thank you, Mr.
So we're
Yoder.
still currently progressing that, but we're on schedule at this point.
Thank you, Mr. Hare. I just want to, are you able to just give us a broad brush commentary about what the complications are?
Well, the complication...
Have we not got legislation in place? Is that one of the considerations that...
So that is one of the factors that would be looked at for every state and territory.
Yeah, and that's one of the issues. And I think we discussed that last time. Every state and territory has to look at its own laws.
Yeah, the fact that it will actually be multiple acts, it won't just be one act, and that there are inevitably, in a federation such as Australia, there are differences between the jurisdictions, and there'll be questions of interpretation. So you also then have to go over look at the case law associated with it. My understanding is the preliminary advice is about 50 pages worth of advice at this point. So we're just working our way through it.
And just on that, I think we talked about this last time, but just in terms of just itself, the law and practice assessment report, I mean, that it's substantial. It reviews the operation of federal, state and territorial legislation, policy and practice across work, health and safety, industrial relations, criminal privacy, public sector management, and it is a substantial domestic violence framework. It's a substantial body of work. But as Mr. Hare has said, we are on track.
Yep. And thank you for that.
Yeah.
Have you identified any gaps in the Australian law and policy in your assessments so far, the ILO C190?
Probably too early to say this. I mean, as I said, there's approximately 50 pages of advice. My team will work through that advice with the Office of International Law to actually just clarify and make sure that everything is covered, or if there are issues, identify those issues. As part of that process, if there's an issue with a particular jurisdiction, we would go back out to that jurisdiction and talk to them about their interpretation. And then come back and do a further assessment. So,
Minister,
I would need to take on notice whether there's been any red flags at this point.
Yep.
If you could take that on notice, that would be helpful. And just, Minister, is the intent for the government to ratify ILO Convention 190, or is this going to be kicked down the road?
Well, at this point in time, we're going through the process. The department now, as Mr. Hare has said, will undertake an analysis and will review the advice that's been provided. They will then provide advice to myself, where I'll be briefed on it. But at this point in time, it is a substantial process that we are going through. It is the process that I think we discussed last time when you're looking at ratifying something like this, there is a very long process that needs to be gone through to ensure that we do obviously get it right, and that is consultation with the states and territories. The states and territories providing us with that assessment in terms of the operation of their legislation, etc. So at this point in time, I then now need to await the outcome of the review of the advice.
I just appreciate that.
And I think, unfortunately, you and I know.
I respect that. I respect
yeah, and
the
we had
step.
this discussion last time, and it is very much. I do need to await the proper process is to await now.
I'm intentionally using the word intent.
No, I know.
Is the intent
No.
to-
And I
to bring
completely
the
understand
mention. I
that, but-
appreciate that
yeah.
there's contributing factors to that intent.
I do need to await the outcome of what the review procedure has been and have a look at what's provided then to me to have a look at it. But in terms of questions that you have previously asked, and I do for you 110%, I understand you are very genuine on this, very genuine. It is as per the usual treaty ratification process. As much as it is taking time, this is the usual treaty ratification process, and I now await advice or a briefing on the assessment, because that is important. We do need to understand the nature of the assessment. And as you've said, are there any gaps or not? And I do now need to await that from the department.
And I'll just as I hand over to my colleague, I can only take that we haven't got the intent clear about whether we're going to implement the convention, but I understand this process.
We have to go through a process.
This process is being followed. A decision
Correct.
has been made about the intent.
Yeah, we've got to go through the process.
Sorry, just before we do that, I'm going to rotate the call to Senator Davey. Yeah, we had 30 minutes there, but of course you will have another opportunity. One follow-up, Senator O'Neill. One.
You described process and a schedule many times in that interaction with Senator Sheldon. So I'm assuming that you do have that process outlined and the schedule framed
it's the
up.
normal process that you would
So I
go
just wonder
through.
if you could provide on notice some dates, times, forward planning, so that we can get a sense of what your timing is, given Senator Sheldon's very ably made the
understood.
point that, it's more than 3 years since you got things going.
And I think it also needs to go to the Joint Standing Committee on treaties as well, as part of the process for those who've sat on the Joint Standing Committee on treaties.
So for those of
before.
us who haven't, can you expose the bones? I can't be clearer than
But
that.
you'd like on notice, you're happy for us to do that on
Taking that
notice
on-
for you? Yep,
Thank
that's
you.
fine.
The Minister
If
has
I may
taken
just
it.
provide
Okay, Mr. Hare.
one qualification to that. So if the process does throw up significant barriers that actually require changes to state legislation, that's something outside of our control. So there will be a number of qualifiers in terms of what the process looks like, because it can take a very long time for states to change legislation if that's what's required. So to a certain
Hence
extent,
why
I can give
I
you
now
a
wait for this
broad
part
one.
of the process to come to me, because that review has to be done by the department of the assessment.
Okay. So just before we go to Senator Davey, I'm just checking that we're, as a committee, happy to have tabled the consultation paper.
Yes,
The respected work.
Senator Pratt and Senator Sheldon, I said that I could get a copy of the consultation paper for you that has been released. This is directly from the department's website, and it was what the Secretary was referring to in answers to questions from Senator Pratt, Chair.
Okay, well, we'll accept that as tabled. Senator Davey.
Thank you, Chair. For the department, we've spoken a lot this morning about the respect at work, the legislative changes that we're progressing, and obviously I note the areas of concern that Labor keep raising. But can you also explain to us what work is going on behind the scenes to ensure we deliver on the government's response to the Respect at Work Act?
Could I jump in first, Senator Davey, and then I will refer to Mr Hare or Ms Hender, who will come back. And again, just to give the overarching understanding of where we are on the Respect at Work report, and as I've outlined to Senator Pratt, significant progress has been made on implementing the Respect at Work recommendations. And just to reconfirm that 42 of the 55 recommendations have either been fully implemented or fully funded, and work is underway on all of the remaining recommendations. And to reconfirm, no recommendations have been rejected. Just to give you a brief summary of some of the funding commitments, we committed significant funding of $66.5 million for implementation of the roadmap in 2020-21 and 2021-22 in those budgets. We are delivering on a range of initiatives, including, as we've discussed this morning, passage of the Sex Discrimination and Fair Work Respect at Work Amendment Act 2021 and an amendment to the Fair Work Regulations. As we've previously discussed, we've established the Respect at Work Council, and that will lead implementation of a number of the key Respect at Work report recommendations. We have substantially boosted legal assistance to provide for specialist lawyers with workplace and discrimination law expertise, with additional funding of $43.9 million. We also provided funding of $1.37 million to the Australian Human Rights Commission. They were actually on yesterday or last night in Attorney General's to progress 10 recommendations, including the development of practical tools and resources to support greater education and awareness of how to address sexual harassment in the workplace. These tools are currently being tested with stakeholders. 13 of the recommendations are being progressed with the states and territories, because if you recall, not all of the recommendations were directed to the Commonwealth Government. Some were to the Commonwealth Government, some were to the Commonwealth, state and territory governments, and some were obviously to industry itself. So 13 are being progressed with the states and territories, including through intergovernmental fora and the development of the next National Plan to End Violence Against Women and Children. In terms of the working women's centres, and again this was canvassed last night or yesterday in the Attorney General's portfolio, we've recently provided a further $350,000 in 2021-22 to support the continued operation of the Queensland and Northern Territory Working Women's Centres, bringing the total commitment to $550,000. We have also commenced, and now to go to the document which has just been tabled with the committee, the public consultation on the remaining legislative recommendations. The public consultation will close on the 18th of March, and I think the Secretary has already said a number of stakeholder meetings will also occur regarding the consultation. The department will then consider the stakeholder views and prepare advice for government. And again, as the Secretary had referred to this morning, this approach reflects the complexity of the remaining legislative recommendations. So, Chair, that's just a brief overview on all of the progress that has been made, but I might get Ms Hender now to give you some sort of additional information and flesh out that for you.
Senator, there are a couple of additional measures, budget measures as well, that I will mention. One was $1.7 million to the WHS regulator Comcare to run forums for Commonwealth, state and territory WHS inspectors around sexual harassment and training for employers on the Commonwealth laws. There was also funding provided to WGEA of $6 million over 4 years to strengthen reporting on sexual harassment prevalence and prevention. There was also funding provided to conduct further research and develop evidence-based strategies and media guidelines to Our Watch, Australia's national research organisation for women's safety, ANROS, and 1800 Respect, to build the evidence base and develop primary prevention initiatives to respond to sexual harassment. As the Minister mentioned, there is the Respect at Work Council, which has a wide-ranging membership. It's met 5 times since establishment in July of this year. July of last year, it was March last year. And it brings together the Fair Work Ombudsman, Fair Work Commission, Safe Work Australia, heads of workplace safety authorities, the Australian Council of Human Rights Authorities, WGEA, and the department, along with some external members, the Australian Chamber of Commerce and Industry, AI Group, Kingsford Legal Centre, JobWatch, the Australian Council of Trade Unions, the Australian Building and Construction Commission and the Council of Small Business Organisations.
And have that council in their meetings, obviously I'm guessing that they are monitoring all this work going on, significant amount of work that's going on. Have they ever raised concerns that it's taking too long or that we're sort of rushing things, or are they comfortable with the fact that this is a complex area and we've got to get it right rather than...
The council are working very cooperatively together and are keen to continue to progress the recommendations and are very supportive of the work undertaken by the department and the agencies themselves. So not to my understanding, Senator.
Senator, if I can just add to that, because I participated in the last meeting of the council as an observer, and I think it's fair to say that every participant on the council is incredibly committed to supporting the government to implement all the recommendations, and it's an incredibly positive and engaged forum, and it's been very helpful, and is meeting again this Friday. So they're keeping up a pretty...
it's a regular...
it's a very strong tempo of engagement
seriously,
and giving us great support, guidance and encouragement to keep going as we are, as quickly as possible.
And the council as well, because it covers both employers, employee organisations and, you know,
industry
fair
and
work,
all of
industry.
fair works of the bodies, regulators.
So are they a good forum to be able to sit down and work through issues to identify potential unintended consequences? Because we know that sometimes things that aren't widely consulted can...
We certainly see the council as one of a range of mechanisms to be able to tease that out, and where we obviously support the chair, Kate Jenkins, to ensure that the issues that are being considered by the council help us work through those sort of issues. But there is incredibly broad expertise there, as you said, representing interests across various sectors, but also representing the experience of people who have suffered from workplace bullying and harassment, and bringing that lived experience into the conversations as well. So it's not just engaging with institutions, it's also engaging with stakeholders that can give us that real experience.
Great. That's all from me. Thanks, Chair.
I was just, Senator, there's just one additional piece of work that I think it's worthwhile talking about the progress on that, which is recommendation 35, the Work Health and Safety Regulation and Code of Practice. So that work is being progressed by Safe Work Australia. There's both the guideline, which is slightly broader in its framing than just simply sexual harassment. It's a broader guideline around psychosocial, but it also includes specific information around sexual harassment. And then there's also work progressing on the Code of Practice. In terms of the update, Work Health and Safety ministers were provided with an update on the progress of that in December of last year, in December 21, and again that work is progressing according to schedule.
Thank you, Mr Hare. Now we're giving the call to Senator Sheldon.
Just a follow-up question on the previous, and then I'll go to some matters on some other matters. What's the recurring funding for the workers' women's centres, working women's centres things? So where are we up to on that recurrent funding question? Because it's obviously one of the key issues about trying to forecast services that can be provided for women being exploited?
Assistant Secretary, Employee Entitlement Safeguards and Policy Division. The issue of recurrent funding is, or funding beyond this financial year is still under consideration, as the Attorney outlined, in addition to the $200,000 that we've spoken about at previous estimates. A decision's been made to allocate another $350,000 to 2 centres for this financial year.
Can I add a little bit more to that, because this is obviously part of the recommendations in the Respect at Work report as well. So as Mr Manning has said, and I had previously stated, we've provided the additional $350,000. That's for Queensland and the Northern Territory Working Women's Centres, because as you know, not every state and territory actually has a Working Women's Centre. I think it's South Australia, Queensland and the Northern Territory. So there are only those 3 states that have the Working Women's Centres. That interim funding has been provided while the future funding arrangements are being considered. Recommendation 49 of the Respect at Work report goes directly to the Working Women's Centres, but as I've said previously, that was directed to Commonwealth, state and territory governments. Last year in June, I convened an extraordinary meeting of the Attorneys General in response to the recommendation. Members, and I needed to get their agreement to do this, the states and territories agreed to task officials to review the scope of services provided by Working Women's Centres and other like services, and to consider the feasibility of funding of services, including under the National Legal Assistance Partnership. And so at this point in time, that additional funding has been given to them as interim funding, and we're working through what future funding arrangements would actually look at. If the Working Women's Centres included legal assistance services in what they do and became accredited as community legal centres, they would then fall within the scope of the NLAP and would therefore be eligible for NLAP funding. There's a number of issues that we're working through in relation to that, because that's for the states and territories. But just to sort of give you that visibility of the work that we are doing with the states and territories, because they are the ones who ultimately will be making the decisions.
Minister, on the recurrent funding question, has there been in that scope of conversations what recurrent funding could potentially look like?
I'm having Mr Manning to update you on what...
Our understanding, Senator, is that the centres believe they require about $700,000 per annum to operate. As the Attorney pointed out, recommendation 49 was a recommendation to all Australian governments. From the Commonwealth's perspective, given the responsibilities and work of those centres, it would be appropriate that if there is to be government funding, it would come from both state and Commonwealth government.
Sorry, I missed the recurrent funding part of it, what you just said. So is the recurrent funding... What the
centres have advised us is they would require up to $700,000 a year to operate, and that recommendation 49 was directed at all Australian governments, so both state and Commonwealth government funding.
Hence the process we're currently working through with, because as you know, states and territories do it differently, and one of the issues that we were working through with them was if you wanted to provide them with funding via the NLAP so that you could actually fund them as a body, there are some qualifiers you would need to actually... So that's the process we're working through. But in terms of our commitment to them, we knew that they needed that additional injection, so we have provided that to them.
I might be missing something in the answer, so if you can bear with me on the recurrent funding. Does that mean that it includes the question in the conversation with the other states for recurrent funding as part of the question as well?
It's a question, absolutely. Literally, review the scope of services and then consider the feasibility of the funding of the services under the National Legal Partnership, so yes.
Thank you. I just want to go to the appointment of Joanne Farrell as Chair of Safe Work Australia.
Sorry, just you're calling Safe Work Australia?
No.
The appointment process.
Okay, the appointment. Sorry. Okay, that's fine. That's fine.
Okay. Good. Thanks very much. Are you aware of a report released earlier this month by former Sex Discrimination Commissioner Elizabeth Broderick into the workplace culture at Rio Tinto. It was delivered on the 1st of February. Minister.
Oh, sorry, to me.
Yeah, sorry.
Sorry, no. I am aware of, I'm not personally aware of that particular report.
Be aware the report exists.
I'm aware of the report exists from reading it in the press, yes.
Are you able to summarise the findings of that report as you understand it from the press?
Not at this point in time, no.
Are you able to give any indication that you have what the report may have contained?
My understanding, and again it's from reading it in the press though, is issues in relation to sexual harassment more broadly within the mining industry, and in particular FIFO workers.
It found a systematic culture of bullying, harassment and racism, including 21 complaints of actual or attempted rape over the past 5 years. Did anyone in your department raise that this is an area, had anyone raised with you directly about the seriousness of this report?
I don't think anyone underestimates the seriousness of the report, and certainly my understanding is from what I've seen from, in particular, the resources industry in Western Australia, they take these allegations very, very seriously.
Well, I mean, I could give you quotes about where they weren't taking it seriously, because in actual fact, there was a number of people within the government who were saying it was a union beat-up along with the companies and their associations, so prior to this report being delivered. So I'm very mindful that they weren't taking it seriously, the industry. I'm just trying to work out how seriously the government's taken this report. I'm going to ask an obvious question. You wouldn't describe it as a good workplace culture, would you?
Well, again, I'm not going to pass comment on this. What I believe you're going to is obviously the appointment of Joanne Farrell as the chair of Safe Work Australia. And if you want to discuss Ms Farrell's little appointment, I'm more than happy to do that.
Oh, I'm asking specifically about the report first.
Well, I would need a chair. With all due respect, I would need a copy of the report before I'm prepared to comment on it any further. To be fair, Senator Sheldon.
I respect the fact that you would need to look at a copy of the report. What I'm trying to ascertain your knowledge of the report, if I correctly understand, you're saying that you're aware of that there is cultural issues. If I correctly understand, there has been a series of allegations of attempted rape, sexual harassment, bullying, racism. And in the case of Rio Tinto, were you aware that there was 21 complaints of actual or attempted rape over the past 5 years?
Someone has now sent me the media article I believe you're referring to, which refers to a number of these allegations, yes.
Were you aware of it before you just read that article?
I was aware of the issue, yes, because I had read about it in the media.
Thank you.
But I'm not going to comment on a specific report because I haven't got it in front of me.
Thank you. Would you describe the Rio Tinto as a safe workplace for its workers, particularly women?
My understanding is, and if in reading the report, they are absolutely going to be putting in processes to address this behaviour. I mean, all companies have to, under work health and safety obligations in particular, the welfare of their workers should always be paramount. No person deserves to go to work and be sexually harassed, be racially abused in any way whatsoever.
Thank you.
Senator, I mean, I'll let that question go, but I would ask that questions relate to the functions and responsibilities, finances of government departments, asking opinions about other companies outside of those departments that would only barely relate to this estimates process.
I intentionally indicated that the matter... thank you, Chair. I intentionally indicated that the matter that I was going to raise to give the Minister an opportunity to consider some of the answers to these matters is the appointment of Joanne Farrell. Part of that appointment of Joanne Farrell is about the work environment that existed with her previous employer when a selection process takes place. So I'm asking it in that context when I'm asking these questions. And as part of that context where Joanne Farrell had a senior role responsible and cutting across these key areas that I'm raising, bearing in mind that during her tenure that 30% of women surveyed for the report said that they had been experienced sexual harassment. I know you're not aware of the exact details of the report, Minister.
Yeah, I don't have
That's
the
the answer
report in
you've given
front
me.
of me. My understanding is, though, as well, that they have asked Elizabeth Broderick now to undertake an external report because they do take the issue seriously.
Minister, were you aware that there was a report being prepared into Rio Tinto before the appointment of Joanne Farrell, the head of Safe Work Australia?
No, I was not.
Did anyone in your department advise you? So no one in the department advised you that there was an investigation was taking place?
I don't believe so. And just in terms of the consultation and the qualifications of Ms Farrell, and I am prepared, I will go through them with you. As part of the consultation process, State and Territory Work, Health and Safety Ministers, I understand, and the department can confirm for me, were consulted in relation to the appointment, because we need to do that, as you know, under the Safe Work Australia Act, and no concerns about the appointment were raised. And you'd be aware that subsection 11.2 of that Act provides that the Minister can only appoint a chair if the State and Territory Work, Health and Safety Ministers have been consulted about the appointment of the person, and they raised no concerns in relation to the appointment.
Thank you, Minister. Minister, to the department, did someone, maybe you might be able to assist as well, in the appointment of, was there a report prepared by the department on the strengths and weaknesses of the candidate? Can you just describe to me what sort of report comes to the Minister? I'm surmising that there'd be a request of the department to have some degree of investigation of the individual.
I think my understanding is that the appointment process itself, and I'm happy for the department to confirm this, was conducted prior to the release of Rio Tinto's external review of its workplace culture, and was subject to the appropriate due diligence processes and, as I've already stated, the requirements set out in the Safe Work Australia Act. And it was in January, I believe, that we announced the appointment of Ms Farrell.
It may assist when the department's giving the answer, and appreciate you've handled that to the department, I concur. But just when they're answering that, if you can include, were you aware that there was an investigation into Rio Tinto taking place?
Are you happy for them to take it on notice to have a look at that?
Well, they might be able to answer it now.
So, Senator, I'm not sure that I'd need to go back and check, but I don't recall being aware at the time of this process that there was the investigation, but I need to check that. I might pass to Ms Sheehan to talk you through the actual process.
Thank you, Ms Sheehan.
Anne Sheehan, First Assistant Secretary, Industrial Relations Legal Division. The Minister's outlined the process, the legislative process in terms of the appointment. That is that the Minister can only appoint a chair if State and Territory WHS ministers have been consulted, which they were, and as the Minister said, no concerns were raised. In terms of the department's process for an appointment such as this, a submission would be prepared with information about potential candidates, which would outline their qualifications, their background, a due diligence process, including information about their CV and qualifications, and that would be provided to the Minister.
In a simple Google, Mr. Here, just again the process, and I appreciate you've given your answer, but just extending onto that. In the case of actually doing a review of potential candidates to assist the Minister, would it be normal practice to look at what is both the individual but also what issues may be arising at their previous employer that may have impacted the individual either positively or negatively?
Again, I might pass to Ms Sheehan, whose team does the process for the detail of that.
There would be there is a due diligence process in terms of researching and finding out information about the candidates, that is focused on their qualifications and experiences. If there were, there are, I guess, internet searches that go with that in terms of whether there are particular issues that the department would need to consider. I don't think that it would extend to issues affecting that industry or that employer in a more general sense, as opposed to that individual.
And I appreciate the generality of the way I asked the question. I'm just going then specifically to, we're looking for someone to be appointed in a government department, in this case Safe Work. Was there an investigation into the areas of responsibility that individual had? For example, there was a series of stories that had been doing the rounds about the Western Australian mining industry, which the Minister's rightly drawn my attention to. There was statements made by unions and employer associations and employers about the veracity of those allegations. There was a lot of discussions about the needs that this would be an ongoing problem. It would seem to me that would be a fundamental thing to look at about, does that impact on the candidate, because they are very publicly Googleable, for such a word, information that could be found. Was that done? Was that information looked at and considered?
Senator, can I just perhaps go to part of the process here? So, as you're aware, Safe Work Australia is a national body, and its members are made up of states, territories, Commonwealth and the social partners. As part of the process here, all jurisdictions are written to, recognising that work health and safety law is the responsibility of the jurisdictions. We would certainly have anticipated that if there were significant concerns about what was occurring in Western Australia in terms of work health and safety matters, that would have been raised.
The Western Australian Minister would have raised it, and as I've confirmed, there were no issues raised.
So certainly we do look broadly, but recognising that until a report is finalised, it's hard to necessarily deal with speculation. And until we actually see a report, it's not finalised. So beyond that, we do have to rely quite extensively on the actual work health and safety responsibilities, particularly for this one. And as I said, no jurisdiction wrote back and identified an issue with Ms Farrell. So we'll take on notice the detail of the process for you, but certainly at the time the report wasn't finalised, and as we said, that all the jurisdictions who do have responsibility for work health and safety matters didn't identify any concerns with the appointment of Ms Farrell.
And can I also just say, Chair, and we'll talk about a right of reply to this hearing from Ms Farrell shortly, because I think that is important. She was appointed, I just found the appointment date, it was the 14th of December of last year. We also, Senator Sheldon, do need to make it clear the Broderick report did not make any findings of any wrongdoing against Ms Farrell, and I hope you're not implying that it did, because I think you know that it didn't. She is eminently qualified for this role. As the Deputy Secretary has said, there is a statutory process that must be followed under the Safe Work Australia Act, and that is going out to the states and territories and consulting them on the appointment. No concerns about the appointment were raised. But, Chair, I would say senators are able to raise issues in these estimates hearings about people. That is done. But I think it is important to also note that should Ms Farrell want to, she does have the opportunity under the standing orders to provide a right of reply to the issues that have been raised.
And that would be appropriate, Minister. I'd have no problems with that whatsoever. I appreciate it's her right anyway, but I certainly wouldn't have a problem with that.
I just because...
So I might just then go to, and I'll contextualise then the question that I'm asking with more recent facts. And we've noted that there was certainly controversy within the mining industry in Western Australia about what was happening. So we're going to being chair of Safe Work. It requires being obviously people's person. It's issues of culture. It's the driver of culture in a broader policy sense. So it's important about how successful people have been in that role. In the Broderick's findings include that in many workplace settings, bullying is normalised, and that employees do not believe that the organisation is psychologically safe, which impacts on their trust in the reporting systems. Now, I understand very much that Joanne, Ms Farrell's role was the company's most senior executive responsible for the safety of workplaces, where last year's bullying was found to be normalised, and for the health of the employees in them. So it does correlate concerns about effectiveness and capacity. And I am deeply concerned about there was indicators prior to that the department was doing some due diligence. I'm raising serious questions about what that due diligence was. And would it be normal, I'm talking now more generally, would it be normal practice with those candidates to question their performance on issues that are raised prior to the Broderick report? There was issues raised in the media, so would it be normal practice for candidates generally to be asked questions from reports that are in the media in matters that are relating to the position they're applying for?
Senator, so I think I've taken the substance of that on notice. So Ms Shan's talked you through the broad process. I've taken on notice that I'd review to see whether we were aware of any media reports around Ms Farrell as part of that process. Certainly from my recollection of the process, a look at the qualifications, their history and their capacity is absolutely part of the process. But again, we'll provide you the detail of that on notice.
Can you then just take me through what qualified Ms Farrell for this job?
I can run through some of her qualifications
Well, what you saw qualified her for this job. I can get a list of qualifications on her LinkedIn. I'm asking what were the qualifications that brought her to this job? So I better just say it a bit clearer. My apologies. I'm appreciative that there will be on LinkedIn a list of qualifications that will be on that. I'm not asking for that. What I'm asking is what are the qualifications on the recommendations for her to be appointed did she bring to this job?
So in terms of to start with the legislative requirements, as it's sometimes the case in legislation, it sets out particular qualifications that are required for a role. The Safe Work Australia Act doesn't prescribe particular qualifications for appointment as chair. The only requirement in the legislation is for the minister to consult with state and territory WHS ministers, as we've covered, which was done, and no concerns were raised. The department considered that Ms Farrell is qualified to be appointed as chair. She holds positions such as the non-executive director at the Royal Flying Doctor Service, WA Museums. She's a member of the Senate of the University of Western Australia, and as we've covered, was previously managing director, Australia and Global Head of Health, Safety and Environment at Communities at Rio.
So she wasn't asked in its broadest terms, that I'm not asking for the details of her responses. I can ask that of her if need be. Companies, was she asked about the responsibilities? Would she be asked, or would a person be asked? So I'm saying it in two ways. Responsible for the safety of workplaces, where would that be something they would be asked about? So if there's a role in safe work, would you be asked about, do you understand about safety of workplaces? A very fundamental question if you're going to be the chair of Safe Work Australia.
And continual improvement of that safety.
So, Senator, I think in a process like this, obviously for the department, it's critical that we're able to support the appointment process, to understand previous positions that someone has held. I think clearly being responsible for health and safety issues at a company of the size of Rio Tinto would have required someone with extensive experience across work health and safety, and undertaking that role in such a large corporation in a challenging environment, I think has probably provided Ms Farrell with extensive experience that was considered very relevant to the role of the chair of WorkSafe Australia.
Chair, can I just ask another question? Do you think the government understood what was going on in the workplace culture at Rio Tinto at the time when she was appointed?
The Rio Tinto report was released after the appointment of Ms Farrell.
Okay, so
Ms Farrell
in
was
that
appointed
context,
on the 14th of December 2021.
I understand
Chair, just
that.
in relation, I do
I understand
want
the
Ms
issue
Farrell
with
to
the
be given
dates.
the right of reply in relation to the allegations that are being made about her. She has more than 30 years' experience in work health and safety.
Senator Cash, I had a question I wanted to ask and you weren't
I'm responding to
asking
Senator
the
Sheldon's
question.
question in relation to the qualifications. As has been articulated, she is a non-executive director at the Royal Flying Doctor Service, WA Museum. She is a member of the Senate of the University of Western Australia. In terms of her previous qualifications, Managing Director Australia and Global Head of Health, Safety, Environment and Communities at Rio Tinto. In terms of her professional qualifications, in 2012, the Australian Institute of Company Directors. In 2000, the Senior Leadership Program at the London Business School. In 1994, the Business Leadership Program at the Australian Graduate School of Management. From 1985 to 1986, a Graduate Diploma in Business Administration at Curtin University. Her basic degree that she did in 1974 to 79 is a Bachelor of Science, Psychology and Economics at the University of Western Australia. She actually worked between 1979 and 81 with the Western Australian State Government. She has held.
Sorry.
Well, you do because you are questioning.
My
questioning.
I'm not
capacity
questioning her
to discharge this role.
Minister, I'll
Chair.
just, Senator Pratt's asked to raise a point of order.
I want to ask
Raise that.
if in her appointment she reflected on her experience in Rio Tinto, not as a shining, glorious example, but as part of the challenges of upholding workplace safety culture.
Senator Pratt, that's not a point of order. It's not a point of order. Senator Pratt, you'll have another
But it
opportunity to ask.
wasn't my question,
Okay,
and
but
this is
I
the
can't ask the minister
point.
to answer the question a certain way.
No, I'm asking not
sorry.
about her qualifications. I'm asking about whether she reflected on her experience at Rio Tinto
Well, sorry,
in the
Senator Pratt.
context of that report.
Sorry, Senator Pratt.
Because it may be helpful to her
Senator Pratt, you
appointment,
raised.
or it may
You
not
raised.
be.
If you want to raise a point of order, you've also got to let me rule on it. There is no point of order. The minister is being relevant to your question. I'll let the minister continue.
Thank you. And just in terms of the qualifications, as I said, various roles in human resources at BHP, and then global roles in particular in health, safety, environment and Managing Director Australia at Rio Tinto and the Global Head of Health, Safety, Environment and Community. She has an extensive resume, over 30 years' experience. I hope you are not implying in any way that Ms Farrell has been engaged in any wrongdoing, and that is why I would like Ms Farrell to have the right of reply. It is also important to note for the Hansard record, given the allegations that have been raised, what Ms Broderick herself says The report is not a reason for reduced confidence in Rio Tinto, as its actions in commissioning the report demonstrates a very clear commitment to increase transparency, accountability and action.
Now, I might take this, sorry, Senators, I might take this opportunity to rotate the call, if that's okay. It's been over half an hour on your side. I won't be too long. I do have some questions myself on the coal long service leave.
Okay, different topic.
Report or review, I think just recently published by KPMG. So I will wait for officials to come to the table. Now, I believe this report has literally just been published this morning, so I haven't had an opportunity to look through it in complete detail, but I presume some of the officials of the department may have had it for longer. I've been particularly interested in how this scheme operates in terms of its coverage. There's a lot of uncertainty in the coal industry about who is covered and who is not, and also on the treatment of employees with different, or perhaps you could say non-traditional employment arrangements, be they casual and or on a contractor basis, and how they are treated. Are you able to provide me, Ms Wang or other officials, on a summary of what the recommendations are for those two issues that have been raised about this scheme?
Lei Swan, Acting First Assistant Secretaries in the Employment Conditions Divisions. Yes, the KPMG report just being released, and it is a very long report. And the report itself and summarised the consultation process it's undertaken. It has spoken to the employers, the employees, and the Coal Long Service Leave Corporation itself. The report is focusing on, as required by the terms of reference, looking at how to improve the scheme to ensure the public accountabilities of the scheme and to serve the interest for the employers and employees in the scheme. So the report, in particular, in response to your questions on how the schemes, the coverage, the schemes currently traditionally cover the mining industries, and over the years, the mining industries has been modernised in a number of ways. For example, it starts having not just the mine owners and operating in the industries, it also have a modern industry employers and participate in that section, in those sectors. For example, you might have a traditional manufacturing business. They now are also doing work on the mine site. So in that, in response to that, in 2010, there was around 2010 and 2011, there are amendments to the Coal Long Service Leave legislations to expand that scope. But in the last 10 years, and as reported in the review report, there are uncertainties around the coverage, particularly around those in modern or non-traditional mining companies. So the report made a number of recommendations on how to improve the clarities of the coverage. That gives certainties to employees, but also enhance the compliance of the scheme. Also, in the second part of your questions about the casuals, yes, there are also concerns around either complexities or different recognitions of hours and earnings and eligible wages between permanent and the casual employees. So the review also made a recommendation to ensure permanent employees and the casual employees are equally treated.
Okay. So just looking at some of those recommendations here, it looks like there's a couple there that go to what you mentioned, recommendation one, which is about amending the definition of an eligible employee, and recommendation 4, which, as you've said there, recommended no less favourable treatment to casual employees. Has the government responded or the government response at this stage to those recommendations?
I believe the government response is also on the department's website and it's been released this morning.
Has the government accepted those recommendations?
Senator, maybe perhaps I could just stepping back,
I'm just getting
noting
that as well.
the review was released yesterday. There were 20 recommendations. Not all of the recommendations were directed at government, but 10 of the recommendations were directed at the government, and the government response supports all those recommendations. Okay. The remaining 10 recommendations are mainly addressed to the corporation itself.
Yep.
We set out in the government response that we will support the corporation in their implementation of those recommendations. There is some legislative action based on the direction for reform that's set out in the report that has been recommended around providing greater clarity on the definition of eligible employee, clarity and fairness to ensure casual employees are treated equitably with permanent employees, and to address some legacy issues around the scheme. It will take some time to work through those recommendations because the legislative provisions are complex, but we will work very closely with the agency in terms of going through the recommendations and working with them to fully implement.
So I'm just looking at the response here as well. I've just downloaded that. It looks like that the government has agreed to ensure casuals are treated the same as permanent employees. That is correct, isn't it?
That's correct.
Good. And also that the government has agreed to change or amend the definition of eligible employee to improve clarity. That's a summary, a broad sense of the recommendation and what the government intends to do?
That's correct.
Okay. And so you mentioned, obviously, it looks like these recommendations don't themselves outline exactly what the legislative amendments would be. So you're now going on a process to work those out. Is that what's happening?
That's correct. And, as the recommendation pointed out, the need or some areas for improvement for the schemes, given it is quite targeted review process, and also as secretaries mentioned, the legal amendment is always very complex. So we, as outlined in the government response, and we'll work with the stakeholders as well as the agencies to draw their deeper knowledge in the sectors to ensure those technical amendments deliver the policy intent.
Okay. And if I could just feed back into that process, that I think one of the issues is there's a lot more contracting occurring in the mining industry than when I think the scheme was set up in 1949 or something like that. So there's a lot of businesses now that might provide services to a mine but don't consider themselves a coal mining company, and they get a little bit confused when they receive angry letters suggesting they should be paying levies when they've had no idea of this scheme. So that would be great if this could be clarified. Finally, just my final question on this. I think the review, just to clarify, that the review does support the continuation of this scheme. Is that correct?
Yeah, that is correct. And the reviews and also I find the schemes operates very well in terms of the majority of the workers in the schemes, and definitely recommend the continuation of the scheme, and as a part of the terms of reference, and the terms of reference not requiring the reviewer to look at changing the schemes, and only asked the reviewer to look at ways to improve the scheme.
Okay. Thank you very much for that information, and congratulations on doing this work. It's very important. I will hand back to Senator Sheldon.
Good, thanks very much. So back to the appointment of the Chair of the Safe Work Australia. Minister, I'm just to assist you, but I'm just going to get a copy of the Broderick review just with a recommendation so that you may have them in front of you.
Yep.
I've only just asked for them, so it might take a few minutes, but if you can bear with me with this question, and I expect that document to be then asked to be tabled through the Chair. Minister, Ms Broderick's report into the culture of Rio Tinto found that bullying is systematic, sexual harassment and everyday sexism occurs at unacceptable rates, Racism is common across a number of areas. Employees do not believe the organisation is psychologically safe. Harmful behaviour occurs by and between employees, managers and leaders, including senior leaders. There are unique features of the workplace that create risk factors, including a hierarchical and male-dominated culture. A capability gap in leading and managing people exists across many levels of the organisation, particularly on the front line. People, policies and systems are not properly embedded or lived across the organisation. Harmful behaviour is often tolerated or normalised. Harmful behaviour by serial perpetrators is often an open secret. Employees believe that there is little accountability, particularly for senior leaders and so-called high performers, who are perceived to avoid significant consequences for harmful behaviour. Now, in light of that's the environment that Ms Farrell is responsible for the safety, health, safety and environment at Rio Tinto as a group executive, the most senior executive responsible for that area of concern. Does that raise her capacity to properly deal with culture within any organisation? And does that still, in light of the fact that that report's now been delivered, would you have still appointed Ms Farrell?
Let me be very clear. There was a consultation process that was gone through in relation to Ms Farrell. It's a statutory consultation process. Each state and territory is given the opportunity to provide input and raise concerns in relation to the process. No one raised any concerns, including the state of Western Australia, where, as you have already stated, a number of these articles were published. In relation to the response by Rio Tinto to the review, and I do note the comments that Ms Broderick made in relation to Rio Tinto actually commissioning the review, and what she said is Rio Tinto's actions in commissioning the report demonstrates a very clear commitment to increase transparency, accountability and action. I also note that Rio Tinto makes no excuses for the report. It outlines 26 detailed recommendations, which it says will inform work being carried out to improve how the company prevents and responds to discrimination and unacceptable workplace behaviour. It also says Rio Tinto will implement all recommendations from the report, and it has a focus on certain areas. So certainly Rio Tinto itself take this report very seriously. As Elizabeth Broderick has acknowledged, they commissioned the report, and in commissioning the report itself demonstrates a very clear commitment to increase transparency, accountability and action. It also says the high levels of confidence among employees that a significant impact can be made in the next 2 years are an encouraging sign that change can happen. She also says, in my interactions with the Rio Tinto leadership team, I have observed a strong desire for transformational change, as well as to make positive contributions to the societal shifts that we need to see. There is a clear recognition that new approaches are needed to solve these issues. So as I said, Ms Farrell has an exemplary resume. She has the ability to chair Safe Work Australia. It is a part-time position, as you know. The due diligence was conducted by the department. The consultation process, as per the Safe Work Australia Act, was conducted by the department. The states and territories were asked for their input. No concerns about the appointment were raised. And on that basis, I am satisfied that Ms Farrell can fulfil the duties and role of the chair. But I would also say, again, chair of this committee, that Ms Farrell should be given the opportunity to respond to the line of questioning that has been raised, given the Broderick report makes no findings in relation to her.
Minister, have you ever met Ms Farrell before appointing her to the position?
I have met her.
Had you discussed with her about the position prior to?
No, I had not, no.
Is the question sort of goes back to, in light of the report that you've just viewing now, I appreciate that you're saying you didn't look at this before, is frankly a little bit worrying that it hasn't been brought to your attention because of the seriousness of nature and involving one of the most senior executives in a very important role in workplace oversight. Can I just ask you just to clarify on your meetings with Ms Farrell? In what capacity have you met Ms Farrell and how many times?
I've only met her on a few occasions, but I would need to go back and clarify that for you, which I can do on notice.
So that might just ask more broadly then, because you're looking for the detail, which I appreciate. You've taken
I will
on
have
notice.
to take that on notice.
Was that in a social context or in a work context?
In Western Australia, it's a very small place and you do bump into people. But also, I believe, as the Skills and Employment Minister, to talk about skills and employment, I may have met with her, but I'd need to go and check that for you.
Thank you, Minister. Just want to go back to the question I asked, just so clarity. In light of the report, and I note you've said that the report
Came out after Ms Farrell was appointed.
That it was we've made the point that there was a number of allegations in the mining industry occurring for a considerable amount of time. In actual fact, there was some reports that were prepared by unions in the mining industry following surveys and interviews of individual workers, particularly women workers. Thank you. So we've got this environment. We've then got a report that's been delivered. It's gone to some very serious allegations, including 21 direct issues of rape. The question goes back to what I have been asking. In light of the most senior executive that was responsible for making sure those practices didn't occur is the person we've just now appointed to Safe Work Australia to chair it. So I appreciate the report was finally instigated after a great deal of public pressure on Rio Tinto, the change of change ultimately of senior executives in a number of roles. So this is the environment that we've got now. In light of all the evidence we have in front of us about the period that Ms Farrell was involved in at Rio Tinto, would you have reconsidered that appointment and I appreciate states have involvement, but it's primarily and obviously an appointment that also has responsibility back to the Commonwealth, which is part of our responsibilities here at Estimates.
Well, again, I believe that Ms Farrell is qualified for the role. I have already gone through her qualifications. We undertook the consultation process as we are required to under the Safe Work Australia Act 2008. The Safe Work Australia Act itself, as I've already read out to you, subsection 11.2 provides that the Minister can only appoint a chair if the State and Territory Work Health and Safety Ministers have been consulted on the appointment. As the Deputy Secretary has advised the committee, no concerns were raised. There were no findings in relation to Ms Farrell, Senator Sheldon. She is qualified for the role. But again, Chair, I would appreciate if Ms Farrell could be given the right of reply in relation to what is being raised about her character.
Can I just write if I can table the report, Chair? I've really only got a question or so.
Okay, everybody happy for it to be tabled? Yeah. Tabled.
I'll probably need that copy. Yeah. Thank you. So, Minister, you have a copy of the report. There are some quotes in section 4.8.3 titled "In Their Own Words," which raises questions about Ms Farrell and her team, including a quote, "I'm in HR and I don't think I'd report there would be recriminations." Now, somebody in Ms Farrell's own team is saying that she wouldn't even report to her own HR department because of fear of recriminations. Is that an accurate description of what I've just said to you?
Oh, I don't have the report in front of me, Senator Farrell. But in any event, the government takes these. I mean, our response to the Respect at Work report, I think, shows, and we've already gone through that this morning, that these issues are taken very seriously. When I look at Rio Tinto's response to this, they take it very, very seriously. Again, in relation to the appointment of Ms Farrell as Chair of Safe Work Australia, she is eminently qualified for the role. She has over 30 years, I think it's going on 40 years, experience. Again,
Excuse me, Miss, I don't mean to break you in mid-stride, but the report's now just to your right-hand side.
Well, again, this was handed down
4.8.3.
after Ms Farrell was appointed. She was appointed in December of last year, Chair. Again, my evidence is not going to change, Senator Sheldon.
I'm not asking you to
process
change your
was
evidence.
gone
I'm
through.
asking you to consider 4.83 and supplementing the previous questions I've asked. And I'm aware of the evidence you've given so far. You have repeated that position on a number of occasions, and I respect that you've done that. But on section 4.8.3, titled In Their Own Words, which raises questions about Ms Farrell and her team, including, I'm in HR, I don't think I'd report that there would be recriminations. The quote is on page 71, 71, if that assists. Can I just then put to you again, in light of what's in that report on the right-hand side of you, and that what I've just read out, would you have appointed Ms Farrell?
Well, again,
And I'm saying
Chair,
I'm saying
report
that now.
was released
I'm saying right
after
now.
the appointment
I'm not saying before the
of
appointment. I'm saying
Ms
right now,
Farrell.
in light of this evidence, this information was available to you. Would you have appointed Ms Farrell?
Again, the appointment process was undertaken, Chair. I am satisfied that Ms Farrell is qualified to undertake the role. The states and territories were consulted as they need to be as part of the appointment process. No issues were raised in the process by the department, and on that basis, Senator Sheldon, my evidence does not change other than I believe Ms Farrell should be given the right of reply to the committee.
Senator Sheldon, can I just... You're perfectly entitled to ask these questions, although I would indicate some of them are getting repetitive in nature, and the Minister has answered a number in the same fashion. So I would just ask you to continue to move on through your questions and not simply repeat questions that have already been answered.
Yeah, thanks, Chair. My intention was just to try to get an answer about which of the
I
ministers...
believe
Now,
I'll
the
provide
Minister-
an answer, Chair.
Can just let me... There's a point being made by the Chair. I'm just about to agree with the Chair, actually, that to some aspects of what he said, and that is that my intention is not to actually repeat the questions, it's just to get a clear answer about the questions I was asking, but I have concluded my questions.
Okay. So, Senator Pratt.
Thank you. I'm now going to ask some questions, please, about casual conversion and casual employment. Can you advise the committee of the latest workforce figures you have on casual employment, the number, percentage of employees, percentage of the workforce?
Just hold on, we're
by
just bringing
gender
the-
and by age.
Yep.
Thank you.
Just
Do you know,
Yes, sorry,
thank
I
you.
missed
So I was
your
looking for the
question.
data in relation to casual employment, the number of people, percentage of employees, percentage of workforce, and by gender and by age.
I'm really...
So I might start.
I'll let them, and then we need to change the
Sarah.
personnel, and I get another official to answer that question.
Sorry, I might start with the answers, Senator. So the latest data shows there's approximately 2.5 million casual employees in November 21. I'll need to check whether there's updated data of this, but the November 21 figures is 2.5 million. That's approximately 101,000 below the pre-COVID level of 2.6 million in February 2020. In contrast, the number of permanent employees has increased by 233,000 or 2.8% over the same period. So what we've seen is employment growth.
Yeah, my question was the number which you've given me, thank you, and it's fine that you reflected on the change. What's the percentage of that 2.5 million of the overall workforce?
So of the overall workforce, it's 20.6%, I think. No, sorry, 22.9%
Okay, and
of
is that-
employees. So
Okay.
that's
And has that percentage of the workforce gone up or down?
that's down significantly.
Okay. Percentage by gender
Might pass to Ms Wettinger for that detail.
of that 22%? So of the 2.5 million, what percent of them are women and what percent are men?
Senator, it's Jennifer Wenninger, Assistant Secretary of the Economics and International Labour Branch. So the latest statistics from the Australian Bureau of Statistics in November 2021 show that the number of casual employees that were male is 21.2%, and the number of casual employees that are female is 24.6%.
Sorry, I don't quite get that. Surely the percentage by gender, that's to get to the 22% in the middle, that I
Yeah.
get? All right. Can you give it, can you give me the percentage by age or gender so that it equals 100% of the casual workforce overall?
Yes, Senator, and apologies for misunderstanding
that's
your
fine.
question. So I can clarify that 53.6% are in fact females and 46.4% are males.
Okay, thank you. Have you seen the studies, Minister, undertaken by David Peats with regards to casual employment?
I don't believe I have. Have you got the study with you?
Well, I can get it for you very quickly. I can ask that
Well,
it be...
perhaps give us the flavour of the questions you
Yeah,
would like
no,
to
that's
ask.
fine. I will just ask my office over the airwaves to post that in our estimates channel, and I think, well, that's probably the quickest way to get it to you. Anyway, this research shows that up to 50% of casual employees don't receive a casual loading. What's your understanding of the number of casual employees that aren't receiving their loading?
Well, I can get Ms Wettinger to take you through the actual statistics.
Thank you, Senator. I might just take some advice on that. Certainly in terms of casual loading, of course, it is a requirement that they do receive the 25% casual loading. So just one moment while I take some advice.
Okay, so can I ask, Minister, yes, we all know it's a requirement. What does it mean, though, when there's research that shows 50% of employees aren't receiving that casual loading? Does that mean 50% of employees aren't receiving their legal entitlements, and doesn't that concern you?
Well, in the first instance, you are merely putting a statement to us. If you're putting a generic statement to us, I can get Mr Hare to respond to what the legal position is in relation to employee entitlements.
So I'm not sure if I've got the detail of the research in front of me and the methodology for it.
You don't.
No,
set up.
we
So,
don't, but...
So we'll take it as a
Department's got its
general
own
question,
data.
Chair,
Yeah.
in relation to employee entitlements.
Yeah.
Thank
So clearly, if someone is being engaged as a casual, then they should be receiving a casual loading. There are times when that loading is, to paraphrase, rolled into a wage rate where sometimes the employees may not be aware it's paid as a loading. So there is a question there about whether they would always be aware. It is always payable, is my understanding, and certainly if people aren't receiving their full legal entitlement, they should contact the Fair Work Ombudsman to support them to address that issue. So with the question
So
mark
would you
around the
want-
methodology,
If David Peats is right, he's an academic at
Chair, with
Griffith
all due respect,
University.
what would normally happen in committees is you would
I do
actually
understand. I'll get you the
provide the
report. I'll get you the report.
It's
Yes, okay.
We're actually,
Well-
if you're happy to ask random questions about hypothetical situations.
My questions are not random, they're based on academic research.
Well,
Thank
look, I think
you.
I think it's entirely appropriate for the witnesses to say that if they have not got a particular report or information in front of them, that they are unable to provide an answer. That is free for them to make that response, not for me, but I'll hand back to Senator
Pratt.
Pratt.
The data is on casual employment. How many people are not receiving their loading?
Senator, I think we've answered questions of this type before in that there's no clear methodology for identifying how many people aren't receiving their payment and whether that includes their loading or not. So what we tend to rely on is who's coming forward and encouraging people to come forward if they're not receiving their legal entitlements to the Fair Work Ombudsman, whose role it is to make sure that people do get their legal entitlements. So the methodology, and there are a range of methodologies out there. We've seen people try to extrapolate the Fair Work Ombudsman's figures. I think the Fair Work Ombudsman herself has said that's probably not incredibly reliable because of the way they tackle their approach, which is both targeted and information-led or data-led. So they believe that probably it would probably represent an over-representation, but it's also possible it could be an under-representation if people aren't coming forward. So there is no clear methodology available to actually identify the level of underpayment.
Okay, so it's nevertheless, you have to pay that loading.
Yes, you do.
So how come the government can't work it out then?
Senator, can I just also add in, if you recall, the government's legislation last year and defined a casual employment as a part of a definition is that people, if they define as casual, they will be entitled to a casual loadings or specific rate of pay for casual employees under the terms of the offer on a Fair Work instrument. So that is now in the Fair Work Act. So that will be, but I understand
Okay, so what proportion of people under the Fair Work Act who are entitled to that loading are not getting it? Why can't the government tell me?
So, Senator, to do that, we would need access to everyone's rate, their individual industrial instrument, the hours that they work, the timeframes in which they work those hours. We don't have access to that information.
In other words, you would need access to an academic report like Dr. Peace, who's done that research through consulting workers, and that's what his evidence shows.
Again, Chair,
Anyway,
general statements made here that have been put to us as gospel. We'll take that as a statement, Senator Pratt.
I'd also...
Can I ask if you're able to advise on how many casual workers have received permanent positions since the casual conversion provisions took effect?
Senator, so I think we've talked about this previously. So again, there's no requirement for a notification to government about someone converting from casual to ongoing employment. We've talked about the importance of the data collection around this and the additional funding that's been provided to the ABS to enable us to work on to collect survey data in a way that's robust, and that work is commencing. In terms of the work around the design of the collection. So that will happen in terms of we'll have some survey data that enables it to do it. But at this point in time, there is no requirement for anybody to report to government that someone's been converted from casual employment to ongoing employment. And, you know, I'm certainly not claiming causality. The only thing we know is that we've got less casuals as a proportion of the workforce than prior to COVID starting. So we've had no real growth in employment,
and we've had an actual reduction in casual employees, acknowledging that there is no causality identified within that statement.
Okay. Have you got numbers by industry, employee, age group or gender
For
what?
for permanent positions?
I'd need to take that on notice. I'm not sure how the ABS break down that data, so I'd need to take that on notice.
Yeah, I think ABS has those data from the labour force in terms of the permanent employees and by industry and the gender. It depends on how deep, how disaggregated you want to be, but the broad industries level data would be available.
Okay.
But we can take it on notice, give you the details.
Senator
So
Pratt, just
you don't-
reminding we've got 5 minutes till morning tea. Happy to give you that time, but it'd be good to stick to time.
Okay. So you don't have specific data. How are you tracking that conversion capacity if you don't have the figures, whether the provisions are working?
So, Senator, my recollection is that there's a review requirement within the legislation in terms of the impact of the SAGE bill. We'll certainly commence that, and I think that can't commence until after late March, so it's not earlier then.
Okay, so you're not
we'll seek to commence that relatively quickly post that, but the methodology is still being designed.
Okay. I'll give the call to Senator Sheldon to take us through to the morning tea then. He's got more questions.
Good, thanks very much. That's Chair. That's okay.
That's fine, Senator Sheldon.
The Select Committee on Job Security has collated some data on casual conversion offers across from more than 30,000 casuals at CBA, ANZ Bank, PwC, Spotless, TAFE New South Wales and the Universities of Sydney, Melbourne and Newcastle. Less than 3% were offered conversions. Are you surprised, Minister, how low that is? Or is this toothless conversion laws exactly what was intended?
I'll get Mr Hare to take you through what the actual conversion laws are, because there is no... Employees are not forced to convert if they don't want you. This was about giving them the opportunity.
Sorry, Minister, I better clarify. I was saying that these are conversions that were offered. This is not conversions that were accepted. So out of 30,000 casuals at CBA, ANZ, PwC, Spotless, TAFE New South Wales, Universities of Sydney, Melbourne and Newcastle, and the evidence they gave before the Senate Select Committee on Job Security, that they said they offered less than 3% of conversions when we total that up of almost 30,000 casuals.
But doesn't that... Sorry.
Senator, so without having the detailed information behind the characteristics of the casuals, and I'm not sure whether you've just taken the complete casual figure, including people who hadn't actually quite reached the 12-month period, whether they had the 6 months of work in a pattern that actually enabled the conversion to the conversion offer to be made. So there's a range of factors that I'd need to know before I could comment on whether a 3% figure was high or not. So if there was a large proportion who hadn't hit the 12-month mark, then
Comment on whether
not necessarily.
3% is high or not.
Senator, because it all depends on what the denominator is.
That Mr Hare is taking you that need to be taken into consideration.
So if the 30,000 figure is all casuals in those businesses, then you actually then have to start applying the criteria to actually understand what the true denominator is, if you like, for that. So without having access to that, I honestly couldn't comment. So my recollection of the broad figures is that a reasonable number of casuals, a reasonable percentage of casuals move on before they hit the 12-month mark. So the number of people who've been employed for more than 12 months as a casual, and I'll check this figure, but in my memory, it was in the order of 1.1, 1.2 million against the sort of 2.6 million. So it's entirely likely that at least half, subject to not knowing what criteria had all been applied to that 30,000, may not be there. So it's just difficult to make a call unless I know what the denominator is.
Mr. Hare, I appreciate what you're saying about having to go through the substance of those. I'm just asking you to take at face value both the chair and the deputy chair that are on that committee were there, that are at this hearing now, at this estimates committee meeting now. It was 30,000 people, only 3%. I appreciate you've just told me that's the way the legislation was to operate, that we end up with less than 3% of 30,000, and that's the point I'm making. It is disturbing to have it so low.
Can I just clarify, Senator Sheldon? Are you just clarifying the evidence, because I was on that committee too? You're saying that 3% accepted an offer?
No, 3% were offered.
That's not my recollection.
No,
anyway,
the minister kept saying they accepted, and I kept saying no, there was 3% that were offered.
Okay.
There was only 3% offered conversion, and in a number of instances, no casuals at all, even though they'd been there for 10, 20 years, were not offered conversion
And
at
this
all.
is where Mr.
So my
Hare,
point
sorry.
for Mr. Hare, which is rightly outlined as a legislation, is operating efficiently, and well, I'm using my words, effectively. He has to research the data I just gave him. I appreciate that. But respectfully, on the basis that there's 30,000 people that were casuals and only 3,000 were offered conversion.
So, Senator, the legislation, particularly for the employers who are required to make the offer, did set out a range of factors that could mitigate against the need to make an offer, but the requirement to provide advice on that. And it also outlined dispute processes, which I might get Ms. Wang to talk you through. In terms of there is meant to be a process. Well, so there is a process that allows people who believe they should have received an offer to have that reviewed. So I'll ask Ms. Wang to walk you through that.
Yes, Senator, we do monitor the evidence provided to the job security hearings and closely. So if I may just clarify what the legislation required the employer to do following the amendment. There is a transitional arrangement that all the employers need to advise every single casuals in their business, including those may not eligible for the casual conversions, and before the 27th of September, advising them whether they are meeting the eligible criteria or not. If they are meeting the eligible criteria, then whether they're making the offer.
Chair, I appreciate the evidence you're giving, and I appreciate the accuracy of your description of the legislation. It's not really the question, not really goes to the heart of the question I'm asking.
So I was just trying to answer the question.
Did actually, Senator Sheldon?
There was a question around the legislation.
Around the legislation, around that proportion, because just to try to give a bit context of who would receive advice from their employers under the legislation. So by looking at the figures and come through the inquiries, we don't have access to of course the individual business informations, so we don't know what's their workforce composition in terms of how many employees, casuals are not meeting the legislation conversion eligibilities. For example, whether they be there under 12 months or they haven't had 6 months in the regular work of patterns. And answering the second part of the questions, if people have been there for very long and they believe they actually are meeting the eligible requirements, eligible criteria, and if they receive a letter from the employers and advising them they are not eligible for the conversion, and there are dispute resolutions and process available. So the standard process is the same as other national employment standards. So they go through the internal mediation, conciliation, or go to the Fair Work Commissions. And also, I think I answered this question before. A number of organisations mentioned, particularly, I think I checked every single tertiary institutions enterprise agreement. They all have arbitrations available to the Fair Work Commissions. So all those employees, if they dispute the eligibilities assessment received from their employers, if the dispute not resolved through mediation and conciliations, and the Fair Work Commission will be able to provide the arbitrating decisions.
Can I just add?
The New South Wales Teachers Federation, the Australian Education...
Senator Sheldon, just before you ask another question, we are 5 minutes over
yeah,
time.
yep.
We can come back to it.
I'll come back to it briefly afterwards.
I think
Maybe a follow-up.
Senator Small did indicate to me he wanted a quick follow-up. If it's quick, Senator Small, because we do need to break.
Yeah, super quick, Chair, and then I do have some more to dive into this casual conversion stuff more broadly. But I think Senator Sheldon has grossly misrepresented the proceedings of the Job Security Committee there. So, Ms Wang, can I ask very briefly, if, as you said, you followed the proceedings of the committee, you recall hearing from a wide variety of employers that less than 10% of casual conversion offers were actually accepted by those employees in their respective companies? And if so, what inference does the government draw about that low acceptance rate underpinning, I guess, the strong support for casual employment as a way for Australians to fit work around life rather than be forced to fit their life around work?
With that, so before I pass to Ms Wang, so and I was going to add this to the previous answer to Senator Sheldon. That's why there was a requirement within the Act that we undertake a review. That review, as I said earlier, can't commence before late March, but our intention is that we would commence it as soon as possible. And clearly we're looking at a range of issues that will need to be reviewed. What I would say is, in terms of trying to understand how compliant employers are with their obligations to offer and whether those offers have been made properly, is absolutely going to have to be part of what we have a look at. In terms of the acceptance rate, I'm not sure we had a figure that we were anticipating in terms of the acceptance rate. We were aware of anecdote that actually a large number of casuals were happy to be casual, and that was their preferred mode. But again, that's something that we will absolutely have to have a look at in terms of the review. In addition to that, it's also part of the work that we're working with ABS on in terms of trying to understand why people do casual work and why they do or don't accept an offer there. So again, there's been funding provided so we can actually look at these questions using the robust methodology from the ABS. We believe these are critical questions and we will absolutely consider them.
As Mr. Hare said, we only have very limited anecdotal evidence about the acceptance of the conversion, but we are aware of a report in the Australians which reported late November last year, and there is a software companies have 4,000 business clients, and according to the report, the software companies and so the employers in using that software company payroll softwares and offer their employees conversion, it's around 12% of the employees received offer and accepted offer. Just as the ministers outlined, there was an important feature in the legislation is the casuals, if they are eligible, they will not be forced to convert, and they employers need a reasonable justifications not to make an offer, but employee can just based on their choice and either accept an offer or remain as a casual.
Thanks very much, Ms. Wang.
Thank you, Senator Small. We will now break. We'll reconvene at 11. Oh, sorry, one more thing before we break. We have a paper from David Peets tabled or proposed to be tabled by Senator Pratt. Just checking with the committee that's okay. So tabled. We will now break and we'll reconvene at 11:25. Okay, we will reconvene with the Attorney General's Department, and I'm going to give the call to Senator Roberts.
Thank you, Chair, and thank you all for attending today. Nice to see you again, Mr. Hare. It's always a pleasure, and I mean that sincerely. Minister, I'll just read 11 points from my additional comments to the Job Insecurity Inquiry report. These are the things that we see in addition to exploitation of casual coal miners, which we're going to have a further discussion about tomorrow.
Yes, you and I, yes, we are.
Yes, and which we've been trying to make progress for a couple of years now. In addition to the exploitation of casual coal miners, Australians are suffering right now from what I consider to be COVID mismanagement, both federal and state, due to capricious lockdowns and mandates. People are uncertain. The second thing is the phasing out of the coal industry and jobs under the policies of all four major parties. The erosion of people's rights and freedoms, especially workplace rights and freedoms in this context. Increasing energy prices, which are decimating manufacturing and hurting agriculture. The killing of manufacturing as a consequence. The lack of much-needed tax reform. The lack of much-needed economic reform. Increasing debt. Workplace health and safety systems being bypassed. Australia's productive capacity being destroyed, and this is the one I want to ask questions about, the failure of our industrial relations systems and more. There's a lot that's hanging over people's heads, workers' heads.
Yep.
And small business in particular.
Okay.
Would you agree? And I think the solution in many cases is to come back to the basics of employer-employee relationship, the fundamental workplace relationship. So with regard to the coal miners, in Queensland and especially the Hunter Valley, we've seen workplace safety and health jeopardised, bypassed, people threatened with firing, being fired if they raise safety issues. I made a submission to the Grosvenor Mine Inquiry. The issue of Simon Turner, no workers' compensation, no accident pay for injury, sacked while being injured, injuries and incidents not being reported, pay rates for casuals being 40% less than people on permanent employed by the mine owner, right next to them doing the same job and the same roster. Coal LSL, which I commend you for the report that's come down today.
Thank you, and I think they're coming later on.
Yeah, we'll be there.
No, that's what I thought. Yeah, you'll be asking the questions, yes.
As we have been in every session for the last 2 years. The loss of coal miners' basic leave and other entitlements, and the threats of dismissal. So these remain outstanding and still to be addressed, and we'll be talking more about that tomorrow.
Yes.
What I see, Minister, I'll let you finish.
No, I'm just having a look at something that you'd written just to make sure I'm all over it. Yep.
What my question is basically, the exploitation of casuals is, I believe, a symptom of a highly complex, needlessly complex industrial relations system that is not serving workers, not serving small business, and not serving some employees. And families and workers are getting jammed in the middle. We see large companies, multinationals in particular, using casuals to bypass industrial relations systems instead of sitting down and negotiating with their workers and with the union. We just see a bypassing through casuals. So what I'm asking you is there any understanding in your department that the exploitation of casuals is a signal or a symptom of the fractures in the industrial relations system?
Okay, there was a lot of commentary
Yes.
there, but what I might do is hand over to Mr Hare, who obviously has looked at the job security report, and get him to take that question.
Thank you, Senator, for the question. In terms of the casuals, it's probably just worthwhile clarifying. So where casuals are employed by the company themselves, they are still subject to the same industrial instruments that the company has either negotiated or the Fair Work Commission has made. So in terms of where the company itself is the employer,
there is the negotiation and discussion process that you talked around the company having with its employees, where there's an EA, should have occurred. So certainly there should be clear processes within any enterprise agreement around how the various employees will be treated and what they're entitled to. I think in part you're referring to the combination of casuals and labour hire.
I am. Yeah, thank you for picking that up.
So that does make for a more complex situation. Recognising that labour hire would regard as less than 2% of the workforce traditionally, but it is an important mechanism that is used by both host employers for short-term work when they need it and when they're as part of their when the need arises. So recognising it's an important and valuable part of the economy, it does get. I think it's clear that when it leads to different rates of pay, it does cause some level of confusion. In terms of...
and beyond that, it causes some kind of angst as well, and it's not very helpful for safety.
I accept that, and I know that there's been a number of comments within the report itself around that broad issue. It's certainly something that the department will look at very carefully. It has been raised both within the main body of the report as well as within your comments in terms of how does that work. The reality is the Fair Work Act and the framework upon which it sits was designed around an employer being the legal entity that actually employs the person rather than necessarily the location where they work. So that's the nature. And the Fair Work Act is clear that we have minimum rates of pay, but what we actually want to see is higher rates of pay than the minimum being negotiated by employers and employees. So that's, I think, one of the very clear principles within the bargaining provisions within the Fair Work Act, that we actually want to do that. The only mechanism that, and the mechanism is focused on the individual businesses. And in this case, where you've got two businesses working, or the employees of two businesses working in the one location, I agree that can cause angst and confusion, but it's certainly something that we need to have a look at in response to the work, and that's something that we'll provide advice to the government on once we've had the opportunity to finalise our analysis of the report. But having said that, the very important focus within the Fair Work Act is that we do want people to bargain. We do want businesses and employees to get together and to think about how they can increase productivity and then share that productivity in the form of increased profits and increased wages. So, and the clearest mechanism to do that, we feel at this point, is on an individual business basis.
Thank you. You gave us a comprehensive understanding of, and I know you've got that, of the casual work situation and the abuse of that. And I'm certainly validating that some casuals want casual work. And I'm not just talking about the coal industry here, but even in the coal industry, some casuals do want casual work. They prefer to have that option. But there has been some abuse of that. And I believe that the complexities of the industrial relations system in this country right now make it such that some employers, rather than facing up to negotiation, they will bypass that and set up a labour hire, establish a labour hire relationship. Some labour hire companies are good employers, some are not. And some rely upon basically cutting wages so that they can make a profit by getting the margin and still leaving the business owner with superior profits. So that's definitely a strategy that we can see. So my question that I don't feel was answered was that do you consider that the complexities, and the Act is what, this high, 600 odd pages, the complexities of that Act lead to workers, small businesses in particular, and even some big businesses not having clear understanding of the employer-employee relationship. And so we dive into all kinds of other arrangements.
Senator, the Fair Work Act is a substantial piece of legislation. It does have a number of parts. So, but we've certainly heard commentary in the past that it's complex and difficult. And we acknowledge that commentary. At the same time, and we do understand the importance of this as well, there are important safety, worker safety, protections in terms of the bargaining process and other things, in terms of making sure that the bargaining is done fairly. And certainly there is some concern that those procedures inhibit the bargaining, but they're also really important in terms of the principle of making sure that the bargain is fair. So getting that balance right is something that we continue to think about. As a department, we honestly are really engaged in the discussion around productivity growth. We think it's a significant issue for Australia and other large parts of the Western world. That productivity growth is low, and we would certainly encourage parties to bargain. But the reality is that the Act is based on both providing the opportunity to bargain, but also making sure that those bargains are fair. And I think that's sometimes where we see the complaints about complexity. Always happy to have a look and see how can we attain that fairness in a more simplified fashion. And that's where we...
I think, and Senator Roberts, I mean, you often come with the Fair Work Act and the various iterations of it in terms of just to demonstrate how big it is and how much both employers and employees have to navigate, because it's both parties understanding their rights and obligations. And certainly, without a doubt, it is a complex act. And it was one of the reasons, though, when you and I discussed this, was last year now, I think, just in relation to the reforms to casual employment, providing a definition to provide clarity as to what a casual is, offering the ability to convert to permanent work, clarifying the Rosato decision, the devastating $39 billion impact on the double dipping and what that would have done to business. So I do agree with you, and we certainly have been able to make some headway in relation to parts of it. Obviously, the other parts of the Omnibus Bill didn't get the support. But they are, I think, some concrete examples of where you can actually put in place, so for example, an actual definition, give the ability to convert, clean up a court decision, and actually give certainty to employers. But I certainly acknowledge that this is something that you raise time and time again.
Yeah, and the fundamental...
Roberts, can I just check how long we have to go? I usually like to rotate the call every 15 minutes.
Another 2 minutes?
That's absolutely fine.
What I'm getting at, Minister, is that the fundamental problem is that despite the intentions of everyone involved, the Fair Work Act, the previous work choices attempt, their mired in complexity, lack of understanding of the fundamentals. And what's happening with the Fair Work Act is that the workers and some small businesses and even some large employers are sidelined in favour of the Industrial Relations Club. Lawyers, consultants, HR practitioners, large union bosses, large industry groups, and the worker is sidelined. And so do you see any need then for restoring the primacy of the workplace relationship, the employer-employee relationship, making sure that and I know that the Fair Work Act, Mr Hare, does have protections in it, but when it's so complex, the protections get lost. And so making it clear on workers' rights, entitlements, protections, safety, which I know assists productivity. So instead of these things being bypassed, they're actually entrenched. And allowing for flexibility, because more and more workers today see alternative structures of work and work times in particular. whether it be uni students or small businesses or casual coal miners. They want that.
And I think you make an important point in terms of the ability for, in particular, employees to choose the type of work that they want to undertake, and that is why you'll never find the coalition government in any way demonising casual employment, as so often happens, and in particular in this committee. It is a valid form of work that so many choose, and when we can take you through the statistics in relation to casual employment, but also that landmark reform that we did pass in terms of that ability to actually convert, should you wish, subject to certain conditions. Again, it's about giving both the employer and the worker, the employee, the choice to do that. Just in terms of, though, people actually understanding their rights, very important, obligations, very important under the Fair Work Act. I think a lot of the work that the Fair Work Ombudsman does, and in particular that investment in its educative role, is so important, working with small businesses, because it's often the small businesses that don't have that capacity to understand the Fair Work Act. And I know, and they'll be on later on today, if you want to come back and ask them questions in terms of what is the educative role of the Fair Work Ombudsman.
We asked that at the last estimates.
We can get an update then at this estimates. But you know, it's a really good point, because it's not just about the Fair Work Act itself, as you've acknowledged. There are other ways and means, and one of them is ensuring that the Fair Work Ombudsman is able to get out there, talk to employees, talk to employers, and actually educate them on what their rights and responsibilities are.
I know that I've had a very positive response and in fact, agreement that, that David Noonan from the CFMEU, Michael Ravbar from the Queensland, from the CFMEU and from Queensland, from the Business Council of Australia, from small business associations, that they'd be willing to sit down in a process to explore a much simpler and better and more effective industrial relations framework. So I know an election is coming, so I'm not expecting you to make any commitment, and this is a touchy area, but is there any appetite for that if it's done properly?
Oh, well, I think when you look at the work that the coalition government has done, you look at the omnibus bill that we brought forward, I mean, that was certainly done in a period of over 12 months, I believe, in terms of the consultations amongst different stakeholders. Unfortunately, when we brought it to the floor of the Parliament, it wasn't supported by the Australian Labor Party. But I think our appetite for making things simpler, and in particular, as I said, the coalition reforms to casual employment, and in particular cleaning up the issue of double dipping and the potential devastating impact of the $39 billion impost on business, I think does show a genuine commitment to working with all stakeholders to improve the system.
With due respect, I just want to finish with this point. I think that casuals conversion was needed and essential. It's a shame it was bogged down in so much misrepresentations by a lot of people, but quite frankly, I think that was tinkering and not reform. It was reform of casuals, but not reform of industrial relations.
Understood.
Thank you, Chair.
Ms.
Can I just do one thing? Is it as the Minister indicated, the casual amendments, the bill, that does introduce the national employment standards, casual conversion and national employment standards, and does simplify the systems. Prior to that introduction into the NAS, you got different conversions in the awards, in the enterprise agreement, in the particularly black coal mining industries. There are confusion about whether the peoples are eligible for conversion or not. There are peoples and may not have a conversion. There was a gap. So by introducing it into the Fair Work Act as a national employment standards, that provides a universal right to all the employees and in certain ways also simplify the system.
And I accept that and appreciate what you said, Ms Yang. The fact that the Black Coal Mine Award excluded casuals, yet there were still casuals under various types of enterprise agreements, which were not, I don't believe they complied with the law, indicates that the industrial relations system is a mess. But that's why we supported the introduction of casual conversion, because it does clarify things for people.
Yes.
But there's a long, long way to go to fix this mess.
Yes, and the casual conversion does now apply to the peoples covered by the Black Coal Mining Award.
Thank you, Chair.
Thank you, Senator Roberts. I believe Senator Sheldon would like to call.
Good, thank you very much. again, back to this question of casual conversion. The situation with regards to we've said before, there's 30,000 casuals at CBA, ANZ, PwC, Spotless, TAFE New South Wales, and the University of Sydney, Melbourne and Newcastle, where less than 3% were offered conversions. At the last estimates, we referred to multiple examples of employers sending out thousands of template letters to casual employees saying they wouldn't be offering casual employment. For example, New South Wales, TAFE and universities. So there was a blanket we're rejecting. Now, I appreciate there are some technical aspects that are proven to be inefficient because people aren't taking up those opportunities. And I also just take you to evidence that was given, leads to my question, from Dr. Julie Wells at the University of Melbourne Executive, where she said in evidence before the Select Committee inquiry into job security that we don't think either are very, in reference to job security conversion clauses, we don't think either are very effective mechanisms to rely on if we're serious about reducing reliance on casualisation. Now, this is something consistently been stated by concerns raised by the opposition, concerns raised by workers during the inquiry, concerns raised by employers now, saying the casual conversion clause is not working. And the stats tell us 30,000 people and only 3% were offered conversions. So, you know, is the system working to plan? Because it sounds like it is working to plan, but the plan isn't to convert people.
So, Senator, the casual conversion process that is now within the Fair Work Act is clearly designed to enable people a clear pathway to conversion. Again, I draw out the issue of there was a requirement that all casuals get notified. I think it was the 27th of September last year in terms of whether they were going to be eligible to receive an offer or not. So some possible examples of where that might be. So if they hadn't hit the 12-month mark, they would have received a letter saying you are not eligible. If they didn't have a regular pattern of work that had persisted for 6 months, they would have received a letter saying you're not casual. So I don't think we can draw a conclusion at this point in time. But again, I go to the fact that there is a review that's built into the legislation that can't commence before late March, but which we are planning to commence very shortly after that, where we will have a look at these. And clearly the purpose of the legislation is to find a clear pathway. As part of that, we will absolutely have a look at what is happening in different workplaces. We'll have a look at understanding whether whether we're able to identify whether employers are complying with their obligations as part of that process. But again, we are still working on the design of that, but they're clearly key questions that need to be addressed in terms of the review. I will make a comment on the universities, and part of that will depend on what their processes are. So if they've got a large group of people who are employed very short term, they would have been told they were ineligible if they hadn't been there for 12 months. So I don't know all the arrangements.
You have given that evidence already this morning, but thank you for that. I just want to just put to you directly, 7,000, and this is to the Minister. If there's only a conversion of if there's only a 3% conversion of 30,000, and we have TAFE New South Wales, which has over 7,000 letters sent out saying that they're not offering conversion from casual to permanent. Does the system sound like it's working to you?
Well, again, Chair, I'll refer to the previous evidence given by Mr Hare, where he actually took you through, Senator Sheldon, what the process actually is, and there are a number of qualifiers to the process that have to be gone through. The measure of success is not necessarily the rate of the conversion itself.
That's my point.
Because the point is...
Sorry, Minister, that is my point.
No, because the employee is offered the choice. Choice is a good thing. Should the employee wish to take it up, that is their choice. That is a good thing. But as Mr Hare has said, there are a number of different things that need to be factored into what you have said. And in that regard, I can't add anything to the evidence that he has given.
So my point is that over 7,000 people in the TAFE system have not been given the choice because the casual conversion clause is not giving them a choice. That's my point.
And again,
only
I'll get
3% of
Chair,
30,000 were given the choice.
Chair, I will get Mr Hare again.
I don't
to
need
walk.
to hear the
No,
evidence again,
but you have unfortunately then verbaled the evidence that was given. There is an employee has to be an eligible employee. If the employer is not following the requirements of the Fair Work Act, then that is a contravention. You are putting to us that there may be an issue in terms of who is being offered or who is not. And I think we actually discussed this at the last estimates. This is an enforcement issue. If you are saying that there is an issue, we are more than happy to take that up for you, Senator Sheldon.
Minister, my point goes to the heart of which you're aware of, and that's the eligibility issue where the casual conversion clause is failing. The University of Melbourne has said that. The statistics tell us that, where only 3% of 30,000 people are offered conversion. And we've seen thousands upon thousands upon thousands of the same letters being sent out to people in the TAFE system saying that they do not have a right because the eligibility clause that you've put into the Act is failing. So 7,700 people were not offered conversion in writing. The system
Senator
is
Sheldon,
failing.
do you not see the irony in these questions when you fought tooth and nail for 2 hours on the floor of the Senate to ensure that this legislation did not pass? You, as the Australian Labor Party, as a member of it, don't even want the right for these people to convert. I suggest you look at the vote on the floor of the Senate. But, Chair, Mr Hare has some information to pass on to Senator Sheldon.
Well, just as we're considering Mr Hare's evidence, you said it's going to be the same evidence he's already given. I don't know whether I really need to hear it. If it's new evidence, I'm happy to hear it.
That's unfair.
If it's
to
the
Mr.
same
Hare.
evidence,
But that's
I'm happy to
unfair
hear it. But I also
Hare.
just want to take point with the fact that the government has turned around and implemented a piece of legislation for casual conversion which is not working. The eligibility criteria they put in that is a fail.
So,
when
Senator,
only 3% of 30,000 can convert, that is a fail. When 7,000 plus letters get sent out to TAFE, New South Wales casuals to say you can't convert, that is a fail.
So, Senator, if I may address the question.
No, it's not, Senator Sheldon, and Mr Hare will now take you through why it's not.
Senator Pratt, you do not have. Pratt, you do not have the call, and Mr Hare is trying to answer.
The legislation was, in our view, an improvement over what was actually in the vast majority of awards. Correct. So most of the awards required both 12 months of service plus 12 months of a regular pattern of work. The Act improved on that by saying, yes, you still had to have the 12 months, but you only need to have a 6-month regular pattern of work. So clearly easier to attain within that 12-month period, a 6-month pattern of work than it is the full 12-month pattern of work which the awards had in them. So certainly this is an improvement over what was in the vast majority of awards. So I think that's important. It's also important to understand that this is a minimum. And I'm really pleased to hear the University of Melbourne say that they want to tackle this seriously because they can.
Mr. just on the point you made before, if you're saying this is an improvement, why are we only getting 3% of 30,000? And why are we getting no TAFE teachers being offered conversion?
So, Senator, again, it's highly speculative of me to even try and answer the 3% question because I still don't know what the denominator is and how many of those people would have been eligible either under the legislation or even less likely have been eligible under the previous requirements within the awards.
So we wipe out, just so you can answer this to me clearly then, we can wipe out casual rights, which the casual conversion has done.
No, it didn't, Senator.
We
it
see
actually
that there's a fail on the number of people being
those
offered.
rights, Senator, because
there
with all due respect,
there's a 40 to 24%
Senator
less
Sheldon
payments paid to labour right people in
Mr
mining.
Hare.
Yeah. Senator Sheldon, it would help the committee to couch your contributions in terms of questions rather than assertions. And I'll give you the call back. Well, I didn't hear that. I didn't hear that. Senator Bilyk, I did not hear
Senator, that is
at the
not what I
time.
said. What I clearly said was that this was an improvement over the vast majority of awards. Indeed, when the Fair Work Commission did the analysis of the awards, it found that. So the independent umpire actually had a look at that.
An improvement that doesn't work.
But Senator,
it doesn't work. That's not an
Senator,
improvement.
again, at this point in time, we are preparing for a review, which is required within the Act, and we will commence that review. We'll absolutely look at these issues as part of that. I'd also reinforce that if there are dispute resolution processes, and I would absolutely encourage people who believe they should have been offered a conversion to take up those dispute resolution processes. And again, as I said, these are minimum. Any employer is able to offer a casual employee ongoing work at any point in time. So these are the statutory minimum.
No, just leave it to the employer. That's the problem. People aren't converting.
Well,
they aren't being offered conversion, and the conversion clause is not working.
That's
Senator
definitely
Sheldon
an
wants to
assertion.
continue making that point, but what Senator Sheldon also fails to acknowledge is that when a person is offered the opportunity, we don't force them, Senator Sheldon, to say yes.
But they have to
There
be
are
offered
some
first.
people who actually would prefer to be casual for all sorts of reasons, including that it actually suits their lifestyle better. You appear to be fixated on forcing a person to accept a position other than a casual position.
Minister, I've never put that suggestion at all. In actual fact, as it's well known, that there is a number of people who want to be casual, and there is a large proportion of people who want extra hours and permanency and security. That was found out during the Select Committee inquiry into job security, that some people don't want to be permanent, but there's a large cohort, substantial cohort of people that do, and dozens upon dozens upon dozens of people who are working regular hours, working regular years, were not being able to convert under this clause. And all we've seen is mine workers have, as a result of the Rosada overthrow by this government, mine workers lose hundreds and thousands of dollars of what they were entitled to under their original decisions.
So, Senator, that's clearly an incorrect statement, because the High Court, which is the court that makes the final decision, was very clear in its findings on those matters. So, referring to a lower court when the High Court's overruled that court is just not relevant. I think we just need to be respectful of the High Court and acknowledge their decision.
7-0.
Which was very, very clear in terms of what the requirements were.
Well,
I'd also like to just add, in terms of my answer, one of the most significant strengthenings, and again, this will be part of our review to determine whether it's being implemented effectively by employers, is actually the requirement to offer. So, that was not generally a requirement within most of the awards or in terms of the Open in terms of a requirement to offer. It was available for an employee to ask, but there wasn't this broad requirement to offer, which is now part of the National Employment Standards. So that's a really important component there, which is where an employer has done their job and done the assessment of making sure that the person has been with them for 12 months, has a regular pattern of work that is able to be picked up in the business, and there's no reasons not to offer that work, then they need to make that offer. So that is a really important step. Obviously, these are all factors that we will look at when we look at the review.
But again, Chair, without labouring the point, Senator Sheldon, you fought tooth and nail against this change happening. Tooth and nail against this change happening.
Well, that's inaccurate. The casual conversion clause and the rights, exactly. There's laws are proven. What my point is that the laws have been proven to be incapable of actually delivering what is stated by this government. It was
by the
false.
Deputy
It was
Secretary
misrepresentation by this
of
government
the
on what the
department.
intention of
Okay,
that legislation
Senator
was,
Sheldon.
because conversions aren't occurring.
So
The evidence
that's
given
a
directly
debating
by
point,
the Deputy
obviously.
Secretary
It's not a
blatantly
question.
contradicts
And
refer to-
I've just provided more than 15 minutes, so I'm going to retake the call here to Senator Small, and we will come back to a Labor senator after his block. Senator Small.
Thanks very much, Chair. And I feel like I've been in a bad dream in that we've gone through this many times with previous estimates, but I think it's worth hashing this out yet again and going through the data that actually underpins the reality in Australian workplaces today. So if we can start, please, and I'll just direct my questions broadly. Apologies, it's hard to see who's in the room there. So feel free to take the call as required. But firstly, it's often said that casual employment is used by younger Australians as a stepping stone to long-term careers, i.e. Their work as casuals, it supports them while they're studying. Does the data support that concept?
We'll get Ms Wang, Senator Small, to answer those questions for you.
Senator, I have figures about the incidence or the proportion of young people among the casual employees, and you are right, and the young people are more likely to take casual employment. So, for example, in the age group 15 to 19, incidence of casual employment is 72.8%. In the next age group, which is 20 to 24 years old, the incidence is 42.4%. So that compares to the across the board incidence rate, which is the 22.5 according to the latest data. And you can see the young people is more likely to take in the casual employment. There are some other informations we have in terms of particularly people taking short-term casual employment, the reason why they take short-term casual employment. So, for example, 2/3 of them working part-time, and I think it is 2 out of 5, and they are studying, so it's around 40% of them are studying when they're taking casual employment. There are some data, but unfortunately it may be the latest is not too contemporary. So there are around 30% of casual employees and moving on to non-casual jobs within a year.
So although Senator Sheldon and his Labor colleagues are determined to fight tooth and nail against young Australians being able to fit work around their life, is there anything in the data that suggests that casual workers are not satisfied with their current arrangements?
We don't have the data on dissatisfaction. We do have some data from Hilda longitudinal studies, which is collected by University of Melbourne. So they ask a respondent to report on their jobs, how satisfied they were with the jobs, and then we can aggregate that data by casual and the permanent. So the overall job satisfactions among casual employees and the short-term employees, they rate between 1 to 10, tend to be very satisfied, is 7.89, and comparing to the permanent short-term employees, and their rate is 7.93. So there are marginal differences.
That's very helpful. Thank you, Ms Wang. Whilst we're on data, can I just go through the same line of questions that we've gone through before, because clearly not everyone has listened to the evidence. So firstly, the proportion of casual employees as against the entire Australian labour force prior to the onset of COVID. Had that figure gone up as claimed by some, or had it in fact remained steady for a very significant period of time?
Senator, I might start the answer to that. So, in actual fact, both the numbers of casual workers has declined since the start of COVID, and that's notwithstanding that the total number of workers has gone up. So what we've seen is a change in the percentage. So my evidence earlier was it's about 22.9% of employees. I think over the last 20 to 30 years, it's been more commonly stable between 24 and 25%. Happy to get that checked, but that's my recollection is it's between 24 and 25% over a long period. What we've actually seen is a reduction in casuals in the order of 100,000. I think the numbers are less than in March 2020. And we've actually seen a 200 or 300,000 increase in workers over that entire, people working over that period. So it is what we are actually seeing is a move to permanent work as opposed to casual work.
And therein the data completely exposes the Labor lie around this issue. So I think, it's worth just going through it one more time. And I know, Mr Hare, we've done this before, but, and maybe Ms Wang, you can give me the information, but the proportion of casual employment in 1988, please?
I have the data here. You're asking for 1988?
Yes, correct.
1988 is 18.2 across all people, the casual incidents. And then from that point, it started gradually increase.
Yes, so 88 was a good year. I was born in 1988, but in 1996, what was the proportion?
Seriously. You can't see the reaction in this room, Senator Small, to that comment, but it's been quite profound. I'll be wearing my mask for the rest of the day now to hide my imperfections.
1996, please, Ms Wang.
Sorry, did I miss a question?
Yeah, sorry, the proportion in 1996, please.
1996. 1996 is 24.4.
Brilliant. And so I think the data therefore backs up what Mr Hare just said, in that the rate of casual employment increased between 1988 and 1996 and then remained steady for more than 2 decades until increasing, efficiency in the Australian workplace as a result of the changes this government has made, has actually seen fewer casuals employed and more Australians in full-time work and more women in work than ever before. Is that true to say?
From 1996, the rate has been broadly stable, but more recent year, as Mr Hare already given the evidence for, and the casual incidence rate has been lower, and the corresponding with a larger employment growth, and we see permanent jobs grow faster than the casual jobs.
Okay, brilliant. If I can turn to the specific effect of the government's industrial relations reforms last year, despite fierce opposition from Labor ganging up with the Greens to fight this tooth and nail, can you confirm for me that those government reforms finally extended universal casual conversion rights to all casual employees in Australia for the first time?
The national employment standards apply to all national system employees, so that does include certain employees, for example, working for state government. But the national employment standards, the casual conversion, does extend the casual conversion right to a first time to around 600,000 employees. Prior to the introduction of a casual conversion into the national employment standards, employees may be entitled to casual conversion under awards. The majority of awards have a casual conversion, or they are entitled to a casual conversion under enterprise agreement. But awards do not have casual conversion clause. And they were enterprise agreement doesn't have a casual conversion clause. And also under the Australia Industrial Relations Framework, there are awards-free and agreement-free employees in the national systems. So there is no agreement or award covers them. And prior to the introduction of national employment standards of casual conversion, they do not have the conversion rights. So the gap, the department estimated is around 600,000 people.
Thank you. So 600,000 casual employees in Australia now have a conversion right as a result of those reforms. Is it also true that as a result of those reforms that the onus is actually on the employer to offer casual conversion rather than on the employee to request it?
That is true. So this is, as Mr. Here already indicated, that's an improvement from the award model clause. But the only exception is small business owners and small business defined under the Act do not have the obligation to offer of a casual conversion. If I may, while I have the floor, is in the other improvement is the small business employees still have the right to request once they become eligible. And different to the model clause is that right is ongoing and a continuous right. It's not a once-off right.
Yes, absolutely. And so just to be very clear then, can you confirm for me that those rights to conversion were not a feature of the Fair Work Act as introduced and amended by previous Labor governments, and that this is in fact the first time that the Fair Work Act provides those rights?
Yes, the government and legislation expanded national employment standards and to include a casual conversion.
Thank you. Could you confirm for me, please, by what date businesses in Australia had to offer their casual employees a pathway to permanency by?
Sorry, would you mind to repeat the question? I missed the first part.
Could you please confirm for me by what date businesses had to offer their eligible casual employees a pathway to permanency?
There are two parts. One is under the transition arrangement, because there are existing casuals. So the business has to make all those offers by the 27th of September, 6 months after the legislation becomes in effect. For the new employees, and the business has to make an offer 12 months after 12 months at employment. And they need to make that assessment, either advise the employees they are not eligible, or if they are eligible, and they need to make an offer.
Indeed. So given that that date for the majority of businesses has only just passed some 4.5 months ago, would it be correct to say that we would not yet expect to see comprehensive data on the take-up of those conversion provisions yet?
Yes, as Mr. Here indicated before, there is no requirement for employers or employees to report on the utilisation of national employment standards, and that applies to all national employment standards. And the other thing I would say is that the transitional requirement asks employers to advise every single employee, irrespective of their eligibility, irrespective of whether they're meeting the eligibility criteria. So that does make the assessment of how many casuals and eligible casuals were made an offer, and how many eligible casuals accepted the offer is a bit problematic. But as Mr. Here indicated, there was an investment announced in the budget for the ABS to collect more robust and national-wise and representative data on an ongoing basis.
Perfect. Now, Mr. Hare touched before on the varying of the casual conversion provisions of certain awards. So can you confirm for me, please, that the Fair Work Commission found that the NES conversion rights, which were introduced and legislated by this coalition government, were more beneficial to employees, and I quote, more beneficial to employees, end quote, than the pre-existing clauses in the awards that have been quoted by the ACT and others, such as the manufacturing award, which only provided which only provided a one-off right to conversion, rather than the ongoing residual right that is now enshrined in Australia's National Employment Standard.
So the Fair Work Commission does take, as required by legislation, take in a casual terms award reviews, and the casual conversions in the award do differ across the award. There was a model clause, but there are some awards have traditional casual conversion terms. Fair Work Commission found the model, the National Employment Standard is more beneficial than all the award terms in the award. Specifically in relation to the manufacturing award you mentioned, the Commission outlined 3 reasons why the new national employment entitlements is better. The first reason is it requires employers to inform casuals of their right of request conversion earlier at the commencement through the casual employment information statement, and the response to request from employees more quickly. The second reason is it provides an ongoing residual rights, not just a one-off right to convert. Third reason, it also consider the national employment entitlement sets out more specific and the well-defined grounds to refuse a request. And so, of course, the conversion, the national employment standards also require the employer to make an offer. That's obligation on employers, which is the more beneficial.
Indeed, and in that same decision, the Fair Work Commission actually laid out that there were fundamental problems in the alternative casual conversion processes that had been proposed by some unions. Can you expand on that?
I did recall the Commission's made that statement, but I might need to take on notice about what the alternative proposal is. There are, I have to take that on that notice.
Senator Small.
No, I'm very happy with that.
Senator Small, I'll just, you've had just over 15 minutes. Do you want to wrap up here or have a couple more questions?
I could leave it here and come back, Chair. So.
Thank you, Senator Small. I'm going to Senator Pratt.
Senator Sheldon.
I'm going to Senator...
I'll do the EBA questions now. Can I ask, please, about the termination of enterprise agreements?
Do you have more questions?
Journalist Ben Butler published in The Guardian in January details of a report that indicates employer interest in unilaterally terminating enterprise agreements is surging. Are you familiar with that report, Minister?
I'll just get the relevant official to come to the table and take you through.
Okay, but Minister, you're aware of that report?
I'm aware of the general comments in relation to enterprise agreements, but I will now get...
enterprise agreements and their termination?
And Ms Anderson will take you through the statistics.
All right, no, I don't need to get to the statistics yet. We've just got to the report.
Sorry, Senator.
Is it correct that a new enterprise agreement can't be legally valid unless it has the backing of both employers and workers?
That's Jodie Anderson, First Assistant Secretary, Safety and Industry Policy Division. Sorry, did you say both employees and...
Employees and employers.
So are you reading from the report,
Workers and...
Senator Pratt? Are you reading from the report?
No, it's a general policy question.
So there are genuine agreement provisions in the Fair Work Act that have to be met in order for an agreement to be made, and that does require that employees do generally agree to an agreement before it is made and before it's approved through the Fair Work Commission.
Okay, I'll table the article just for...
Is this the Guardian Australia article?
Yes, that's right. And I'll ask if my office can post the link to that article to senators in our group. The law allows... Yes, thank you.
Pratt, we might just Guardian newspaper article. Committee's happy for that to be tabled, so tabled.
So to reach agreement, it requires both, but the law allows employers to seek to terminate that same agreement unilaterally. Is that correct?
In terms of terminations, employers, employees and unions that are covered by an enterprise agreement which has passed its nominal expiry date can unilaterally apply to the Fair Work Commission to terminate agreement. The Fair Work Commission, though, must consider a range of factors, though, before the Commission makes the decision to terminate an agreement. And those considerations are that it is not contrary to the public interest to terminate the agreement, and it is appropriate in all the circumstances, taking into account the views and circumstances of the employees, employers and unions covered by the agreement, and the likely effect that termination will have on them before the Commission makes a decision.
Okay, so the Commission makes the decision, but if employees say we don't agree to this, the Commission can support the employers that are seeking to terminate that agreement. I'd like to move on to some questions about the practical significance of terminating such an agreement. If a worker's pay and conditions are no longer governed by an enterprise agreement because their employer has made such an application, then what rules apply? My understanding is it's the relevant award. Is that correct?
That is correct, but there's also circumstances where other arrangements are put in place, such as maintaining salary and other conditions as well. So
yes, I've seen that
situation
happen, where when the agreement is terminated, it won't just revert to the award, but the Commissioner might add some extra things on, pretty inadequately, I must say, in terms of what I've seen. But before I'll keep questioning. Before the Fair Work Commission approves an application by an employer and their workers to move off the award and onto a new enterprise agreement, the Commission has to be satisfied that moving to the enterprise agreement will leave the workers better off overall. That's correct, isn't it?
In a broad sense, that's correct, yes.
So if the employer subsequently makes a unilateral application to terminate that exact same enterprise agreement, is the employer then required to satisfy the Commission that putting workers back onto the award won't leave the worker worse off?
So, as I've just previously noted, the Fair Work Commission needs to weigh up a number of things before it agrees to terminate the agreement.
Yes, but a better off overall test is not one of them, is it?
No.
It's never been the case under the Fair Work Act.
No.
Section 223 of the Act, did you want us to read it out for the
No,
benefit of
that's
Hansard?
fine. But I also think...
Just hold on one moment, Joe, we just got to get the...
Clarify that as part of that assessment, they need to understand the impact that the termination will have on the employees. So that is, they need to understand the impact is absolutely part of what they need to look at.
Okay, so can you explain what that safety net actually looks like for those that are forced back onto the award because their employer has moved in that way? What's the minimum standard underneath that between the award and the enterprise bargaining agreement that they were originally shifted off?
Senator, that would vary depending on the award, and as I mentioned before, dependent on whether there was other arrangements in place that were agreed through the Fair Work Commission process.
And so by vary, I take that there's no minimum standard.
So clearly the minimum standard is the award. You cannot go below the award. So that arrangement remains in place, recognising that the test, the Better Off Overall test, is an assessment against the award. So the movement up can only happen where it's better off compared to the award.
Okay, so
Senator
that I understand.
No, but you do understand these are, I'm assuming you do, that these are the rules that the former Labor government put in place.
I debated
yeah, I just wanted to
them
make sure that you
intently
understand that
at
exactly.
the time, and some of us thought it was a vulnerability at the time, and I was assured it wouldn't get used in this way, and I'd like to fix it.
So is the point you're making, just in terms of just where you're going, is the point you're making that there is an ability for an employer to unilaterally terminate an agreement? Is that the point you're trying to make?
No, it can only be done by the Fair Work Commission, that I
Right.
understand.
I just wanted to make sure you weren't going down that path, because then we would have, yes.
What I am concerned about is that when an employer moves to terminate the agreement via the Fair Work Commission,
Or via the Fair Work Act, yes, in the Fair Work Commission, yep.
it means work there because the minimum standards, the Better Off Overall test doesn't apply. It's correct that workers can get a pay cut or a cut in other pay and conditions.
So can I just clarify that? So it's slightly awkward phrasing to say the boot doesn't apply, because the boot's applied against the award. So
That I understand.
So to say it doesn't apply when you can't drop below the award is the bit that I'm questioning in terms of that. But yes, if the Fair Work Commission determines that it's in the public interest, after all of its consideration, that an agreement be terminated, and also presuming there aren't any undertakings as to maintenance of pay, etc., then it's possible that someone could have a reduction in their pay from what they got under the award, under the agreement. Sorry.
Under the agreement.
Yep.
So we're talking about the gap between the agreement, enterprise agreement, and the award.
Potentially,
Is there
yes.
any limit on the amount of a worker's pay that can be cut by being forced back onto the award?
I think what's important here is that Mr Hare actually take the committee through, yet again...
No, I prefer if you just
but it's the
answer
considerations that the Commission need to take into account and what they have to weigh up between the parties, the individual parties, before they come to any decision.
I'm well aware of what those are, probably not in the same detail as Mr Hare, but that was not the nature of my question.
So
When you're looking at what the Commission can do after an employer has applied to revert to the award, is there a particular point between the enterprise agreement and the award? Is there any limit between those two levels, about how much pay a worker could lose?
So there's no arbitrary limits, and that's because the process that's within the Fair Work Act is clear about the requirements for the Fair Work Commission to have a look at a range of factors. So the Fair Work Act acknowledges that all circumstances need to be considered, and the Fair Work Commission is in the best position to do that. So the requirement that the Fair Work Commission must consider all of the circumstances, including the views of the relevant employees, the employer, and any employee organisation, unions, that are covered by the agreement, as well as the impact that termination will be likely to have on them. So rather than having an arbitrary figure in there, the Act requires the Fair Work Commission to take into consideration all of those factors in determining whether it's in the public interest or not to terminate the agreement.
Okay, so
quite often, Senator,
I've seen.
No, I
I've
was going to say what you'll find in
observed a number of
practice.
these. I've observed a number of these in the case of Avato and others. I don't need to hear in practice. I want to ask.
No, but the point in
specifically-
practice, Senator Pratt, is that often an employer and the employee will actually reach an undertaking as part of this process. And the
I've seen
undertaking
that-
will be
I've
to the
seen
effect
that
of
happen.
they don't drop.
Sometimes it's about trying to keep a business viable and all of those things, and people want to keep their jobs, etc. But if there's an overall move and interest for employers outside, restructuring to keep a business viable, where an employer, as we've seen here, you've got employers expressing interest in taking this to the Fair Work Commission. Can I ask what the minimum entitlements will be in relation to sick pay, leave entitlements and redundancy entitlements? My understanding is that the minimum requirements are the award.
The modern award rate, it will...
So, Senator, again, it's subject to the process of the
Correct.
Fair Work Commission and subject to any undertakings that might be made.
I do understand.
So
It may be that Senator Small, when he gets a line of questioning, Mr Hare, might be able to ask you to actually go through the process, because that seems to be what's missing here.
Yeah.
No, I've seen the process in action. I'm looking for the statutory minimum standards in the law, and as I understand them, they are simply the award. So what assessment have you done on how much sick pay, leave entitlements or redundancy entitlements could be lost by workers?
So, Senator, in terms of the difference between the award and an enterprise agreement, the range can be tiny to large. There can be, 1 or 2% difference in some cases, or it could be a significant difference in others. So,
How significant?
I haven't. I'm not sure if I've got. I have to take on notice what the largest difference is. I don't have that to hand, but it can absolutely be substantial.
Yeah.
So, does that? But recognising that the basis of the Fair Work Act is it sets a statutory minimum,
Correct.
and then enables parties to bargain, with both parties being part of that process.
That I well understand.
Just as in any decision or any consideration of a request, an application to terminate, the Commission must hear from all the parties.
Can workers be forced to work longer hours for the same or less pay under these unilateral decisions by a company that are approved by the Commission?
So again, that would depend on the difference between what they have in their agreement. So if their agreement enables them to work less than the maximum amount of hours that is set within the awards, then yes, that is possible. But again, it's the awards provide a broad safety net that's currently utilised by about 2.7 million employees are, I think, paid on awards. So, yes, there is the difference between what's been negotiated and what's in the award system.
Yeah.
And in some
you've
cases,
answered that very well, Mr Hare. Can I ask, though, there are some industries where routinely the industry operates on the award, and there are others where you have had EBAs evolve that have, for more than a decade, have evolved where the award hasn't been updated. What's your assessment of the gap in things like the hourly rate?
Again, I'd need to do that to have a look. I just have to take that on notice.
Okay,
Thank you. You can take that on notice.
There's a point of order.
I just think it's... Senator Pratt is asking questions about, this is not a single issue. There is not one single award that can be compared to one single EBA. There are over 120 odd awards in Australia.
I don't disagree with your point,
and then there
Senator Davey.
Thousands of EBAs, and you're asking
I don't think you need
what
to
is the
interrupt
hourly
my
difference?
questions
It
to
is
make
an
it.
impossible question to answer.
Well, I believe the Mr Eyre has taken that question on notice,
yes.
so
And he's
we
quite
can move
capable
on.
of answering it. So for employers, particularly in the circumstance where there's a big gap between the EBA and the underlying award, it's going to be all downside for workers, isn't it?
Chair, we have a small
It's
issue
a
here.
free-for-all.
In the first instance, let's be very clear, and I do appreciate the comment that you made about your own legislation, Senator Pratt, that you thought that it was unfair. I'm verbally you there, but that was the implication of what you said. So we're operating under the Fair Work Act that the former Labor government put in place. In that time that you're in government, you did not change this. So let's just be clear there. Let's also be clear that in relation to
It wasn't a problem at
what
that time.
you are referring to, the statistics are incredibly limited. That is because negotiating an enterprise agreement is done between both parties. Both parties come to an agreement that benefits them both as a whole. Okay, that is an enterprise agreement. In relation to...
Point of order, Chair. Point of order, Chair.
Senator Pratt, you are verbling the evidence.
I haven't asked a question about this.
You are verbling the evidence that is being given.
Senator Pratt can raise a point of order.
Point of order, Chair. I haven't asked a question about this.
So that's not a point of order, but Minister, I'd ask you to
relevant
conclude your
because it's not
contribution as brief
relevant.
as possible.
There is then a process that must be gone through by the Fair Work Commission. Senator Pratt, when she asks her questions, makes it sound as simple as an employer can unilaterally terminate an agreement and suddenly the employees are on the award. That just does not represent, Chair, the reality that the Assistant or the Deputy Secretary has been at pains to try and explain to Senator Pratt. There is an entire process that is set out in the Fair Work Act. It's around 223, 222, those sections. And the Commission has to weigh a number of considerations before it makes a decision. But at the same time, as we have also noted, agreements will also be entered into often by the employer and the employees in relation to what terms and conditions the employees may revert back to, and you will often find they remain the same. I just wanted to ensure that that's on the Hansard record, Senator Pratt, because your question assumes a simplicity that is just not the reality.
Thank you, Minister. I'm going to rotate the call soon, but I'm happy to give you... Do you need to finish this line of questioning, Senator Pratt?
Okay, well, I want to take you to an example, and that is Qantas, and Senator Sheldon and I want to address that.
Is this a new... I mean, I'm just...
No, it's about
I'm
this
only going to give
issue.
you 1 or 2 minutes, but it's up to you whether you'd like to...
Rotate the call, please,
Yeah, okay,
Chair.
and
Thank you.
it'll only be 15 minutes and I'll come back to you before lunch. Senator Davey.
Yeah, look, I would like to get my head around the process properly because Senator Pratt's line of questioning implies it is as simple as an employer saying, I want to terminate an EBA, and the Fair Work Commission rubber stamps it. But my understanding is it's not that simple. There is conversations that need to be held between all stakeholders. Mr Hare, do you mind explaining the process so that we can actually understand more fully what employers have to, what hoops they have to jump through before they can actually have a termination signed off?
Yes, so look, probably some context is useful. I'll ask Ms Sheena and Ms Godden to come to the table to talk you through the Act, but...
Is this a point of order?
Just if, I mean, it's up to Senator Perrin if she wants to do this, but it would just be of assistance for, if you want an explanation, they should include the Horizon case, which was the first one that demonstrated a shift of the Commission's views about how it works.
Okay, thank you for that point of clarification. Mr Eyre.
We've got someone coming to the table, Senator.
So while they come to the table, recognising that the termination occurs post the nominal expiry date of the agreement, I think it's fair to say that reasonably often it's part of the back and forth of the negotiation. Some more recent examples have been after quite long periods of negotiation, and parties seem to be able to reach agreement through the process. I note the most recent Patrick agreement appears to be on track to be agreed, where there was an application to terminate an agreement within part of that after some period of negotiation. It's also important to recognise that employees have, as part of this period of negotiation, the ability to undertake protected industrial action. So it is part of a broader process. And again, it's not just employers who can seek to terminate agreements. Employees can seek to terminate agreements, and we've seen a couple of what so-called zombie agreements terminated, which have actually resulted in improved conditions for employees. So it is clearly envisaged within the Act that this process is possible, and parties will look at how they use these provisions carefully. But I might ask Ms Sheen to walk you through.
Thank you. As Mr Hare said, employers, employees and unions that are covered by an enterprise agreement which has passed its nominal expiry date can apply to the Fair Work Commission for termination, and that process is set out in sections 225 and 226 of the Fair Work Act. The Fair Work Commission has to take into account a range of factors. They have to consider whether it would be contrary to the public interest to terminate the agreement. They have to consider whether it would be appropriate in all the circumstances, taking into account the views and circumstances of the employees, employers and unions covered by the agreement, and the likely effect that termination will have on them. And part of that consideration would include any undertakings that the employer has made as part of the process. So, for example, that might be maintenance of particular terms and conditions that would be maintained above the award. So in that assessment of the likely impact on employees, that would be one of the factors that the Commission takes into account.
So it's not right to say that if an employer applies for termination and it is successful, then employees automatically and every time go straight back onto the award. There may be conditions that are retained from the EBA to protect employees if it is determined that it's in their interest.
There may be instances where there's conditions that are maintained above the award. In terms of the process that the Commission would go through, there would be an opportunity to hear from, if it was an employer that was seeking to terminate the agreement, there's a process to hear from employees and from unions that are covered by the agreement to put forward their views. So the Commission would arrange a hearing to hear from those interested parties.
And in fairness to what Senator Sheldon was saying before, and it's referenced in this article that was tabled by Senator Pratt, the Horizon case, but does the success of that case mean that the Fair Work Commission is not applying as stringent a lens over termination applications going forward from that case? Because the legislation hasn't changed. The rules, which we know is Labor's legislation, has not changed to make it any easier to terminate, or am I misinterpreting?
So could I just get you to repeat?
So
that?
Senator Sheldon wanted us to reference, and it's referenced in this article that was tabled, the Horizon case. This article implies that since the Horizon case went through, there are more applications to terminate EBAs. But am I right to point out that the legislation hasn't changed? So while there may be more applications, it's not any easier to terminate, or am I misinterpreting?
You're correct. The legislation hasn't changed yet since the commencement of those provisions.
And is it also fair to say that, as Mr Hare alluded to earlier, employee groups can apply to have an EBA terminated, and they have done so in the past with regards to what was colloquially known as zombie agreements. We did propose amendments to outlaw zombie agreements, but they weren't supported by the opposition. Is that correct? Or maybe I'll ask the Minister that.
Yes, that is correct. That is correct.
Yeah.
And it's correct that employees can seek to terminate as well, not just employers.
And on the law of averages, do we have any data to show which side is more likely to apply to terminate?
I think I would have to take that on notice unless anyone has. Sorry, my colleague just noted that the Fair Work Commission would have that data on the outcomes.
Very relevant. I'll we can put that to them later. I think that's all from me. Thanks, Chair.
Thank you, Senator Davey. I'm returning to Senator Pratt.
Thank you very much, Chair. So in relation to Qantas, I understand Qantas has different categories of staff under its existing enterprise agreement. Is that something the government's aware of?
Yes.
Okay. I'd like to focus on the impact of Qantas's decision on what I understand are referred to Group 1 international cabin crew. They are our most longest serving loyal staff. Many Group 1 cabin crew have served Qantas for 20 years, others even longer, and most of them are women. Are you familiar with the enterprise agreement?
I'm aware that there is a separate enterprise agreement there, yes.
And are
I'm
you
not familiar
aware
with it.
of the relevant modern award?
Not aware of the detail of it, Senator.
Would you know what the gap is between the enterprise agreement's base rate and the award?
Not offhand, Senator. I'd need to take that on notice.
Okay, so the EBA has $73,700 and the award is $45,864. Now, I know that this is an area that Senator Sheldon spent much of his working life on, working with Qantas and other TWU members, so I'm happy to hand to him now.
Thank you very much. So we're seeing that there's the number of people forced off the enterprise agreement under the award. A worker employed as Group 1 flight attendant will going to have their pay cut by $27,836. That's how it works, isn't it?
So, Senator, this is a hypothetical. The Commission hasn't heard this. There is no determination around what the decision
in the case.
Chair.
This is.
But the minimum
if there
standard is the award.
But hold on, Chair, this is a hypothetical because as Ms Hare has stated...
Can I rephrase? I'll rephrase it in a different way, Minister.
But it is a hypothetical because the Commission still has to go through the process.
The difference between the enterprise agreement and the enterprise and the award that covers the area for Group 1 flight attendants is at $27,836.
Is that a statement that you're making, or is it?
No, it's a question. We've just been given given you the figures.
We
for
take
Group
it on
1.
notice to confirm whether or not that is the case, but I'll take it at face value that you're not misrepresenting that.
So
thank you, Minister.
The qualifier to that is I don't know what conditions.
Correct. There is a whole lot of qualifiers
rolled in terms of actually reaching that figure. It's entirely possible that things were negotiated away from the award, so it's a bit hard for me to say what the actual difference is between what's paid under the award, because that's the pay rate.
If I can, I appreciate I'm not asking for all the details, but you're most welcome to give them to me because I know the answer will be, an eye-opener hopefully for you, because the fact is the base rate there's a reduction of $27,836.
So hold on, Chair.
And also,
again,
I'll be not surprised when you have a look at the comparison with the enterprise agreement and the award that there are substantial losses for other benefits, monetary benefits, to those workers as well as condition arrangements by going to the award.
The Commission, though, Senator Sheldon, you would acknowledge what Mr Hare has said up front, that the Commission has not yet made any decision in relation to this. So what you are putting forward is actually a hypothetical at this point in time. Well, at least acknowledge
can I just express then the position of both the various parties, both the Flight Attendants Association of Australia, the Transport Workers Union of Australia, and Qantas are of a view that the likelihood is that this will occur if the company pursues its desire to use the Horizon decision from 2015. That it will be that agreement will be terminated, and the consequence of that will be certainly the figures that we've given you as an example, the 27,836, 37% odd wage decrease. So I just want to go under the enterprise agreement, Group 1.
That is, hold on, the Deputy Secretary.
So I just want to check, and I might just check whether Anne or Sarah can work us through the Horizon details. My recollection is that there were actually undertakings given to pay or conditions within that. So that does make it a little bit more awkward to rely on this being a difference between the award and that. But if I can just get that confirmed, and that's my understanding, recognising I need to have it confirmed.
We understand we might need to double check this, that undertakings were given to maintain the salary under the EA for 6 months, but we might just need to check that detail.
Thank you. So Qantas could potentially, Qantas or another employer in that position of Horizon can make an application to say we'll keep the same rate for 6 months and then bye-bye.
Yep.
Potentially, that's
Thank you.
That's open to
Thanks
employers.
Thanks for the clarity. Under the Enterprise Agreement, Group 1 international cabin crew working as supervisors have a base rate of pay of $90,000, but under the award, the base rate of pay for supervisors is $53,513. So a supervisor kicked off the Enterprise Agreement and forced onto the award will get a pay cut of $36,487. That's how the system works, isn't it?
So, Senator, again, that's a hypothetical. We've noted that for Horizon there was an undertaking to maintain pay for 6 months, which we are seeking to confirm. And at that time, and I understand this is also part of the Horizon process, the view was that the parties were able to continue their bargaining processes, including any industrial action that the staff or employees may have wanted to take. So certainly, and as I perhaps implied rather than stated clearly before, there are times when this seems to be a tactic to try and hurry up a stalled process. Whether anybody actually gets paid less or not is a hypothetical process.
One more example from Qantas. A person working as a manager in Qantas, Group 1, international cabin crew, gets a base rate of pay of $105,964. But under the award, their base rate of pay is $62,498. Though that gets a pay cut of $43,466 if the company is successful.
Chair,
and
again,
based on the Horizon case matter, that the success rate for many of these agreements without consent of the workers being abolished since 2015 has dramatically jumped. So what we're saying is that when did the government first learn of Qantas' plan to gut the paying conditions of Qantas' most loyal and hard-working staff, Minister?
Chair, again, Senator Sheldon, you have jumped to the end of a process that has not been gone through. You are merely presenting the committee with hypotheticals. Hypotheticals in relation to what a decision may be. As the Deputy Secretary has pointed out, there is a process that the Commission must go through. The Commission has not yet gone through that process. My understanding is also in relation to the offer that Qantas had put on the table was they'd put a 4-year deal on the table that offered more than 6% pay increase and higher allowances. My understanding also is Qantas has said that they are open to putting the same deal that was rejected back on the table, but they would have to negotiate some changes. So I think it's really disingenuous for you to jump to an ultimate conclusion when there is still an entire process to play out.
Minister, you keep saying it's a hypothetical, but this is the proposed outcome of Qantas's application, which you are refusing to intervene in to support
again,
those workers.
Chair, in relation to that...
I haven't finished my question.
Can I just say here, I've been listening closely. We are going around in circles.
Haven't finished my question.
Senator Sheldon, if you want to take up your time making assertions, I'm going to let the Minister make assertions countering the record. That is perfectly fine and reasonable for the Minister to do that. And while hypothetical in nature is not necessarily a public interest immunity, it is certainly unreasonable to ask the witnesses to have detailed information about different scenarios that are currently not occurring in real terms. But Senator Sheldon, back to you.
Chair, I note the Minister has the statement from Qantas, which is helpful because this question that line of questioning is not hypothetical, because the proposed outcome of Qantas's application, which this government is refusing to intervene with, has the consequences of tens of thousands of dollars being ripped out of these workers, that have been working for this company for years and years and years. It'll devastate their families. It'll devastate their capacity to pay for their families' upkeep, mortgage, rent, food, you name it. We'll see mortgages, we'll see houses being handed in. So I'll go back to my question. When did the government first learn of Qantas's plan to gut the paying conditions of Qantas's most loyal and hard-working staff?
Well, in the first instance, Senator Sheldon, you would be aware that this application is ultimately a matter for the parties and the Fair Work Commission. You would acknowledge that. It is a matter for the parties and the Fair Work Commission. Secondly...
Is that a question to me?
No, I'm just saying you would acknowledge that, though. Secondly, the process, as you know, has not yet been gone through. The Fair Work Commission will consider and will decide the matter in accordance with, as the Secretary has laid out, the Fair Work Act. What that also includes, as we have heard, is considering the views of the parties and the effect of the termination on them. In relation to an intervention, my understanding is, and I'll get the Deputy Secretary to provide further information is required, as the Qantas application to terminate its enterprise agreement is currently being dealt with by a single member of the Fair Work Commission, the Minister actually has no specific entitlement to intervene. But as I've said, we would continue to monitor this matter. But at this point in time, it is currently before a single member and there is a process to be worked through. I don't know, Mr Hare.
I might pass the machine to work through the process.
Ms Sheehan.
Yeah.
Yes, that's right. In the Fair Work Act, there's no automatic entitlement for the Minister to intervene before matters before a single member of the Fair Work Commission, whereas when matters are before the full bench of the Fair Work Commission, there is a provision of the Act which entitles the Minister to intervene.
Thank you, I'm aware of that. What I'm saying is that the Minister, do you intend to intervene if it's required to stop these workers from having tens of thousands of dollars ripped out of their pay packets?
Again, Senator Sheldon, I don't think you listened to the evidence that I just gave. Ultimately, the application is a matter for the parties. There is a process still to be gone through, and the Fair Work Commission itself will work through that process. It will consider and it will decide the matter in accordance with the process that is set out in the Fair Work Act. And as I've said, this is the Fair Work Act that the Labor Party itself created. You put in place the regime that the Fair Work Commission must work through. It has appropriate checks and balances in place. It will consider the views of both of the parties, including, as you know, the impact of any decision on a party. At this point in time, it is being dealt with by a single member of the Fair Work Commission. There is therefore no entitlement for the Minister to intervene. But as I have said to you, we will continue to monitor the case.
So, Minister, when did the government, just back to my original question, which I'm not clear on the answer, when did the government first learn of Qantas's plan to gut the paying conditions of Qantas' most loyal and hard-working staff?
Well, Senator Sheldon, that is a characterisation you are making. If you are asking when the government first became aware of the application to terminate the agreement, I'll take that on notice for you to find out exactly when we became aware.
Are you able to give us an estimation?
As the department, I'm not aware of us knowing in advance, so I'd need to take that on notice, but certainly I didn't know in advance, but I'll need to check.
So how did the government first learned of this plan through the media, did they?
Certainly that was my first awareness, but I'll confirm with my staff.
I will take that on notice for you, Senator Sheldon.
What conversations have occurred since they've become aware of the Qantas intention to take tens of thousands of dollars out of Australian workers' pay packets? What consideration, what meetings have taken place since then?
So again, I'll need to take that on notice. Certainly, I haven't had any discussions with Qantas since this. This is we would regard this as a matter for the parties, where the employees and the unions are best placed to identify the impact and on them and argue around whether it's in the public interest or not. And we certainly would anticipate that. Of course, we'll monitor it. But this isn't something where we would see at this point a need to intervene.
Would you be able to give me, if you aren't able, if no one here is able to tell me what meetings have taken place and what conversations have taken place at this point in time, are you able to take that on notice?
We'll take that on notice for you.
In the conversations with Qantas, are you aware, did the government offer any support for the Qantas plan?
For the Qantas?
For the Qantas plan to rip off tens of thousands of dollars out of wages of workers?
Again, Senator Sheldon, this is a matter for the parties, and then there is a process to be worked through.
So the government hasn't offered support for the Qantas plan?
Well, again, as I've said, the government's position is this is ultimately a matter for the parties in the Fair Work Commission, and there is a process to be worked through.
What written correspondence has been exchanged between Qantas and the government on the issue? Can a copy of the correspondence be made produced on notice?
We'd have to take that on notice.
Are you aware that there is any written documents?
I'm not aware personally, but I'll take it on notice.
Mr. Here?
No, I'm not aware of any.
No, I'm not.
Is the Qantas providing financial support or any other form of support to Qantas in relationship to this matter?
It's Qantas
Is the government,
providing...
is the government providing financial support or any other form of support to Qantas in relationship to this matter?
Not that I'm aware of, Senator Sheldon.
Could you please also provide the committee with an account of all the support, financial and otherwise, the Morrison government has provided Qantas since the 1st of January 2020 to date, which is all other support?
When you say support, how are you defining support?
Packages, the financial support that the government has given to Qantas. There's been packages given to the aviation industry, which is specifically...
we may have to refer that to another portfolio for you.
I think it's more likely to be Treasury.
Yeah, but we can take that on notice, and if it needs to be referred to another portfolio, we can refer it.
I just want to give...
Yeah. I've now got some questions in relation to a similar issue at the Tuftmaster company. They make carpets, not grass.
I was thinking green.
Tuftmaster Carpets, they're based in Dandenong in southeast Melbourne. Just like Qantas, Tuftmaster are planning to apply to terminate their enterprise agreement and force their workers back onto the award, but for a different underlying reason. Are you familiar at all with that case?
So that, again, sorry, and just checking the words you used, you said are planning to apply.
Are planning to. They haven't yet.
So have they applied? So if that's, sorry, so that's even more speculative in that they haven't even made an application at this point, if that's what you meant.
Well, we did discuss Avato here in Senate estimates before they had actually formally made the application, and the company had been talking to them about a whole range of issues in relation to applying to cancel the award. The government had spoken to them, as I understand it. So I'm asking in similar terms as to whether you know about the Tuftmaster case.
I need to take that on notice. I'm not aware of it.
You're not personally aware. No. Is anyone else here aware?
No.
Okay.
So are you saying that you're confirming they haven't made an application to do it?
Well, I'm unaware of whether they have or they haven't, but I'm told that they are planning to.
So we haven't.
Yeah, we'll take that on notice, Senator.
Tuftmaster has a relevant modern award. My understanding is that if they make an application, that the difference in the award from the EBA is quite significant, but because they're Tuftmaster workers suspect, frankly, that the company is planning to shut down whole sections of its operations, slash its workforce and relocate whatever's left. Are you familiar at all with how a company might go about doing that? For example, as Avato did?
So there's a range of mechanisms available to companies in terms of how they work through any downsizing, etc. So yes, conscious that there's a range of mechanisms that can be used.
Okay, but you're not familiar with Tuftmaster's plans specifically, or if Tuftmaster's approached the government? You're not aware if they're going to relocate their business or anything like that? They have a very hard-working, dedicated workforce, some of whom have been with the company for some 20 years or more. And as any decent employer, I think, would think that kind of loyalty is a great thing. And they, of course, have built up a great deal of value in their accrued entitlements. Tuftmaster obviously sees its good workers as a liability, because under the enterprise agreement...
Yeah, Chair, I think we need to be very careful here. You're making allegations in relation to an employer that you're saying, oh, but I've heard. And now you've just said they obviously see their employees as a liability. Chair, I really do think we need to be careful. You were just making assertions, Senator Pratt. At this point in time, we've said we're unaware. You may also now wish to give this employer the ability to respond to the allegations that have been made.
Right,
that was quite a serious one.
I'll reframe my...
Senator Pratt.
I will certainly reframe my question, Chair. I acknowledge Senator Cash's concerns.
Okay, thank you.
Just a separate... And I'm not, with all due respect, but you keep on saying, I have been told, I have heard, but then you're making a number of allegations into how the company may or may not think. And I do think, Chair, we just need to be very, very careful.
Well, I believe Senator Pratt has taken that on board.
Thank you.
It's a fair point. But a separate issue, sorry, Senator Pratt. Can I just ask at this juncture, with less than 10 minutes left, do you believe we'll be able to wrap up with the department before lunch as scheduled?
We might go a little longer, and I'll seek some clarification.
And we'd be able to wrap up if we had that flexibility, you think?
I will ask the airwaves to let us know what they want us to prioritise.
Let us know
next.
before the 15:15. That would be good.
So, in terms of the interpretation of what a liability is, and I'm not saying that as a moral liability, I'm looking at the financial aspects of this, and Mr. Hare understands what I'm saying. So, is it true that if you've been working for a company for 20 years or more, you would have accumulated under the EBA accrued entitlements?
So under the EBA or under an award, there are redundancy provisions subject to you not being casual.
Okay, so if the Fair Work Commission endorses a decision to revert to the award, what happens? And I appreciate the Commission might vary it in various ways.
Process as to what might happen.
Yeah, it might vary it in various ways, but what happens to accrued entitlements and the value of those entitlements if their current value is the entitlement under the EBA? What happens to those accrued entitlements if you just revert to the award without any variation?
Understood.
So my understanding, and I'll just check with the team, is that you would then become, your entitlements would then be calculated off the entitlements that are in the award at that point in time. So I'll check and confirm that.
I think we'll have to take on notice that level of detail.
I'm sorry, you would have to take that on notice. Well, I know the answer to that, and that is that, yes, the bare minimum is and there have been cases that have demonstrated that. Are you familiar with any such cases,
So
Mr. Hare?
I'm certainly aware that if there's a revised enterprise agreement, that the agreement then applies. So I think the principle stands, but I would want to confirm that. I would take that on, confirm that, but broadly that's my understanding.
Okay, so what happens to your accrued long service leave or under the EBA if you revert to the award?
So long service leave will be a range of things, and often...
Or your accrued leave entitlements?
So there's a range of things that happen there. So long service leave is generally a matter for states and territories and is actually legislated by the states. So...
And what about, I'll accept that. What about your holiday pay that you've been saving up for a long trip?
So your leave entitlements in terms of the period, I need to check. So that's the level of detail I need to check. So I'm not sure. So the reason I need to check this is if under the EA you had 6 weeks leave and under the award you have 4 weeks leave, I need to check and see what happens to that conversion in terms of do you get calculated the 6 weeks you held for that period and then it's calculated forward on 4 weeks per every year.
I think I'd really appreciate if I notice you can give us the answer to that. And what about the rate of pay for those weeks?
So the rate of pay, my understanding, would be based on the rate of pay at the time. But again, that's something I need to check.
My understanding is that it's the rate of pay under the award, even though had you taken the leave instead of accruing it, you would have been paid at the rate of the EBA.
So that's broadly my understanding. I do want to confirm it, but that's a very similar principle in working the other way in one sense. So if you accumulate pay at a junior rate, if you accumulate leave at a junior rate and you don't take it for some period of time, and you get promotions, etc., or pay rises, you're paid at that rate at the time that you take the leave, is my understanding. But I do just want to confirm that, Senator.
Yes, that's what happens currently. But if you revert to the award, my understanding is you revert to your accrued entitlements revert to the old rate. So you're no longer paid.
The Deputy Secretary said he'll take on notice just to ensure that you've got the exact information, because there may be other considerations that are factored in, which is why we have to take it on notice.
So if a company does want to restructure, what are the implications for the cost of such a restructure in terms of accrued entitlements? And I've seen it happen that people think their accrued entitlements are set in stone. What happens when a company applies to revert to the award, not so it can revert to the award to keep those workers, but revert to the award so that it can make them redundant?
So, again, that reversion process needs to go, if it's not agreed by the employee, so if it's not a new agreement struck with the employees, that decision still needs to go through the Fair Work Commission processes, and I certainly believe that would be a factor that the Commission should be considering in terms of whether it's in the public interest. And I believe that parties would absolutely argue that something that's done to reduce employee entitlements in order to wind up or pay them less in their redundancy is a factor that needs to be considered in a public interest test.
It might be that we on notice work through the process for you, because again there are different considerations along the way that we can actually set out for you.
Is it possible that the reversion to the award could see accrued entitlements drop below even the value of the fair entitlements guarantee? That would be a worker would have access to if the company went broke instead of successfully restructuring?
So it depends on which point you're talking about. So if the premise is that they went broke with the higher pay and conditions still in place, then the assessment would take place, and I just might get Mr Manning to come to the table. The assessment would take place on what the conditions were in place at the time of the insolvency.
Yes, I understand that. I understand that that's the case. But what happens if you sought to restructure and went broke?
Yeah.
And got the award cancelled and went broke anyway?
Got the
I think there's
cancelled.
Yeah, I think there's a number of issues here, and some might be being confused. So you're not just talking. So accrued entitlements will remain the same. The employee will either get paid out the accrued entitlements or they'll transfer to another employer, depending on the situation you're talking about. You're talking about in the event that the company is wound up?
Yes. Then you would have access to the fair entitlements guarantee.
Correct.
And my understanding is, if the company can't afford to pay out the entitlements,
You go back to the fair entitlement guarantee scheme.
Fair entitlement guarantee.
Yep.
In the case of Avato,
yes,
even though they didn't go broke, you gave them access to the fair entitlements guarantee.
So can I just be clear? The company that became insolvent was given access to, not the company that was no longer in danger of being insolvent.
The four companies.
Yeah.
Okay, so were those entitlements in the case of Avato for the company that went insolvent that did get, what was the value of those entitlements that were paid out?
Oh, so you're saying what is the entitlement under the fair entitlement guarantee scheme?
No, that's not my question. My question is,
Senator
the
Pratt,
award
maybe-
was...
We're a bit over time.
The award was terminated in the case of Avato.
I think I can answer that.
Well, hold on. Mr Manning seems to be
So we in
understanding what you
administering
want.
the fair entitlements guarantee, we'll make an assessment of what was the relevant governing instrument at the time of liquidation. In the Avato case, it was the 2020 Avato Enterprise Agreement. Now, that is an issue that is in dispute in the AAT, but we would do that in every case, depending on the facts. We would do an assessment of what was the governing interest, either the enterprise agreement or the award, as the case may be. And in that case, one enterprise agreement had been terminated and another agreed in 2020, and our assessment is that it's that 2020 agreement that was the relevant instrument at the time of the insolvency of the four companies. And as I said, there is a matter in the AAT where that's been contested.
Okay, so as a matter of policy for the government, if a company has successfully applied to restructure, revert to the award and got that, but nevertheless then went broke, would the government pay the entitlements under the fair entitlements guarantee to the value of the guarantee or to the value of the award?
As I said, it would be to whatever was governing the employment relationship at the time of liquidation. And if that was the award, it would be the award. If it was an enterprise agreement, it would be the enterprise agreement. If it happened during the restructuring, that would be something we'd have to look into and take advice on and again, pay out.
Senator Pratt, we are now going, and I believe I have got information that you would like some additional questions, but we'll be able to make up time later in the day. So is this an appropriate time to break? I'm just wondering, we will have these.
Well, I can finish these in 5 minutes. I know we're over time if you want.
I'm happy to finish this section off, but what we might
because
also
it's a bit of a mind-bending thing.
There's a number of considerations that have been put on the table. So we'll also, on notice, review all of the evidence to make sure we've understood the different considerations that you're putting on the table, and then ensure that the evidence given appropriately responds to the consideration. But if we finish up this, I think that would assist.
Okay, I have a real-life case study from Tuftmaster, who's worked for 20 years. The enterprise agreement has built up a redundancy entitlement of equivalent to 70 weeks' pay. And that worker relies on the idea that if they were to ever lose their job or get shut down, that they would get those 70 weeks, and that's part of why they've stayed loyal to the company for that time. But if the award, if the EBA is unilaterally terminated, or even with some variation, and drop the workers' accrued entitlement down to the award, his redundancy entitlement would go from 70 weeks to just 12. A cut of some 63 weeks, more than a year's pay. Another example is worker 2 has given 19 years of loyal service. Under the enterprise agreement, they've built up a redundancy entitlement of equivalent to 57 weeks of pay.
Yeah, no. So, Chair, to be fair to the officials, again, I understand what you're doing, Senator Pratt, but there will be a number of considerations. So to be fair to the officials so that they can actually properly analyse the situation, can we take it on notice and on notice provide you with what the analysis may be?
Look, you may do that, but can I put to you that you do not have, you cannot explain here and now an actual safety net that protects these workers' entitlements beyond, if you revert to the award, then that's what they'll get. If you send the company, if the company can't afford to restructure, then they'll get what's in the Fair Entitlements Guarantee. There is nothing here that protects their 20 years of loyal service.
So, Senator...
if you can point to something, then please do.
So, Senator, the Fair Entitlement Guarantee is, of course, a legislated scheme. Correct. And we're required to apply the legislation in practice in terms of administering that, and the team always strives to do that. So we are following what the Parliament has determined is the correct process. For the other factors, I have taken on notice the detail of that. There are a range of complexities there that I'd need to work my way through in relation to the hypothetical in terms of what they might have under their EA versus what they might have under the award. I don't have the EA or the award in front of me, so I'm just not able to. Yeah.
These are real workers. Have you got any words of comfort that you can give them that will demonstrate that the government will be in a position to protect their accrued entitlements?
So the only thing that I can really add then is that, the Fair Entitlements Guarantee is a process that's designed as a safety net. It does have some parameters associated with it in terms of some caps, etc.
And those parameters might be dropped from 70 weeks accrued entitlement to just 12.
So I might ask Mr Manning to work through the detail of the parameters around the FEG scheme, but there is a cap in terms of the payment level in one form or the other that Mr Manning will be able to work you through. But it's where public monies are put in, stepping in, there are the requirements to follow the Act.
So the entitlements, the FEG covers unpaid wages of up to 13 weeks, capped at 13 weeks, unpaid annual leave and long service leave, payment in lieu of notice capped at 5 weeks, and redundancy pay of up to 4 weeks per full year of service. They're capped, so our assessment's done on the governing instrument at the time, and entitlements are calculated based on a maximum weekly wage of $2,529, which is $131,508 per annum.
But, Chair, just to be clear, Senator Pratt, you are putting to us a hypothetical situation, just to be clear, and we are taking you through examples of what you
It's not all that hypothetical,
are indicating.
because it did happen in the case of Novato.
My understanding is there's no Fair Work decision that has been made. There's no decision to wind up a company that has been made. There's no claim on the FEG that has been made. So I think we do just need to be very careful that... I'm happy for you to put scenarios to the department, and you can ask what that scenario might look like or scenario might look like. But at this point in time, it is a hypothetical, Chair.
Okay.
Well, that might be a good opportunity to break. As I flagged some senators have some additional questions
Okay, so
for
the
the
department will come
department
back.
after
Yep.
lunch.
Okay.
But I'm told that we should be able to make up some time within the agencies and
Okay.
hopefully get back on time. So with that, I will suspend and we will return at 2:25 p.m.
Thank you, Chair.
Well, I will resume. The Education and Employment Committee. We're still with the Attorney General's Department before we go to questions. Just checking with all the committee that we do not need questions for the Registered Organisations Commission. Okay, Mr. Bilecki, you are dismissed. Released, sorry. Okay, I'm not a school teacher. All right, no detention for you, but there is detention for the Attorney General's Department. You've got to stay over. So I'm going to give the call to Senator Sheldon.
Thank you very much, Chair. Minister Cash, I just want to go to some straightforward questions to start with. Can you tell us what the national minimum wage is for both a permanent employee and for a casual employee?
I can, and if you hold on for one moment, I will actually get that for you. Thank you very much. Yeah. Did you want it as a dollar figure or as?
As a dollar figure would be.
$20.33 is my understanding as to what it is based on the last decision.
And the casual loading with that comes to $25.41, is that correct?
So the casual loading of?
With the, if
Yeah,
they're
so
a
the
casual
25%
employee.
casual loading on top of the minimum wage.
Yep, so it comes to $25.41. Thank you. The Fair Work Commission recently ruled that the Road Transport and Distribution Award is the appropriate...
Sorry, I can't. Can you just speak up ever so slightly?
Oh, no, sorry. Thought I was speaking quite loud. The Fair Work Commission recently ruled that the Road Transport and Distribution Award is the appropriate award for Menulog employees. As you're aware, Menulog is a food delivery company. Can you tell us what the lowest minimum hourly rate is in that award?
I don't have that in front of me, so I would need to take that on notice, Senator Sheldon.
Maybe I can give you just assistance when
Yep.
they're looking for it. So Transport Worker Grade 1 is $21.53 per hour.
Yep, so
as
it's
a
above the
permanent.
minimum wage, as you say.
That's right. And if you're with the casual loading, it's $26.91. Are you aware what the minimum wage for an Uber driver or delivery rider is?
So I can't remember.
Are you aware what the minimum wage or minimum payment is for an Uber driver or delivery rider?
Well, it can be no less than the $20.33 per hour or the $772.60 per week in terms of what the minimum wage is.
So I might just clarify that. So that would be as an employee. My understanding is that most of the rideshare arrangements are regarded as
the different
independent
arrangements, sorry.
contractors.
Yep.
Where there's no set minimum wage within that. There is a provision within the Independent Contractors Act that allows an independent contractor to bring an action seeking to have the minimum wage enforced.
Thank you. Minister or Mr. Heard, are you aware what the average income, is for those workers working for Uber or as a delivery rider?
I'm aware of media reports, and I think from some statements within the Security Jobs Committee report, where there's figures identified. I think we've discussed them previously, Senator, and as part of that, we've identified that while we're aware that there are payment levels identified from one company, but we're also aware that it's quite common for people to work across a number of platforms. So we don't have to ourselves an accurate figure.
Working across the number of platforms.
Yeah, so it's hard for us to determine what an actual payment figure is, but we're aware of the evidence.
So can these people access a minimum wage?
Um,
Senator Cash I'm sorry, Senator Cash, the Minister has said.
So my recollection, I just might check with Ms Sheen or one of her team, is that the Independent Contractors Act does allow, have provisions that enable independent contractors to seek to apply to the court to have at least the minimum wage applied.
So how would they do that if they're working for multiple employers to get that minimum wage but doing the same job for all of them?
So that would be a complex sort of circumstance that the court would be best placed to address.
So if Mr. Hare,
Mr.
Hare, just on the point you just raised, is it correct that under the Independent Contractors Act that there isn't an appropriate enforcement mechanism for someone who takes a claim on the basis that you just put?
So my recollection, Senator, is that the claim needs to be made to a court rather than to the Fair Work Commission, and that the court can make an order in terms of what the payment should be, but it can't cast that backwards.
Yes, so they can make an order about what the payment should be, but they can't enforce the payment.
From the past, no.
Sorry, back to Senator Pratt before I've got some further questions though, but back to Senator Pratt if you want to.
Senator Pratt?
But I'm happy to keep going. So.
You go.
Okay, sorry.
Established there, and thank you, Mr. Hare. There has been a number of studies that have been carried out and evidence at the Job Security Inquiry Committee report that looked at the whole series of questions about payments, average payments. Some evidence was saying it was as low as $6.90 an hour. Some evidence was saying an average of $12 an hour, again before costs were taken out. Others were saying around $13. Some were saying 10. So it's certainly there was no evidence that we were given except from one report, which was reported today in the media, and also had given a preliminary report to the committee from Uber, which put a different view. Sorry, Minister, that might be better. Put a different view to all the independent academic reports and the union report. But there's also a study published last week in the Australian Economic Review of data provided by Uber, covering 10,975 Uber drivers, found their average hourly pay after some cost was $21 an hour. That doesn't include leave or a 25% loading in lieu of leave. It doesn't include superannuation and doesn't include workers' compensation. So the average pay for an Uber driver based on Uber's own figures is substantially below the national minimum wage, isn't it?
Subject to those riders not doing any cross-platform work during those hours, which is the bit that we don't know, based on the figures of $21, that's below the minimum wage with the loading. So if the minimum wage loading figure, I think, was $25.44, the $21 would be below that.
If you take the $21 per hour, thank you for that. If you take the $21 per hour average and take 25% off for a leave loading and a 10% off for the super guarantee, that actually comes out at $13.65 an hour. And that's still being before receiving workers' compensation. Does the government regard $13.65 per hour as a living wage?
So the framework for employees is clear that people shouldn't be paid below the minimum wage, and that if they're entitled to a loading, that they should receive that loading. The Independent Contractors Act does have the provisions in it, is my understanding, that enables a claim to be made, but it is up to the contractor to make that claim. So it's quite clear the Fair Work Commission's decision about the minimum wage is an independent decision, and they determine a range of facts independent of government to form their view about what the minimum wage should be.
And thank you for the explanation. That's I just wanted to ask the question though: is that $13.65 per hour a living wage?
Sorry,
maybe the minister could make a comment on that.
So that's on my before the minister's happy. So the view about what a living wage is that's ill-defined. So certainly, I think we would acknowledge that $13 is below the minimum wage for employees of $20.33.
That question seemed to be asking an opinion of the witness. Keeping in mind, I don't believe there's a legislative definition of living wage or anything, or established by a court, and the common practice is not to ask officials for opinions.
I'm more than happy to put it, Senator, to the Minister. Does the government agree that $13.65 per hour is a living wage? Is a living wage?
Well, Senator Sheldon...
Can you live on it? Might be another way of saying it if you makes it easier.
I'll take this off. As you know, and I know that you have different views on the gig economy, and certainly throughout the inquiry, the gig economy inquiry, that was made clearly. Ultimately, the minimum wage itself is determined, as you know, by the independent umpire. They have the annual wage review each year. In terms of the gig economy itself and those people who work in it, they can work across multiple platforms. I think there was evidence at your inquiry that there was one worker, he said, they were earning $60 an hour via the gig economy. It presents, as you know, opportunities for flexibility and a variety in how people work. They build their skills, etc. I mean, you heard all of this at your inquiry. Many Australians choose to take up this arrangement because that is what actually suits them in terms of how they want to live. It only still represents, as you know, and I'll have Mr Hare confirm the statistic, it is a very, very small part of the workforce. We, as you know, gave the ABS, I think it was $2.8 million over 4 years, to actually expand and improve labour market surveys to enhance industrial relations statistics, including workers engaged in the gig economy. Ultimately, as you know, and this was again seen throughout your inquiry, you need an evidence base, and we are looking at the evidence base. You also raise work health and safety matters. I know you canvassed them in great detail again throughout your inquiry. There are a number of matters currently before the Fair Work Commission, I understand, in the courts concerning worker status in the gig economy. But ultimately, it still is a very small part of our workforce. We do need to continue to gather the data in relation to how the gig economy is operating, pay close attention to the decision of courts and tribunals, the views of stakeholders, and how platforms operate both in Australia and internationally, but also of the understanding that people can operate across varying platforms.
Mr. The small part of the economy, Uber describes that they have 120,000 people working for them in Australia. They're the second largest engager of workers. There's also, sorry if you didn't hear that, Uber had 120,000 people working for them in a year, and they see themselves the second largest employer, engager of workers in this country. The $60 you're referring to, if my recollection's correct, is referring to what was being paid when Uber first came in the market, and there was considerable evidence given by that same individual about how it had substantially declined over the period of years by arbitrary decisions by Uber, which weren't negotiated, just arbitrarily said, here's what we're going to pay you, either accept it or you don't have a job. So it goes to my, and last but not least on the ABS statistics, that there was evidence was given regarding the ABS, that it was still deficient. I recognise that there's money being spent, but the ABS statistics haven't been efficient in identifying the number of contractors, individual contractors that operate in this sort of fashion. So I must go back to that question. It is, in light of there's a gap in regulation and protections, and I described most recently as a result of a recent High Court decision by a number of learned individuals that this is a gaping hole in the Industrial Relations Act that many ill-intended employers could use and well-intended employers could be abused by as a result of the unfair playing field in the marketplace. So I go back to that question, this question then, that Minister, the day after the report came out on the 8th of February, your spokesperson was quoted in the Sydney Morning Herald saying, "The Morrison government supports giving Australia's genuinely self-employed and independent contractors, including in the gig economy, the freedom and flexibility to enter into contracts, negotiate their own rates of pay, set their own times and duration of work and perform services for multiple organisations at the same time. So is $13.65 per hour an appropriate rate for people to be paid, and arbitrary decisions by these companies on how their work is remunerated?"
Well, my understanding also is, and I'll get Mr Hare to respond as well, but in terms of Uber were called before the committee a second time, I understand, in November 2021, where earnings during the period of the Sydney and Melbourne lockdowns were considered, and the average earnings per hour before cost was revealed was $29 per hour for food delivery and $32.25 per hour for the ride shares. So again, I go back to, this is but a small part of the economy. I stand by the comments that you just made. We have provided the ABS with the additional funding so that we can properly inform ourselves as to the evidence base. In terms of the safety for the workers, though, that is paramount. Regardless of who they are and how they work, every single worker, no matter how their employment arrangements are structured, they have a right to a safe working environment and to come home safely at the end of the day. And as you know, the work health and safety laws themselves, they are already flexible enough to capture arrangements in the gig economy. But ultimately...
So look, Senator, in terms of the figures, so I note the figure that you used for Uber was 100,000 over the year. So we tend to actually try and do our assessment in terms of who's working within a particular week. So the week of the survey is how we actually do it. So again, I'm not clear on the process there. As the Minister has identified, we are working with the ABS in terms of actually developing a definition of the gig economy, which is actually quite a difficult task. To my understanding, nowhere in the world, in terms of the statistical collection agencies, actually have a working definition. So working with them in terms of defining what the gig economy is, and then seeing, using that definition to actually gain the data that we need. So from that perspective, we are working with the ABS to improve the data collection, or to actually enable data collection around gig workers. And the first thing, there have been a range of surveys and undertaken, but again, we're not clear on the methodology of all of them, where I've seen figures go from 0.7% to 7%, so quite a range of figures estimated there. So from our perspective, it's still very hard to quantify how many people are working in the gig economy in any particular week.
And evidence was also given that there's a substantial increase in areas such as the NDIS, that there is substantial increases, evidence from both employers that there was a substantial increase, and also from workers themselves. The New South Wales Point-to-Point Transport Commissioner delivered an audit report on the Uber in July last year, and it's just recently been obtained under Freedom of Information in New South Wales, which said that they looked at 32,000 drivers when the state audit began in complying with its direction. So there's 32,000 drivers at that point in one state alone. So I just want to go back to this question then, that the evidence from a number of independent inquiries have come up with substantially less than what Uber said that they were paying, substantially less. Evidence from individuals said there was substantially less. Accenture carries out an inquiry, Australian Economic, and reported in the Economic Review, so it's the most recent inquiry, and they, with the way that they've concluded the evidence that was given to them by Uber on movements and payments, that they concluded as a result of these payments, or comes to the conclusion of the result of these payments, that those payments are substantially less than the minimum wage. So we've got everyone except Uber, surprise, surprise, saying that they're getting paid well below the minimum wage. And we've got every organisation, think tank, we've got every academic report, we've got every industry broad report, except Uber, saying that they are being substantially paid less than the minimum wage. We've got evidence from individuals during the inquiry that made that very clear as well. Minister, is it about time that we actually regulated this area and gave people some rights? And I just want to just clarify one thing before you answer that.
Yep.
I am not saying that people that are contractors should be employees. I'm saying people that are contractors should be getting workers' rights, and these workers should be included in that.
Yep. So in the first instance, just in terms of evidence, my understanding is there was also evidence given at the inquiry in terms of a question that was posed. What do you believe your approximate hourly rate is when you're driving Uber? The evidence given from this Uber driver, it varies. It all depends on how busy the platform is running on the day. If I'm in a quiet area around where I live, which is out and about in the city, you could probably get $20 per hour. But in peak times when I'm working, I can get up to $50 or $60 an hour. I also understand that the Uber numbers that you've mentioned account for online time and not just the time workers were engaged on Uber tasks, which meant that those people could have been earning on other platforms, and that was the whole point of what we were saying previously. You can work on the other platforms or studying at the same time as, say, getting $32 an hour for Uber. I know that you very much want to regulate this space, and I respect that.
Yes, give people rights. Yes, I'm very keen.
Well, and I've said I've gone through with you in relation to safety in the gig economy, and in terms of the work has done there, and the basic premise: every single worker, no matter what their employment relations or how that they're structured, they have the right to a safe working environment and to come home safely at the end of the day. And in that regard, as you know, I've had this on the agenda for the Work, Health and Safety Ministers, and we've talked this through. And the model work health and safety laws, they are already flexible enough to actually capture arrangements in the gig economy. This still represents, though, a small part of the workforce. It is a part of the workforce that presents opportunities, in particular in terms of flexibility. You need an evidence base before you seek to regulate to the extent that you want to, which is why, and thank you for acknowledging, the funding that we have provided to the Australian Bureau of Statistics to enhance the data in this regard. We continue to monitor, as you know, how the gig economy is operating. We pay close attention to what's happening in the courts, the tribunals, the views of stakeholders, how platforms operate both in Australia and internationally. But to just go in and regulate something like you do could possibly have the effect of wiping it out. And I'm assuming that's not what you want to see either.
That's correct, Minister. As you know, that I've spent a great part of my life representing owner-drivers and making sure that they keep their jobs and they keep running efficiently and effectively, but also have rights. And the question is, and that does go to the very important question about the capacity in, for example, in other jurisdictions in New South Wales, proposed in Victoria and proposed in Queensland, to give those contractors rights. Because in the statement that was attributed, your spokesperson said that there's a freedom and flexibility to enter into contracts, negotiate their own rates of pay. Well, are you aware that that's not possible at Uber and Menulog and, not Menulog, apologies, but at Uber it's not possible, Deliveroo it's not possible, and the list goes on?
We've just got some more information for you here as well.
So, certainly aware that those platforms tend to use algorithms and set the price. But importantly, in October of 2020, there was an exception announced in terms of a class exemption for small businesses with turnover of less than 10 million, which would include independent contractors, including gig economy workers, to collectively negotiate under the competition law framework without first having to seek ACCC approval. So certainly, and we've seen in other countries, Uber drivers, where they have formed a collective or been unionised, have been able to
effectively have sought to negotiate for prices and for conditions. So from our perspective, the Independent Contractors Act remains important, and I acknowledge your view that you're not trying to change the Independent Contractors Act, but certainly it is possible for people to collectively negotiate in these arrangements from our view.
I won't go through chapter and verse all the difficulties of actually negotiating through that body, because it's well documented, and the fact that so many independent contractors don't utilise that service because it's an impractical way that it's actually developed. And there is a bipartisan approach to independent contractors being able to get employment work justice, to get justice about return on capital for the labour that they put in, so contractors to have rights. And it's been a bipartisan piece of legislation that exists for now many decades in New South Wales, which has included bipartisan amendments that have been supported by and even proposed during periods of Conservative governments to make sure those independent contractors have collective bargaining rights, the right to withdraw their labour, rights against discrimination and persecution in employment or engagement practices. So there is a number of opportunities there to do it. The problem that we've got now, and that is that we have, evidence from, all the independent evidence saying that these average income, the average payment for people within this particular work category, and specifically at Uber, are paid substantially below the minimum wage. And my point is it sustainable? Now, one of the things that became quite clear in the point-to-point inquiry in New South Wales, those recent documents I referred to, a recent report, the New South Wales Point-to-Point Transport Commissioner, was that a small percentage are on the road for 17 hours a day. This is what's happening at Uber right as we speak. There's somebody picking up your family members or one of us potentially here. A sample of more than 11,000 shifts found 26% of drivers had completed shifts of 12 to 13 hours. That includes time off the Uber platform, but the audit documents note that. Now, 79% of the offline times are less than 30 minutes, and drivers are generally driving in their vehicle during the offline time. So on the question of the capacity, someone working 79 hours, and there was actually examples of 2,189 of nearly 32,000 drivers at Uber that worked at least 30 consecutive days, and 458 drove 61 consecutive days. Now, I'm not criticising those drivers. The fact is, if you're paid a wage that's not livable, then you stretch yourself. Without having regulation, which has been proven in inquiry after inquiry across this country so far, right along the eastern seaboard, both Labor and Conservative governments, that there is a need for minimum rates and rights for those drivers and contractors to have a system to be able to pursue justice. And if you can't do justice, well, then you keep working, because otherwise you can't put food on the table. Starvation wages or starvation? Putting yourself at risk to try to earn enough to provide for your family, or turning around and getting paid too little? My question is this, and that is that is the program regarding these payments for $13.65 is the amount that was paid, Minister, from the Essentia report, if they are correct, the average income from the Essentia report of the $21 per hour, isn't an appropriate amount of money to be paid? And the fact that people can't negotiate their own rates of pay, is that a gap in the industrial relations system?
And again, Chair, I think I've answered this question several times now in terms of, depending on the methodology that's used, depending on whether or not people are working on other platforms other than just the platform that you have referred to, I've made it clear that the government's focus at this time is building the evidence base on the gig economy and participating in the national effort appropriately to ensure that the work health and safety laws and the safety outcomes are improved for these drivers. And there has been a significant body of work that has been done at the state and territory levels. But again, Senator Sheldon, it is such a small part of the workforce. You do need that evidence base. That is why we have provided the additional funding to the Australian Bureau of Statistics. What you don't want to do is step in and regulate a part of the economy that presents, in particular, significant opportunities in relation to flexibilities for people, you know, in how they work, in how they build their skills, in how they operate their business, and actually close that part of the economy down. There was a lot of evidence given. I think you've had 3 reports now?
4.
4 now. I thought the one wasn't delayed. I do apologise. In terms of how this works, the capacity of people to earn, how they actually earn working over the different platforms, etc. So I think we're going to have to agree to disagree. You would like to just go in and regulate overnight. We're going to build the evidence base to ensure that if and when the appropriate policy decisions are put in place.
Could I just intervene here, Senator Sheldon? We are almost 30 minutes over the allocated time for the department. You are, of course, within rights to continue to ask questions, but I do tend to agree we've started to get around in circles, and it's an interesting policy debate, but there are other appropriate forums for us to do that in the Senate, particularly given all the officials that are here. It'd be good to get back to questions in regards to their areas of responsibility.
At the 2021 budget estimates in June last year, I asked Senator Stoker whether it was appropriate that workers at Uber and Deliveroo are getting paid well below the minimum wage. Senator Stoker said, and I quote, "It's true to say that a person who chooses to enter into a job as a contractor where they know the terms of the work that they've been doing and they know the rates upon which they are being paid, and are nevertheless happy to enter into that arrangement, are not victims of exploitation in circumstances where they know what they're getting in for. If it's a choice between starvation wages and starvation, people take starvation." My point is, ABS statistics or not, there has already been 30 years of history of giving protections and rights to contractors in the state of New South Wales. There has been decades in other states. In actual fact, it's well over half a century now in the state of New South Wales where there's been rights under the industrial relations system. There's not a new phenomenon. It's not just because Uber turned up. It's because Uber has turbocharged the exploitation of workers getting paid below the minimum wage, legally or not.
So,
Mr. Hale will address it.
Senator, so at this point the department is considering the 4 reports and the recommendations within them. And I note that this is one of the recommendations within them. And there is a reference to the New South Wales transport processes. So we will, of course, look at those reports. We will, of course, look at the evidence provided to the committee, and we will provide advice to the government once we've finished our analysis. Certainly, and I acknowledge the comments from the Assistant Minister Stoker, but I do think she followed those up with some other comments, which I'll try and see if I can identify. But the important thing, I suppose, is that everyone's looking for the evidence base to try and find a way to understand what's the best approach in this area. And the department will consider the report, consider the recommendations and provide our advice. We'll also continue to work with ABS to develop a definition of the gig economy and then to roll that out and actually ensure that we're able to collect information. It is a difficult policy area, there's no doubt about that, but certainly we will absolutely consider the report and we will provide our advice on it to government.
And sort of my final question on this is that I am very aware that the previous Minister Porter said this was too complicated to make a decision on. I'm also mindful that these issues have been raised for some considerable time during the period the government's been in power, and also there has been regulatory frames that do apply to contractors that have applied on the national level. So that this isn't, I just want anyone to be misunderstand out there that this is something new, fresh, something non-consequential that hasn't been around for many, many decades.
But it also
and has been turbocharged by Uber's being the second largest employer in this country. People are being ripped off.
Well,
That's the problem.
You also have to acknowledge, Senator Sheldon, that at this point in time, it is a very, very small part of the labour market. The labour market in Australia, like everywhere else, is an incredibly diverse labour market. It presents opportunities to people. The gig economy itself presents, as we've talked about, opportunities in particular for flexibility, etc. On this hand, we're looking at building the evidence base, as Mr Hare has just taken you through, on the gig economy. But at the same time, we are participating in the national efforts that we've talked about in terms of ensuring the work health and safety. So you are seeing progression, Senator Sheldon. I know you just quoted the previous minister. I'm not aware of that comment that you've put on the table. But the area is changing. You are seeing laws adapt to the gig economy. But I think where we disagree, well, we have to agree to disagree is we want to ensure that they are the right laws that don't have a detrimental impact and actually close down. You seem to want to regulate overnight with a sledgehammer, whereas you need that evidence base to make the right decisions.
I don't think I've suggested that at any stage, Minister, that any sledgehammer should be used. I'm just saying that governments right across the eastern seaboard of different political complexions have dealt with this, have come to conclusions on it. The capacity's there for the government had the will to do it, to have had it done by now. Thank you. No further questions.
Thank you, Senator Sheldon. Senator Pratt, did you
yes,
still
thank
have
you, Chair.
questions?
I've got some questions now about both labour hire. Actually, I'll start with labour hire. Minister, previously in Parliament, the Leader of the Opposition and the Shadow Minister for Industrial Relations have raised specific real-life examples of labour hire workers who work side by side with directly employed workers doing the same job, same hours, same roster, but are nevertheless paid significantly less. 2 train drivers at Pacific National's coal mine in the Bowen Basin who do the same job. One's employed by Pacific National and one by a labour hire firm. The train driver employed by the labour hire firm is casual, so should be getting all those loadings, but nevertheless still earns around $300 less than his colleague every single week. Minister, can I ask if you think that's a problem?
Well, I think, are you referring to Labor's same job, same pay policy, which has been widely criticised by employers, including Innes Willox, Chief Executive of the AI Group? The last time that, I think he said this, it is all cost, all barriers. The policy takes us back to the 1960s-style 9-to-5 workplace, which is unsuitable for a 21st century economy. Labor's bill is unfair and unworkable as it contains all the flaws of the original announcement, bearing in mind that this is a rehash of a previous policy. Steve Knott, the CEO of the Australian Mines and Metals Association, it's clear that the true intention of the ALP's policy is not same job, same pay, but to shut down labour hire arrangements at the behest of the ACTU.
Okay.
I was hopefully,
So,
Chair,
Minister, I asked if you think this was a problem. I can take it from that lengthy reply that you don't...
Well, no, Chair, I don't seem to...
I'd like to hear the rest of it. Minister, did you still have...
By all means, let it rip.
I did. Ultimately, Senator Pratt, and I think I've answered this question previously in question time, the government believes in a workplace system that promotes safe, fair, harmonious and productive workplaces. We want to encourage employers and employees to work together, not a system that you propose that is going to actually pit them against one another. If you look at labour hire itself, and I believe we've discussed this
I think
at
you've
a
gone beyond
previous-
answering my question, Minister. Chair.
Chair, a question was posed to me.
I said, do you think it's a problem?
Yes,
and you
yes.
haven't
And I'm about to get
addressed
to...
the disparity in the wages,
Hang on,
which
hang on. You
is
said-
what the question was about.
Sorry, Senator Pratt. You asked if the Minister thought something was a problem. She's quoting a range of people that are giving their opinions on whether it's a problem or not. That is clearly directly relevant. Minister, you have the call.
In terms of labour hire, you would recognise that it has been stable at less than 2% over the last decade. You'd also be aware that labour hire employees have the same rights and protections as all other employees when it comes to, for instance, unfair dismissal, rights awards, entitlements, general protections and work health and safety protections, to name but a few. You also would recall, I think, and this was something that we had discussed previously in question time, your own Fair Work Act means that labour hire employees working under enterprise agreements will already have rights and entitlements above the relevant modern award. The Fair Work Act, again, and I think, again, we've discussed this in question time, that you introduced does not overrule the ability for workers to negotiate their own pay and conditions by setting particular levels of pay. It only requires that every employee is better off overall under the agreement compared to the relevant award. So, Senator Pratt, I think the fact that employers who employ people have come out and absolutely slammed this rehashed proposal. I mean, I'm just looking at Andrew McKellar, the CEO of the Australian Chamber of Commerce and Industry, said the federal opposition's plan to increase labour hire regulation risks undermines the competitiveness and flexibility of the Australian workforce. I think that pretty much, Senator Pratt, answers your question.
Okay. So, did you know, well, Minister, you won't know this, but I'd written in the notes here, presumably the Minister will attack Labor's policy and bill. But I will ask you now, does this mean that you agree with your colleagues in the House, including Mr Fletcher, that this is a made-up issue? That the fact that someone is getting $300 less in take-home pay for the same job is a made-up issue?
I think the question needs to be, why does the Labor Party continue to demonise this type of work? I've clearly set out what the position of the government is. I've set out what the position of employers is in relation to your bill.
Okay, so despite being presented with real-life case studies of labour hire workers being paid as much as $300 less per week than a directly employed worker, you don't believe that's a problem. Is that correct? Minister, you can give me the long explanation. I am asking you specifically about the pay disparity.
Well, Senator Pratt...
Is there a problem with the pay disparity?
There are two different types of employment.
Yes, I understand that.
Of employment.
But is not a casual worker supposed to be getting leave loading and the like if they're on labour hire? I still don't understand how they could therefore be getting less rather than more money than the directly employed worker.
Senator Pratt, can I just intervene? When you ask a question asking someone for an opinion, I'm going to let the witnesses make a reasonable attempt to answer that question and provide context for the interpretation of that opinion. As I've discussed, you cannot ask opinions of witnesses, but I think it's reasonable for the Minister to explain that. Your question was not one of facts or established objective truth, but if you continue to go down this path, we are probably going to end up with very lengthy answers and be here longer than we'd all like, but the call is yours.
Well, thank you, Chair. I would draw to your attention in terms of fact, yes, they have different employment structures and different types of contracts, but I point to the fact that these workers do the same job and one earns $300 a week less than the other. And I want to know if the government thinks that is a problem.
So if I might perhaps assist. So I think in an earlier answer to Senator Roberts, I gave the basic frame here, but I think it's important to repeat that, which is the Fair Work Act clearly envisages that people can be doing the same job and get paid differently. The Fair Work Act provides a set of provides the framework for the minimum payments, which are determined independently by the Fair Work Commission. It also provides a framework where people are able to bargain, where employers and employees can reach agreement about employment arrangements or that are higher than the award. That model automatically contemplates that there can be people doing exactly the same type of work and getting paid differently. The model is predicated on the agreements being made at the enterprise level, at the business level. So what that means is that where one business and their employees feel that the business is profitable, that they're able to increase productivity, they can enter into an arrangement that reflects that. Where another business, even if they're in the same business and they don't feel they're getting the same level of profit or productivity or whatever the issue might be, they are able to either remain on the award or negotiate a lower rate. Or indeed, if they wish to, they could negotiate a higher rate if they believe that was affordable. So the framework within the Fair Work Act is predicated on the assumption that businesses, often employing people doing very similar, if not identical jobs, are able to be paid differently.
Correct.
So is it fair? I think that's a very difficult question. It's a very subjective question. What I would say is the Fair Work Act, in its construction, clearly envisaged that.
Yes, okay. Which means I take that as a yes.
But you understand this is Labor's Fair Work
No,
Act.
no,
This
that was
is the
not my
system
question. I understand the origins of the Fair Work Act.
It's a system that you put in place and it envisages exactly
I don't
as
need a
Mr.
lecture
Hare
about that,
has
Minister
set
Cash.
out.
It was not the basis of my question. Minister, the ABS appeared at the Senate Job Security Inquiry last year and told us about the ABS Labor Account Data Series on labour hire. To quote the Program Manager of the Labour Statistics Branch, Mr Bjorn Jarvis, he said the labour account gives us the best sense of the size of the industry, how many people are employed by the industry, jobs in that industry, the hours worked in that industry, and the total remuneration. I'm assuming you're familiar with the labour account, Minister?
So I might actually ask Ms Wettinger to talk you through our views on that in our discussions with the ABS.
No, well, I haven't asked a question. I just asked the Minister. I've put a quote, yes, but I've simply asked the Minister, you're familiar with that account.
An official actually talk you through the statistics?
I haven't asked those other statistical questions yet. Okay.
Yeah.
So, according to the labour account, the number of jobs in labour hire have increased from about just over 500,000 in 2011 to 12 to 797,000 in 18-19. That was a 37% increase in 7 years. Minister, can I ask, does that sound like a made-up issue to you?
So So this is, I might start and say, so we're aware of the quote. So we have discussed this issue with the ABS, and my understanding is the ABS has confirmed that the best source of information on labour hire as a working arrangement is the characteristics of employment publication, as noted in their answers to written questions on notice from Senator Sheldon as follows. The best source of information on labour hire as a working arrangement in Australia is the annual characteristic of employment supplement. This provides information on whether employees were registered with a labour hire firm or an employment agency, and also whether they were paid by a labour hire firm or an employment agency. So that, my understanding was that was provided on the 22nd of November 21.
All right, so Minister, I understand, because I'm familiar with the debate, and that you're going to characterise the employment data, which shows the number of people working in labour hire, as lower than I state, and that it hasn't grown. But as you rightly point out, that data is collected by asking a sample of respondents if they're paid by a labour hire firm, while the labour account data is actually collected from industry. So you cannot deny the fact that there have been in labour hires own industry reporting 797,000 jobs in 18-19, which is a 17% increase.
Chair, I can't add anything else to what Mr Hare...
No, I'm not asking you to add. I'm just putting my own...
...given evidence to in relation to the source of the statistic. In terms of just some basic facts and figures in terms of labour hire, I mean, it's been stable over the last decade at less than 2%, which is the point that we've been talking about. I think that's around since 2008. It was 1.1% of employees in August 2020. The highest was 1.5% in November 2011. The low was what I've just referred to, the 1.1% in August 2020. But again, okay. Senator Pratt, I can't add anything further to what
I understand
Mr.
the difference between the ABS data and the data reported by industry itself. According to the Queensland Coal Mining Board of Inquiry in '96, direct employment accounted for more than 94% of jobs in Queensland coal mines. Today in Queensland coal mine, direct employees are in fact outnumbered by labour hire and other external contracts. Does that sound like a minimal issue, a made-up issue, particularly for those employees?
Mr Hare has presented to you the evidence in relation to the data that's relied upon. I have provided you with the evidence in relation to the general trends. I think what you're doing is picking and choosing data that supports your theory. And again, Chair, I can't add anything further to what Mr Hare has put on the table.
Well, I put it to you, Minister, that if you are working in coal mining in Queensland, the data that you are looking at and is relevant to you is the fact that it was 94% of workers that were directly employed, and now labour hire and contract work outnumbers those directly employed. So
on coal mining, because you have mentioned coal mining.
No, I haven't asked a question. I was responding to the data that you said I had been selective, and I have put back to you that the data that I quoted in relation to those 94% is very, very relevant to those workers. Can I ask, as I said, Minister, do you or your government propose to take any action to stop this? Clearly not, because you've given me your philosophical understanding.
Now it's now a Q&A answered by Senator Pratt.
You did ask a question.
Indeed.
You can't answer your own questions.
Well,
Minister, would you like to add anything?
Well, I can't.
Well, just
give the Minister the call, Senator Pratt.
You mentioned coal mining, Senator Pratt, and the information that I have is that last time Labor proposed to upset the enterprise agreement system, analysis by Deloitte Access Economics showed that the policy that you're referring to, the same job, same pay policy, would cost 6,004 jobs every year and $15.3 billion in lost economic activity. In the coal sector, modelling shows 2,300 jobs lost every year and $5.8 billion in lost economic activity. They're not statistics that I would have thought you'd be pleased to hear about. Senator Pratt, in terms of the statistics, I mean, as I've said, Mr Hare has explained to you the statistics and the basis for them. I've taken you through the trends in labour hire, stable over the last decade at less than 2%, 1.1% of employees in August 2020, a high in 2011 of 1.5%, a low in August 2020, as I've referred to, of 1.1%. I just don't know how much further we can assist you.
Minister, do you see for workplaces that have seen an increasing use of labour hire that replace jobs that were once permanent to be a problem. Labour hire is by very nature not permanent. How do you characterise the permanence, the access to permanent work?
I don't make a habit of this, but can I just, for a point of clarification, I don't think that's correct, Senator Pratt, that labour hire is by definition not permanent. There are people in labour hire companies that do fill or have permanent roles, but I just intervening there given my knowledge of the industry. But Minister, did you have an answer to that
Mr Hare
question?
said he'll respond.
So,
Well, you'd be more a subcontractor for another company if you were permanent, but anyway. Mr Hare?
So my understanding is indeed that labour hire does include a range of employment statuses, including ongoing staff as well as casual. In relation to the use of labour hire, that is the ability that a business has to decide whether they're going to self-employ workers or whether they're going to contract workers through labour hire, whether they're going to have a core team of workers themselves and then move in and out in terms of peak load and other issues with labour hire. So it is a flexibility that we are seeing employers use, and I suppose that's part of the process for them in terms of making sure that their businesses remain viable, and they have a look at how they're going. So, given that that it operates within the framework that's allowed within the Fair Work Act, and given the important flexibility that it provides, it is a very important part of the economy. Notwithstanding that it's a relatively small part of the economy, it is also a very important part of the economy in terms of allowing people to bring in a workforce when they need workforce on a non-ongoing basis, or to deal with peaks in workload, etc. So it does have a very valuable part of the employment framework.
Can I ask, Minister, are you aware that the Minerals Council told the Job Security Committee that the pay gap between labour hire casuals and directly employed workers in the mining sector is some 24%?
So the figures that I have for mining, for casual employees, for direct hire is $50.80, and employees paid by labour hire firm is $47.70.
Okay, well, this is the figure from the Minerals Council in their evidence to the committee, the Job Security Committee, and it's not a report, it's just a figure they cited to the committee.
So the source for my data is provided by the ABS Characteristics of Employment, August 2021.
And I note, Mr Hare, if you're saying that, labour hire is useful in particular when there are peaks in employment, normally a peak in employment kind of means you've got increased demand, etc. I cannot see the reason for the disparity in wages there, but I think we've exhausted what we can get out of this topic, and I'll ask Senator Sheldon if he wants to pick up the next bracket.
Finally, we agree on something. Senator Sheldon, did you have...
Good. Thanks, Chair. From the most recent annual report, I note that part of the charter of your charter at the Industrial Relations Division within Attorney General's Department is that you provide advice to government on emerging issues and legislative options for reform. Is that correct?
Yes, Senator.
What do you see as the current emerging issues in industrial relations?
So we have talked about many of those issues today. So the gig economy is absolutely one of them, which is why we're doing the work around the data collection. We're aware of the issue in terms of the payment differential and independent contractor arrangements, which are also caught up in both the gig economy and labour hire. Also, we would regard people being able to be paid properly is certainly a significant issue in terms of making sure that businesses know what they're meant to be paying and that they pay it. So they're probably the three critical ones.
So the issue of job insecurity is not one of the priorities?
Sorry, I was probably wrapping that up into both the labour hire and gig economy. So
have you included
casuals certainly
substantial? Thank you. Sorry, Mr. Hare, I didn't mean to cut you off.
No.
The part-time. Have you considered the evidence that was received from the job security inquiry was that that many part-time workers, particularly in feminised industries and particularly in the care industry, the part-time provisions mean that their jobs are insecure. The nature of the work, from zero contracts to minimum hours, 1 week people working 20, 30, 40 hours, and in normal times the employer arbitrarily just taking them back to the minimum contract on a following week, and there was numerous individuals that gave that evidence, including the union.
Certainly, I think that fits into that broad category of people with, well, it's very similar to casual in terms of they have no ongoing right to employment, so they are able to be taken back to low hours. So yes, I'm certainly aware of the evidence provided.
So thank you. Can you just step me through what, with the answers that you've given me on the priorities, how you propose to address the emerging issues?
So Senator, that's advice that I'd give to the government. And that would be a matter for the government to determine their views on that advice. So I'm not going to walk you through policy advice.
That's fine, Mr. Hare. Senator Cash, Minister Cash.
So the question's already, Senator Sheldon.
It was just outlined what the priorities were for the department on giving advice. The department understandably said that it's a matter for government. So I'm just pointing, there was a list of examples, and Mr. Hare can go through that list again if that's
many of
some
the topics
assistance.
that we've canvassed today continue to be the topics that we look at. I mean, the gig economy in particular, as we've spoken about at many estimates now, the ABS and the data collection, the issue of labour hire, continuing to monitor that issue in particular. I think the work that we did in relation to, casual employment, etc., and the changes that we've been able to make to actually ensure that people are offered that ability to convert over to the more permanent forms of employment. I think they were very, very good changes. The simplicity of the system, obviously, and I mean, Senator Roberts raised that today. And certainly that was one thing that we could do to simplify the system. It sounds like a small change, but putting in that definition of casual was an incredibly important one, and allowing that conversion to a more permanent type of employment, but also the ongoing educative role of the Fair Work Commission, ensuring that both employees and employers are properly aware in the employee's case of their rights and the employer's case of their responsibilities under the Fair Work Act. The ongoing work that we do, and in particular looking at the Boland Review and the implementation, I think when I first came into the portfolio, I sat down with the states and territories and we managed to get agreement in relation to all of the recommendations of the Boland Review, which I think was a very good step forward. So that ongoing monitoring of work health and safety and the model work health and safety laws is just something that you continue to do.
So I just want to go to
Respect at work as well. Sorry, the respect at work that we also did discuss this morning, that ongoing implementation of the Respect at Work report.
Thank you. Just this part-time provision we just talked about just then. What's the government pursuing to deal with the issues of casualisation and part-time work where people haven't got job security? So what is the proposed?
I'll get Mr Hare too.
I think he just threw it back to you before.
No, I'm just going to get Mr Hare to
So
respond.
in terms of the policy decisions already taken,
no, I'm not asking about the policy decisions taken. What is the proposed steps taking to emerge that are emerging? How are you dealing with those issues, these emerging issues?
So, Senator,
and the policy questions, obviously, to the Minister.
So there are some things there where I can talk you through where we're up to with the process as opposed to any of the policy advice. So we've already talked about the gig economy and the work that we're doing in terms of looking at the data and
yes,
trying
thank
to
you.
improve
I've got
that data. Of course, we will consider all the parliamentary reports on the subject matter as well. We're also, in terms of casual and ongoing work, we continue to monitor that, but we do note that there is a reduction there. We also have a review of the provisions within the Act that needs to be undertaken, and of course that will inform our policy advice to government, and that directly goes to casuals. In relation to the part-time arrangements, I do note that I think it was the November figures, we saw the lowest level of underemployment reported since about 2008. So fewer people identifying they want further work, but more broadly that context of people wanting more work is still sitting there within the economy, while lower than before. That's a complex interaction in terms of the strength of the economy, because clearly the strength of the economy has a direct relationship to the level of employment.
And that's right. And when you look, Senator Sheldon, at the impact of COVID over the last 2 years, when you look at where Treasury had anticipated that unemployment would go, when you look at where unemployment is today, and in particular, I think it was the comments of Mr Jim Chalmers that the test of the Morrison government would be the level of unemployment as we move towards where we're going now with the election, and it's at 4.2%. But just to pick up on what Mr Hare has said in relation to, in particular, the rate of casual employees, we talk about this every estimates, and I will again reiterate it, it's remained stable at around 25% for more than 2 decades. And that is leading into the pandemic. It is currently at 22.9%. This is now lower than what it was before COVID-19, which was around, I think it was 24.1%, so it's now lower. It's lower than what it was in 1996, relevant obviously because that was under Paul Keating when it was 24.4%. I think you'd also be aware that the greatest jump in casual employment on record took place between 1988 and 1996, and again relevant because it was under the Hawke and Keating Labor governments, from 18.2% to 24.4%. So when you look at the data, and I could take you through this part-time, the independent contractors, the labour hire, the fixed-term contracts, when you look at the data, it's not supporting where you want to go. And I think the fact that the Labor Party fought tooth and nail on the floor of the Senate against the changes that we did successfully legislate in relation to casual employment, giving them that ability to actually convert over to another more permanent form of work, actually for the first time inserting a definition of casual into the Fair Work Act. Again, Senator Sheldon, I think both the statistics, the unemployment level and the policy actions that we've taken do show that the settings that we've put in place are having the right effect.
Minister, thank you for that. I just want to go through some. You've put a series of facts, alleged facts, about what's happening in regards to job insecurity, but you're aware that the figures for working for multiple jobs has increased, and it's actually at the highest recorded rate
I don't think that's correct, Senator.
I think we've got Ms Wang might be able to.
I think there's been a reduction in the order of about 100,000 people working multiple
The June
jobs.
2021 ABS figures show that there are now 867,900 Australians working multiple jobs.
I think that we might
The
have
highest
more
number.
recent figures,
I haven't
Senator.
finished the question. I haven't finished the question. The highest number since the ABS began tracking secondary jobs in 1994. That in 2018, the proportion of Australians working in permanent full-time jobs with paid leave entitlements, which was unearthed by the Senate Job Security Inquiry, fell below 50% for the first time. The number of labour hire jobs in Australia has increased from 584,312 in 2012 to 797,710 in 2019, a 37% increase in 7 years, and that was based on the figures that employers had provided. The proportion of Australians in permanent part-time employment has increased from 10% in 1996 to 32% in 2018, and particularly the lack of job security for care workers, which is a predominantly, as we're aware, feminised industry. And of course, Uber in less than 10 years in Australia has become the second largest employer in the country. And it does paint a picture of job insecurity, doesn't it?
So if I might, Senator, the September 21 figures for rate of multiple job holdings was 5.8%, or 767,000, down from the 832,000 in June 2021. That rate has remained broadly steady between 5 and 6% since 1994. The peak was 6.2%. So I think in September 21, 6.1% of all jobs were secondary jobs, down from the series high of 6.4% in June 2021. In relation to people identifying themselves as underemployed, that has fallen dramatically, and it's at its lowest level since 2008. In relation to part-time employment, yes, that has grown. That is again an important flexibility where people are happy with their level of part-time work. It is a positive that people are able to avail themselves of part-time work. And as I said before, where people want more work, of course, that would be better if they could access that work, but that's largely dependent on the economy. I'd also note that in terms of unemployment at 4.2%, again, that's the lowest figures since 2008.
I might suggest that you look at the Job Security Inquiry report about and the effect on feminised industries and the care industry, because both a number of employers and employer associations said that there was no practical reason why, they couldn't tell us why, that they were not giving people permanent work, more regular hours in the terms of their contract of part-time. And as I get back to before, on zero contracts, trying to get a home loan is pretty damn hard, regardless of the fact that you're doing 20 or 30 hours a week, and sometimes substantially more than 40. So that evidence was in there. It was very clear there's a failing in the part-time provision and how part-time's worked. And no wonder we've got a growth of 10%. You can treat permanents as casuals. That's why we've got the problem with the system.
So, Senator, look, I absolutely acknowledge the issues associated with highly feminised workforces, and if they're not, and if they're, and I think we saw the figures today that there's about 53 to 54% of casual workers are women, compared to about 47% of men. So it certainly is something that we're conscious of. We're also conscious that the award, I think, in the care industries, I think it might be the aged care industry in particular, has a slightly uncommon provision around allowing the use of the 0 hours. So that's certainly something that I'd encourage parties to tackle at the Fair Work Commission, who do set the awards.
In relation to why employers are saying they're not sure why they're using those arrangements, I mean, I would have thought it'd be important that all businesses be thinking about their employment arrangements and why they're using them, and if they believe it's possible to employ permanent people on an ongoing basis, and it makes sense to them and their workers, and they should certainly look at that.
Professor Tony Lamartine from the Institute for Health Transformation at Deakin University shared some very concerning recent academic studies from Europe with the job security inquiry. Those studies linked job insecurity to a 30% elevated risk of coronary heart disease and a 60% elevated risk of depression. The Australian Medical Association echoed those concerns in their submission to the Job Security Committee. The AMA said, and I quote, "Job insecurity has a range of well-evidenced effects on individuals' health, including stress and anxiety resulting from uncertainty about future work, an increased likelihood of psychological distress and psychiatric morbidity, a higher risk of coronary heart disease, and higher incidence of high cholesterol and hypertension." Is the department aware of these links, and what's the department doing about them?
Look, I'm aware of some of the work. Probably the best characterisation of those would be to think of them as psychosocial risks, and that's something that the Work Health and Safety Framework already covers. The Safe Work Australia are in the process of developing guidelines around psychosocial hazards, and I mentioned that previously today, including in particular in relation to sexual harassment. So it's certainly something that employers need to have a think about and work with their employees about in terms of making sure their workplaces are safe. That's a responsibility that employers have and share with their employees.
Mr. Here, look, I have no doubt some employers share that with their employees. The problem is that not enough employers share that with their employees, and there isn't a fair or reasonable playing field in many of these situations that are put forward. If one company is exploiting the system or taking advantage of it or is gaming it, then that puts unfair practice pressure on companies they compete in the same market with.
Look, I think it's also important to note, so I think the initial set of research you mentioned was overseas research, and I think it's fair to say that Australia's casual arrangements are quite unique, including the loading, etc. And previously we've talked about actually how casual arrangements are often used by young people for the flexibility that they offer. So I don't think we should presume automatically that somebody being casual is a psychosocial risk.
I didn't say that.
I didn't suggest you said that. I just said I don't think we should assume that.
I said, and I also included, rightly as I pointed out, was a European study, and also the Australian Medical Association echoed their concerns in their submission about job security and the consequences. Has the department considered any policy options to create, or the minister, any policy options to create incentives for employers to employ workers on a permanent basis? At
this point in time, I'm not sure that we've looked at incentives. What we've looked at is providing a clear pathway for those employees who want to move to ongoing employment, if they've got a pattern of work that supports that, for that to be made, an offer to be made to them. So in terms of actual incentives, no, there's no current work underway in terms of that process. What we've been trying to be clear about is what the definition of a casual employee is, and providing a clear pathway for people to move from casual to permanent employment where they meet the criteria and they wish to do so. But again, I'd note that a review of the Act is required, and we will be looking at a range of issues when we commence that review shortly after the end of March.
Just my final question from me. So that, just take from that the 90% of workers that are part-time in the aged care industry, many of whom given evidence about the incapacity to become permanent hours, more regular hours, that you're leaving it to the employers that are already inflicting those unsafe conditions. So unsafe as far as the Australian Medical Association is concerned, and also economically
So, Senator,
vulnerable.
I made a number of comments there. I think the first comment I made there was, my understanding is the Aged Care Award has some unusual provisions in it, including allowing zero-hour contracts, zero-hour arrangements. And certainly I think the parties should have a look at that when they're having a look at the award. If it's unusual, I think it's certainly worthwhile the parties having a look at that and seeing it's worth going. My comment in relation to employers should have a look at it was, I think, in response to your comment that employers had said they weren't sure why they were doing it. So my comment to that was they should certainly think about it if they're not sure why they're doing it. And no, I don't think it's entirely up to the employers alone. Clearly, the employees and or their representatives should be participating in processes if they believe there's a significant issue in the industry. Certainly I'm aware of the HSU and others and the matters they have before the Commission at the moment in terms of pay levels. So I'm very conscious that there is a range of work occurring at the moment in relation to the aged care system.
And they're also, on the Deputy Secretary, there has been discussions over a period of time with employers about making sure that there is appropriate hours in transition to full-time hours for those that wish to do it and it's practical within the system, but the employers have objected to it. That's why I'm raising what consideration has the department given other than give it back to the people and at least one party that's failing to reach an arrangement that's suitable, if not both parties.
So, again, that's something that we would consider in terms of any negotiations the parties might be having in terms of enterprise agreements. These are things that could be dealt with within an enterprise agreement, whether they're having a look at the award itself and whether they're seeking changes to the award. These arrangements are...
Mr Hare, it's not working. What you're proposing is in place now and it's not working. As long as it's containing to the question that I raised.
Yeah, it is.
And not some other stat about something else that's got nothing to do with what I'm talking about?
I'm talking about a part-time provisions in the award, if I assume that's what we're talking about.
I'm talking about the caring industry and I'm talking about aged care in particular.
Yes, that's I understand you're talking about.
Thank you.
The part-time provisions in the award is as any award provisions. If you work beyond guaranteed hours, you've got an overtime pay. And then awards usually have a minimum guaranteed hours or minimum engagement. I understand in those aged care specific awards that the minimum engagement hours is between 2 to 3 hours. And when employer is being asked to work beyond the guaranteed hours, in your case, and the cases you suggest is 0.
Ms. Wang, if it helps, I'm already aware of
entitled to overtime, but the employer, I understand the employees may agree to it and waive the overtime.
I'm very keen to get to the ABCC, so I am aware of that.
So the most recent case I would want to draw your attention to...
Can you take it on notice then, and we can just, might be easier, otherwise we're just getting information we're already aware of.
The other comment I would make is that there is a regulatory body in place and policy around health, probably sits with the Department of Health. In terms of the framework arrangements, these matters are generally left to the Fair Work Commission and or the enterprise bargaining process in terms of sorting that out. There is no...
So when the system's broken, we don't do anything about it?
That's not what I said, Senator, but certainly the employment frameworks that are allowed within the Fair Work Act and the common law include part-time arrangements and they include casual arrangements.
if there is a case for a specific change to that or difference based on the industry, I think that would have to be taken up by the area with policy responsibility for that. In terms of the broad framework, though, those arrangements are important arrangements. They're important arrangements for employees and employers. Unless there's a specific case made on an industry-specific basis, we'd need to be very cautious about making any changes there.
Mr. Here, in light of the recommendations from the Royal Commission into Aged Care, and specifically looking at this question of part-time, what actions are you taking to actually enact that, to take it forward, and particularly in the case of the aged care industry, to deal with those particular concerns which are enterprise-based, having a detrimental effect on those working in the aged care industry and those receiving services in the aged care industries?
So, Senator, the agency with the policy responsibility for that is Department of Health. They're the agency who are doing that. If there's framework,
but it cuts across industrial relations matters. I'm asking you, what are you doing about the industrial relations matters? And you're saying leave it to the parties for a broken system.
So, Senator, as I said, we deal with framework issues, and as I said previously, there is nothing inherently wrong with part-time arrangements. There is nothing inherently wrong with casual arrangements. So at this point, we don't believe there's a framework issue there. Of course, we stay in contact.
So the Royal Commission's got it wrong, have they?
Of course, we stay in a framework sense, Senator, is what I clearly said. In terms of the recommendations from the Aged Care Royal Commission, we stay in close contact with Department of Health and work with them in terms of any policy views they might have.
Have you put is there any policy views that you've put regarding part-time employment that was highlighted in the Royal Commission that need to be changed?
Not from a framework perspective, Senator. That would be a matter for Health in terms of whether they believe that's appropriate within those workplaces.
But you're sort of, so you haven't put any proposal forward for any industrial relations reform that should actually occur in that area to meet the requirements that's been handed from the Royal Commission to Aged Care. That's what I understand.
Look, Senator, I'll go and refresh my understanding of the recommendations, but I don't believe the recommendations suggested broader changes to the industrial relations framework. What it did suggest was that the government engage with both employers and employees, representatives, to have a look at what could be done to improve outcomes in the aged care industry. So it was quite targeted to the aged care industry.
Has your department entered any of the discussions with the parties regarding changes to the aged care industry that's recommended
Senator,
for government to actually talk to the parties?
Senator, as I've said before, Department of Health are the lead agency on that, but we remain in contact with them.
Okay, now look, just a quick administrative point. I believe in discussions was it roughly 30 minutes of questioning or so to go, so we might, for the department that is, so we might seek to extend the afternoon break if that's okay with broadcasting. I'm getting a nod. And so hopefully we can be done with the department by afternoon tea, and then we can move on to the ABCC after the break. Senator Pratt.
Thank you. Has there been any assessment of the impact of changes made to the Corporations Act that happened in 2019 with regards to misuse of the Fair Entitlements Guarantee?
Senator, I'm not aware that there's been any changes to the Corporations Act. My understanding is that there was consultation undertaken by the Department of Treasury, but those questions are best put to Treasury.
Well, it's Treasury that administers the FEG, or is it this department?
This department administers FEG, but my understanding was the question you asked was specifically about changes to the Corporations Act, which is administered by Treasury.
Well, the Corporations Act was amended essentially to say that you can't contract out or restructure out of your obligation to provide entitlements. So have you done any assessment in relation to the relationship between the use of the Fair Entitlements Guarantee, which is this department's jurisdiction, and the relationship back to the Corporations Act?
So, Senator, as Mr Hare said, provisions are administered by Treasury. However, the particular provision you're talking about, those amendments to Part 58A, do give rights to take action to various parties, and we, as part of it, the FEG recovery program, which, as you may know, has as its aim to reduce the overall net outlay of FEG, have funded investigations or recovery action by liquidators in 8 matters under those provisions.
Okay, so can I ask, in dollar terms, how much has been recovered in entitlements from entities in a corporate group or connected this financial year to date, last financial year, and in the previous financial year?
I'll see if Mr Carr is able to answer that in relation to the FEG recovery program.
Hello, Senator. Henry Carr, Branch Manager of the Recovery and Litigation Branch. Would you repeat your question? I think it was in particular recoveries from corporate groups in respect of those revised laws. I don't have an answer for you. I may be able to take that on notice if you're willing.
Okay, well, I know that, well, can you tell me how much, I know the government has given out under FEG money to ensure people have some entitlements when a corporation goes, or a company or an employer goes belly up. How much have you recovered from employers to cover those entitlements?
Through the FEG recovery program, the best way to look at it, Senator, is over the period of the program from its inception in the 2015-16 financial year. So across all of our matters, we've recovered $216.4 million.
Okay. So can I ask this financial year, last financial year and the previous financial year?
Again, Senator, I'm giving you the numbers for the FEG recovery program. There's also recoveries made that are recovered through the ordinary operation of the winding up.
Yeah,
So-
that's not what I'm asking. I'm asking in relation to, because if it goes through the winding up, then it might go to the employee directly, or it might come back not through this your program. Can I ask specifically in relation to your own recovery, what has been recovered last financial year, the previous financial year, and this financial year to date?
Yes, Senator. I'm unable to give you those numbers, Senator, but I'd be happy to
that's fine, if
provide
you can take
them
them on
notice. I'm just a little
notice.
bit confused whether you're connecting to the first question you asked, because there's a couple of concepts here.
Okay, so I was going to further ask about what was recovered by liquidators for FEG, as well as reports of. So I don't know if that assists. If you're able to tell me what the figures are.
Yeah. Senator, I'd like to take it on notice, but if I can just inquire so we can give you exactly what you're asking, there's a couple of concepts here. The concept that you introduced at the beginning around the law reforms and our recovery based upon those reforms is complex because often our investigations and liaisons with liquidators doesn't conclude with a court case based upon those provisions, but often it's a sophisticated back and forth where we would attempt to identify and agree the amount of the recovery. So what I don't have off the cuff, and I'm not sure I ever will have, is the ability after that, again, I don't want to overplay it as a sophisticated discussion with practitioners, then ultimately a recovery is made. And there's also a difference between the recovery program more broadly.
No, and I understand that some people might get their entitlements recovered and never end up with FEG, and others will. So I understand that it is different, and I guess it would be good if we can pin down that data at some point in the future.
So
when we know.
Understand what figures are you looking at? So what figures are you requesting, just so we can get the right... So you're not looking for just the general figures, like you're not looking for example, claims received, payments made. That's not what you're looking for.
So you have your own recovery program, and that's what I was asking about rather than liquidators.
So does that assist at all, Mr Carr?
Yes, I think so. I can give you the numbers for the FEG recovery program. So that's GEARS and FEG combined together. And in 2021, $42.7 million. In 1920, $132.4 million. And in the 18-19 year, $47.1 million.
Okay,
but
and
if you're
that represents money that you claim back after the government had already paid it out in...
Correct, Senator.
Yeah, no, that's fine.
Because
I just wanted to clarify that I have that correct.
Because it's a safety net scheme of last resort.
No, I understand what the scheme does. Can I ask how many reports of fraud have been reported through the FEG hotline? Thank you, Mr Carr. That was helpful. I do understand that, when you're able to get money back from another entity, it does kind of demonstrate it might not have been the last resort that it's supposed to be. So thank you for...
I think I have to take that question on notice.
Okay, so if we've got between 132 one year and 42 million another, and that's recovery from associated companies, that's a fair bit of fraud against the FEG scheme.
Do you want to go, Greg?
It wouldn't. It's not. That's why I was taking on notice.
Well, I'm trying to work out what is recovered by a liquidator, and some people might just hand money back because they know they have to.
Under the FEG recovery program that Mr Carr was just talking about, we will fund liquidators where there exists a right of action. We believe, Senator. The most common rights of action would be, where we recover money, would be if we believe the company was trading whilst insolvent. Another common right of action would be where we believe preferential payments have been made which should have been in the general money available for distribution in liquidation. I wouldn't say that involves fraud. I mean, it's a different concept.
Well, you're not supposed to trade insolvent.
No, but it is a... That's true, and we, of course, seek to recover money where it's happened. Of course, it's often a very hotly contested issue as to the date of solvency, so as compared to fraud, which is a very deliberate act. The other point I would make is, if we believe there is evidence of behaviour like deliberate phoenixing, for example, or other behaviour in breach of directors' duties, for example, then we would share that information as part of the anti-phoenixing task force with bodies such as ASIC and the ATO for appropriate action in relation to those directors. I did say it's the final thing, but I might say one other thing which is relevant, please, Senator. We were speaking earlier about those Part 5.8A amendments. At the same time, there were some other amendments, including in relation to directors who have been directors of a company that's gone into liquidation where FEG has been called on and there hasn't been a substantial dividend more than once in 7 years. And we hand the details of any directors who we believe fit that description onto ASIC, and then ASIC can take action such as seeking to have them disqualified as directors, which they have done on a number of occasions.
Okay, thank you. I might just seek some advice about the extent to which I should push for more detail or whether I can put the specific data requests on notice. But can I, while getting that advice, I'd like to refer to a matter that went before the AAT. It was the matter of Steel Go Australia Pty Limited. It was insolvent and the department refused to pay a particular worker up to $23,600 in lost entitlements despite his eligibility. Is the department aware of that matter?
I don't have details with me, Senator, but if you have questions you'd like to place on notice, we'd seek to answer them. What I would say, though, is we administer the scheme according to the Act to the best of our ability. There's both internal reviews and then claimants who are unhappy with the outcome can seek review by the AAT.
Okay. All right, well, I'll take you to the details. This has gone before the AAT, but it does have deep policy implications because we've been talking about the extent to which a company might trade insolvent or some of the other examples where a company can't even, which we talked about earlier today, a company can't even restructure without reverting to the award because it can't afford to pay out the accumulated entitlements. So there are many interrelated things. So the FEG made a decision to deny someone who had lost their entitlements a payment because the company had failed to make their contributions to the Victorian Entitlements Fund, Incolink.
Is it a superannuation issue, Senator?
No, these are accumulated entitlements. Incolink is a fund not for super. It is like the building industry and other people use. Yes, it's a redundancy, so it's supposed to cover your sick leave, your annual leave and your accumulated entitlements.
Yeah.
So isn't it common sense that when an insolvent company hadn't made those contributions, that it strengthens a worker's case to access the FEG?
So this fact situation rings a bell. Is this a matter where a body was meant to have made payments, and the FEG, in assessing it, said, well, you actually don't have that entitlement because it's owing to you from that body, but it turned out the employer hadn't made the payment to the body? I'm vaguely familiar with it, Senator, but I still would have to take on notice any questions.
Okay, it's just that I can't see the difference between a company that says in its award, we will pay this money to Incolink or some other fund to accumulate that so that should you be made redundant or we restructure or we go insolvent, that those entitlements are there, versus another company who has not kept that money internally ready to give out under the same circumstances. I don't understand the difference. FEG is there for the company that didn't make the internal provision, but apparently not there for the company and therefore the workers where they didn't make those contributions to Incolink or another external party.
And from memory, Senator, that matters before the Administrative Appeals Tribunal?
Yes.
Is that right?
The Administrative Appeals Tribunal characterised it as studied ambiguity on behalf of the department.
What I would say, Senator, is the department is very keen to get the right money to the right person as quickly as possible in administering FEG. We take very seriously our obligation to administer the Act for the benefit, it's beneficial legislation, for the benefit of someone who's often in a very distressed situation as best as we can. We balance that against our obligation to administer the legislation according to its terms and to fulfil all of our obligations with public money. So, as I said, I can take any questions of detail on notice and provide a response, but I really do want to assure you that there's no situation, administration of FEG, of somehow taking a really pedantic or approach to the legislation.
I would have thought it should have been a simple determination in favour of the worker rather than.
I'll get Mr. Hare to jump in here as well.
So, as with Mr. Manning, I'm aware of the broad facts and also the statement from the member of the AAT. What I would say is, look, the team. Mr. Manning's characterisation of the team and their approach, I think, is very accurate. They know the importance of people getting their entitlements in these circumstances, but they do balance that against the legislation. In this case, it appears they've interpreted that incorrectly. That's subject to having a look at the decision and determining whether we want to appeal that or not because of the legislation. There's no intent about doing the employee out, but we do actually have to have a look at the legislation. But subject to us deciding that there is no basis for appeal, we will learn from that and we will make sure that that's
Thank you.
dealt with.
I appreciate that answer.
And I was just going to say, I was reminded while Mr. Hare was providing that answer that we didn't appeal the decision, so we accepted it and we'll review our operational practices accordingly.
Okay. Can I ask if you've got any awareness of any similar cases, because there's been a determination by the AAT in this case, have you double-checked to make sure that you haven't made decisions that would have seen FEG deny payment to workers under similar circumstances?
To take that on notice, it was quite recent, so if that's occurring,
that's
it
fine.
will be occurring now.
But you're not aware of any?
No, I'm not, Senator, but
You're
we'll
not?
take on notice.
Okay. And you're not either, Mr. Hare?
No, Senator.
Okay. I'm now going to ask about Avato. The government sought the services of Norton Rose Fulbright to advise on that matter. What was the cost of using them? And am I correct in saying that the Avato matter has now been finalised?
Senator, I don't have the number with me for the cost of engaging Norton Rose.
Okay, that's fine. I'll take that on notice. Are you able to tell us if it has been finalised?
It's finalised, I believe, in respect of the claims. I'll just check with Sue. That's correct. And in terms of the recovery, Senator, we're still in liaison with the liquidators, and so the recovery and the winding up isn't finalised.
Okay. How many applications were received and were any applications rejected?
Sue Saunders, Assistant Secretary of the Fair Entitlements Guarantee Claims Branch. For the Avato Group, the department received 205 claims from former employees, and all 205 claims were paid.
Can I ask what the difference was between their entitlement under FEG and what their entitlement would have been as an accumulated entitlement under the EBA?
I can't answer that question in particular. What I can tell you is that under the FEG scheme we paid $16.4 million to the claimants, and for the purposes of how we calculated those entitlements, the redundancy amounts were calculated based on the 2020 enterprise agreement, which was the agreement that we determined was the governing instrument for determining their entitlements. The redundancy pay that was paid to employees was $10.5 million. We're aware that the distinction between the previous enterprise agreement and the 2020 enterprise agreement was a difference of The previous entitlement was 4 weeks per year of service uncapped, and under the 2020 EA it was 2 weeks per year of service capped at 52 weeks.
Thank you, and it's very good of you to be able to cite that data. Can I ask if Avato is able to use the FEG to restructure its work? I know we've touched on this earlier. We know that there's an insolvent entity, but there's also an entity for which it sounds like you're still trying to recover some monies.
I think that we'll be trying to recover monies from the insolvent entity.
Okay,
Senator.
that's fine. But there are associated entities, as I understand it. Avato essentially split itself up and had an insolvent entity. In splitting up, if the entity that survives is able to use FEG to cut off those accumulated entitlements and use the scheme for the government to meet those entitlements while it restructures. So the department, the Assistant Secretary of the Fair Entitlements Guarantee Branch has themselves said this would set a precedent for restructuring to access FEG, a fundamental shift from FEG as a scheme of last resort to a source of restructuring finance for struggling businesses. And this would be inconsistent with the government's Treasury-led business support scheme process, which has already considered Avato and at that time declined to assist. Can I ask now, does the government still consider what happened at Avato to be an appropriate use of the Fair Entitlements Guarantee?
From our perspective, we provided advice to the then Attorney General. I think as part of that and in discussions here, Senator, we've acknowledged it's a difficult issue. It's a complex issue. The claim, as I understood it by Avato, was that the whole company would go under if they needed to start paying out this level of redundancy. And we were then faced with this prospect of over 1,000 employees, I think. 1,200.
Up to 1,200.
Up to 1,200 employees being made redundant. It was an innovative use of
That's one way to
FEG.
characterise it.
I think that may have been the language we used at one point. It still remains a difficult policy question, and my apologies earlier, Senator. I thought the changes to the Corporations Act you were talking about was actually the consultation process that's still underway.
Yeah, no, that's fine. The Corporations Act change was quite symbolic, but I don't know that it...
Well, but there's actually a proposal to look further at schemes of arrangement, which is what this is, Avato schemes of arrangement. So there's actually a consultation process that Treasury are leading that we've been engaged in to actually look about how do we want to control these in the future. So that policy work hasn't finalised, as my understanding. It's still sitting within Treasury, but we remain very interested parties to it to understand actually where this ends. Because
Can I ask in that context, and I understand that you've answered that very well, can I ask in that context, when we were talking about a company being able to apply to the Fair Work Commission to cancel the EBA and revert to the award, and the impact on the accrued entitlements that would have, are you factoring that into your discussions in regard to schemes of arrangement?
Noting that I don't think that was the arrangement in Avato, we are concerned to make sure that there is appropriate use of FEG and that it is a genuine use of last resort. But at the same time, in terms of making sure that we don't see large-scale disengagement from work or dislocation from work for employees, it is a difficult policy thing. So we are certainly conscious of a range of factors in our engagement with Treasury.
Okay, are you aware of what FEG looks like as a baseline when you're considering, when you change someone, if the Fair Work Commission, you said you can go anywhere between the award and the EBA, and that will impact the accrued entitlements.
Yes.
Are you aware of where FEG sits in the middle of that? Because there doesn't seem to be any relationship of what the Fair Work Commission might do that says these are your new entitlements versus what you would get if the corporation went insolvent.
So we're very aware of the arrangements within FEG, or the parameters within FEG, that they've been set as a cap, and they've been, my understanding is they've been set as a cap on the basis of what's reasonable for the public purse to pay to individuals.
Yeah, I understand they're a cap, but they are also a base, based on whether some people have accrued more entitlements than that.
So that's right. So they operate as a cap in that circumstance. That we never move above what's in the employee's workplace entitlement.
Someone might have accrued less than the FEG, but you're not going to pay more than the FEG had they accrued more.
If they've accrued less than what they would have, so instead of a 4 week, so we've got a 4 week cap.
I understand. They'll get up to the cap, but what I'm interested in is the fact that it also becomes, if you like, someone might, by the Fair Work Commission, get their entitlements reduced below even the FEG to be, even when it's an ongoing concern, and I'm very worried about that. Can I ask why the Minister did not accept the advice of this official and intervene before the courts to prevent that precedent? And can I ask what steps the government has taken to prevent further abuse of the FEG? Are you just relying on that future consultation, that existing consultation process?
So I can't answer for what's in the Minister's mind. We provided our advice. My understanding is you've got a copy of that advice. The Minister will consider a range of factors, and in that case, he made his decision. In relation to the work that we are doing, yes, predominantly we're working with Treasury in terms of the schemes of arrangements discussions. My understanding is that if they haven't concluded already, they will shortly in terms of the consultation process. And we will, of course, be engaged with any, in providing our Minister our views on the policy outcomes from that, so that our Minister can be fully informed in the discussions about any future legislation. It's something, as I've said before, it's a difficult balancing act, this one.
Okay, so in that context, the documents we have under FOI attached to the email includes a report from external legal counsel that said the EBA termination application and relevant associated documents and orders made by the Industrial Court, which will enable FEG to properly understand how the company has, as is said, sought to manage its workforce obligations. Does the government have concerns that this case has established that threatening to terminate an EBA can be classified as seeking to manage its workforce obligations when seeking to access FEG for a restructure?
So if I recollect the advice correctly, our recommendation from the department was that we should test that arrangement. As I said at that point, the Minister reached their own views on what was the appropriate course of action, and we didn't intervene. But that's certainly trying to make sure that the balance between enabling viable aspects of businesses to continue to employ people versus people inappropriately accessing FEG is very front of mind for us.
The only aspect I'd add there that's relevant, the Department administers the legislation according to its terms, which is as a scheme of last resort. So our position is always it should be a scheme of last resort. The circumstances you're outlining in relation to the EA were as I understand it, I wasn't involved, but sometime before the liquidation of the company. So the department wouldn't have been involved from a FEG perspective at that time. But as I said, always would have been saying
I can kind of accept
FEG
that,
is a
bar
scheme
the
of last
fact that
resort.
to pay out the entitlements would have bankrupted the company. So
There was evidence before the court that was the case.
You can't separate the
No, but
two.
So that, I mean, that's exactly...
Sorry, Mr. Heck.
All right,
We've been going an extra 35 minutes since we
Okay.
were sent a run-up, so you think you can finish soon? Because otherwise I'm going to have to take a break.
Well, we'll perhaps come back to migrant workers.
Or do we want to take a break now?
Let me try and finish it now.
Okay.
Why did the department reject an offer of a briefing when the department was first approached by Avato in relation to this matter?
Sorry, could you ask the question again? I just want to make sure I got...
The department was offered a briefing on the scheme months before the legal action, but the department rejected that.
Offered a briefing by Avato?
Avato.
Yeah, okay.
Yeah.
Look, I need to go back and check, but some things that we would normally be worried about in those circumstances is whether they're trying to gauge our support for such an approach. So we would be cautious about that, but I will take the rest of it on.
I mean, the department, I understand, had a teleconference with Avato's legal representatives in June 2020. But in that point, I think Avato was seeking assistance generally, and in the context of that, raised the possible consequence that if the entire company went under, there would be a call on FEG. I think those details have been released in answers to questions I noticed from previous estimates, but we could do that again if necessary.
I'll move on to asking about FEG and migrant workers. The government's asking for migrant workers to return to Australia after telling them to go home during COVID. So it seems important to Labor that when migrant workers return, that they're able to, but that they don't return to the same inequalities they had before. So may I ask Minister Stoker and the department, when will the Fair Entitlements Guarantee be extended to migrant workers?
Senator, I answered questions on this at the last estimates. That issue is still under consideration by government.
What progress has been made on that consideration since the time we last discussed it?
There's a briefing under consideration by the government. I haven't got the exact timing.
Okay, when was that
of
briefing written?
I'll have to take that on notice, Senator.
Okay.
I don't have it with
Was
me.
it before or before the last estimate?
That's what I need to take on notice, Senator.
No, that's fine. I'm just trying to be quick. We're on the same page with working through the
noting,
issues.
Senator,
You briefed the government. You said that at the last estimate. You don't know if they're responding to a new briefing, but there has not yet been a decision
That's right, and
from
I've
the
taken on
government.
notice the date of the briefing, Senator.
Can I ask, given we are seeking to invite migrant workers back to our shores, why nothing has been done to address this unconscionable inequality? We've seen migrant workers underpaid when Phoenix companies disappear or they go insolvent. Because they're not covered, it also means that the government is less motivated to go and recover their entitlements for them, because it's not structured under the same scheme because they don't have that entitlement.
And Senator, we've taken on notice the date of the briefing that's under consideration, but it's not accurate to say that nothing's happened. There has been extensive consultation on a couple of occasions within government with multiple agencies about how, if the government was to extend FEG to migrant workers, that could work in practice. The two particular complexities from administration from a FEG perspective are that the government committed to consider it for people who are working lawfully. So that would be a factor that FEG would have to take into account in administering the program, so working out how to do that. And also in the government's approval in principle of that recommendation. It said it was mindful to do so where people have been complying with their taxation obligations. So that's another factor that we've been working through with the ATO and others about how could compliance with both the visa schemes and the taxation systems work. So there's actually been quite a lot of consultation and thinking done on how that could work.
Thank you, Chair.
Thank you. Now, just confirming we no longer need the Attorney General's Department. Fantastic. Thank you very much for your evidence this morning to all officials. So we will now
Thank you, Ms Jones and Mr Manning.
We will now take our scheduled afternoon tea break. We'll return at 4:45 with the Australian Building and Construction Commission. I suspend. Welcome officials from Australian Building and Construction Commission. So, just I don't have notes here. Who is it? You, Mr. McBurney? Are you the lead witness here?
Yes.
Okay, Mr. McBurney, would you like to make an opening statement?
With the Chair's indulgence, if I could be permitted to make a very short opening statement.
Absolutely fine. Thank you.
Stephen McBurney, Australian Building and Construction Commissioner. The ABCC has recently achieved 3 key milestones that demonstrate the breadth of our work in regulating workplace relations in the building and construction industry. Since 2 December 2016, we have assessed more than 10,000 enterprise agreements for compliance with the Building Code. This has enabled contractors to tender for Commonwealth-funded building work with confidence and assurance, and it's also given workers' unions and employers certainty on their proposed arrangements. Secondly, following the ABCC's intervention, more than $1.5 million has been paid to subcontractors this financial year, and since 1 July 2019, over $9.5 million in payments have been made to building contractors following the reporting of security of payment cases to the ABCC. And finally, we have a litigation KPI of 80% in our corporate plan. The courts have delivered 19 judgments in penalty proceedings this financial year. In ABCC cases, we have won all 19 of those cases, recording a 100% success rate. In those cases, the courts have imposed over $2.1 million in penalties against a range of respondents, and this includes the ABCC's first successful age discrimination case. I welcome the committee's questions on these milestones and any other matters that may assist the committee, and I'll just note that the remaining ABCC witnesses are all based interstate and are all online and available to take any questions.
Thank you very much, Mr. McBurney, and thanks other officials for joining us. We are going to Senator Sheldon. Have a look at it.
Thank you. I'll get there.
It's okay.
We've just got ahead of ourselves. Is the ABCC aware of the recent High Court decision in the CFM and EU versus personnel contracting?
Yes, Senator.
Thank you. I understand that the worker that was involved in the personnel case was paid 25% below the award under the arrangement set up by Personnel Contracting at Hanson. What steps has the ABC taken to ensure that workers receive the appropriate back pay to meet the minimum requirements in the modern awards in light of this decision?
Senator, I'll shortly pass over to my Executive Director who runs our wages function, Madeline Jones, who's based in Perth. We're aware of the decision of the High Court. We are going to publish industry update on Thursday of this week to inform industry of that decision and its ramifications. But we have no further involvement in that case or prior knowledge of the case other than what's been reported. But we are across the decision and will take whatever action is appropriate for us. But I might just ask Ms Jones if she can supplement my answer to the question the Senator
Thank you, Mr McBurney.
Good afternoon, Senator. My name is Madeline Jones. I'm the Executive Director of Wages. The ABCC does have responsibility for recovering wages and entitlements for building workers in the construction sector. I have actually reached out to the company in question and will be meeting with them in the next couple of weeks. The ABCC is keen to ensure that the company is restructured in a manner that's consistent with the decision and that any worker who has been underpaid is duly compensated.
Have you ascertained on how many employees, has there been any communication to say how many employees are likely to be affected by the underpayments?
Not at this stage, Senator.
Has the ABCC taken any steps to ensure that personnel has not taken any money or assets out of the company since the decision?
No, not at this point. The decision came down on Thursday. I understand that the company itself is seeking its own advice and we're looking at the decision very closely.
Appreciate you looking at the decision very closely. Is that one of the things that you're monitoring, the potential for, you know, as a matter of course, the potential of personnel taking money or assets out of the company? Is that something you're monitoring or is it something you haven't considered?
No, not at this time, Senator. We're meeting with the company in the first week of March.
So if they were to take money out before the first week in March and you have a chat over coffee or whatever you might do, and they took the money out before then, there could be a problem, couldn't there?
Yes, there could.
Well, the CFMEU...
The company has given no indication that that's their intention.
You might be surprised, Ms Jones, but employers that are likely to do that won't give you that indication. That's a pretty common practice. In actual fact, I think everyone that deals with employers that are doing, illegally operating and unfairly competing with employers doing the right thing aren't likely to say, I'm a crook.
Sorry, Senator, if I may just join in, just noting that the High Court, I think, remitted the matter back down to the Federal Court for an actual look at the payment or any payment. So at this point, there isn't actually a sum determined. So there's still that bit of the process to go. So there was a decision made in terms of whether, in that case, someone had been identified as being an independent contractor was identified by the High Court as actually being an employee. But my understanding is they've remitted that back down to the Federal Court.
Thanks for that detail. It also goes back to the issue which I was asking about the assets being moved and concern about that. CFMEU, who funded and ran the litigation, estimates that the collective underpayment of wages for workers engaged by Construct alone over the last 6 years is estimated to be around $60 million. How much money has the ABCC recovered for workers who have been misclassified as independent contractors since it was established in December 2016 and for each of the financial years since then?
I'll ask Ms Jones to address you on that question, Senator.
Sure. Thank you. I think there are a few issues here. Sham contracting is used colloquially in a very general sense. However, the Fair Work Act definition is quite narrow. There are three types of relationship that the that the ABCC deals with. We look at the employer-employee relationship. In this instance, we assess whether the pay is correct, such as, is it the correct award, the correct allowances and the like. The second category is where there's a mischaracterisation of the employment relationship. So this is where the individual is engaged to work as a contractor, such as the individual offers an ABN or the contractor suggests they get one, but no one's actually turned their mind to the true nature of the relationship. No one's accusing anyone of misrepresentation or making demands, and there's a confusion about understanding what the law involves.
Sorry, Ms Jones, you're answering a question I haven't asked. What I'm actually asking is how much money has the ABCC recovered for workers who have been misclassified as independent contractors since it was re-established in December 2016 and for each financial year since then? That's what I'm asking.
Okay, so this is sort of then what I'm saying, because then there's the sham contracting definition of the Fair Work Act. We classify matters as sham contracting when they fall within that very, very narrow definition. But where matters have been mischaracterised, that in itself isn't a contravention of the Fair Work Act. Therefore, it would be a contravention of the modern award or the enterprise agreement. That then falls within the general wages collective. We don't independently classify that.
So
And
I'm
we
just,
can give you the total figures, Senator, if you would be assisted.
if you can
by
give us the total figures, and are you able to, even in your own system, be able to say about how you might break that up for each financial year for payments?
So we can give you the total figures for wage recoveries for each financial year.
You can't break it up.
We can take the question on notice. I'll defer to Ms Jones on that particular question.
Can you Ms Jones, can you break it up?
We can tell you where we've classified a matter as a sham contracting matter and that there have been monies recovered, but where the relationship has been mischaracterised, we don't separately disaggregate that.
Right. Can you, the best you can you break it up for us and just come and also the totals?
We can do that. Do
You
you
can
want
do
the
that now.
totals?
You can do that now. If it's
Yes.
helpful.
So the totals recovered since 2 December 2016 when we took on this function to 31 December 2021 is $4.796,383 for 7,826 employees. This financial year we've recovered from 1 July to 31 December $1,642,713 for 3,111 employees. Last financial year, $909,918 for 1,449 employees. 2019-20 was $1,122,140 for 1,914 employees. 2018-19 was $824,626 for 1,377 employees, and in the bridging period from 2 December 2016 to 30 June 2018 was $296,987 for 199 employees.
Thank you, Mr McBurney. In light of the fact that this is the matter that was funded by the CFMMEU involving $60 million, would it seem sensibly cautious to make sure that that company isn't moving assets or money out of their business, which as you would well know, I would hope, but by all means contradict me if you think I'm wrong, the industry is notorious for people phoenixing, short-changing contractors. It's a dire industry.
Yes, I need to make a couple of points about that, Senator. The first is not all of the employees may necessarily fall within our jurisdiction. We're aware that the Fair Work Ombudsman is also across this matter. We've become aware of the High Court decision, and as Ms Jones says, we're analysing that decision. But I would point out that we have powers under our Act, and the Fair Work Ombudsman has powers under her Act. And those powers will be used where appropriate. We can't engage on a speculative fishing expedition into whether there's a propensity or a potential, but we will act on any information we receive. And our commitment within our jurisdiction is to recover underpaid wages and recover underpaid wages in full. And our track record on that demonstrates that that's what we've done to date for the 7,826 employees we've assisted.
And thank you, Mr McBurney. I note that the substantial amount of money that unions in the construction industry have been able to obtain from companies substantially higher than that. I'm just very mindful that the $60 million, a large proportion of that is from the construction industry, which you have both responsibility for and obligations to pursue. It seems that an industry that has a notorious behaviour, and no offence, Ms Jones, but you're saying that we're going to have a chat with them and find out whether they're okay or not is not really an inquisitive way of looking at it. The company moves the assets, they don't tell the workers until the workers find out the assets have been moved. So you sort of catch up after the event. So again, I request very strongly that if you could at least make some preliminary investigation into, that the assets are still maintained, and at least communicate that with the request formally with the company.
We'll take that suggestion on board, Senator, and we'll ensure that as a responsible regulator, we work to recover the money that has now been assessed by the High Court, subject to what Mr Hare said, that there is further proceedings pending, that whatever recoveries ought to be made will be made.
How many compliance notices has the ABCC issued to code-covered entities for failure to comply with sham contracting provisions in the 2016 code?
I'll refer that question to the General Manager responsible for our building code operations, which is Janine Drennan.
Janine Drennan, National Manager, Building Code. In relation to the code, we've issued a number of compliance notices in relation to security of payment and other matters. We haven't had a reason to issue a compliance notice for sham contracting because we haven't had the requisite belief. We have conducted compliance activities in relation to sham contracting, but we haven't found any breaches by code-covered contractors.
Thank you. The 2020-21 annual report indicates that out of the 162 investigations that was conducted, only 4 or 2.4% related to sham contracting as a primary topic. In the 2019-2020 year, it was 2.5%. Given the scale of wage theft involved in sham contracting arrangements, why does the ABCC continue to treat this as a low priority?
Senator, I'll take that question. The number of investigations is reflective of the number of complaints and the number of proactive compliance activities we conduct. And I'm bound under my Act to deploy my resources in accordance with the proportion of complaints across all of our areas of operation. The low number of sham contracting complaints are not something that we generate. It's reactive work that we respond to what is reported to us. I note since December 2016, we have published in our annual reports all complaints and all investigations. Further to that, we've published the details of that in quarterly reports as well as our annual report. It's fair to say that our primary area of complaint and investigation in the past 2 years has been wages and entitlements and right of entry, and sham contracting is well down the list.
The ABCC industry update published in January 2022 set out litigation statistics since the 2nd of December 2016. Those statistics show that only 3% of all ABCC prosecutions have related to contraventions of wages and entitlements. The statistics don't say anything at all about sham contracting cases. Have you got any observation on why that's the case?
Yes, Senator. The cases we've run since 2 December 2016 are based on complaints to the agency and proactive investigations. We will proceed to court with a matter where there is sufficient admissible evidence and an external legal advice that there are reasonable prospects for success, and that where it is in the public interest. We have not had investigations culminating in successful sham contracting prosecutions that would satisfy a court that there is a case to answer. And if I can just deal with the low number of wage recovery cases, if I refer back to the 7,826 employees we've recovered wages for, we've worked with the employers in all of those matters to recover the wages in full, and that's obviated the need and the necessity to go to court. There have been a handful of court cases we've run against employers for underpayment of wages. We'll continue to do that where an employer does not make full rectification to our satisfaction. But that is reflective of our court results, and it's also to be observed that the vast majority of our court matters have been in cases where contraventions of the Fair Work Act or the Building and Construction Industry Improving Activity Act have occurred, and we have successfully run 90 of 100 cases proving contraventions of those two acts.
So has the ABCC run any court cases for breaches of sham contracting laws since it was re-established in 2016?
I don't believe we have since 2 December 2016, but I'll just ask Ms Jones to confirm that fact.
That is correct.
As the agency with statutory responsibility for eradicating sham contracting and protecting workers against wage underpayments in the commercial construction industry, why was the important issue being left to the CFMMU to police and prosecute? And what is the ABCC doing to ensure that workers do not keep getting ripped off?
Senator, the primary means we have for addressing underpayment of wages is recovering wages. And we've done that, and I've referred you to the figure of $4.796 million recovered for 7,826 employees. Their wages have been recovered in full. They've been recovered by my agency, and in 80% of those cases, neither the employer nor the employee was aware that there'd been an underpayment. It was discovered by proactive audits conducted by my agency. That has been the primary means by which we're making a difference in the wages space, and we'll continue to do that.
And in light of the proactive, as you describe, audits,
yes.
Why isn't there proactive audits of potential sham contracting arrangements? I would understand that the industry has a lot of intelligence, as has been reported in many inquiries, of sham contracting, and there'd be certainly, my experience in that space would be that there'd be many companies that would be more than happy to give evidence about, certainly private evidence regarding sham contracting, if not public.
We'd be happy to receive information, intelligence, complaints, referrals or assistance from any building industry participant. And that's what our Act defines, a building industry participant. It can be a contractor, a subcontractor, a worker or a union. Senator, regrettably, not one referral in 5 years from a union regarding sham contracting.
They haven't got a great deal of confidence in you, Mr. McBurney.
Not one referral, Senator. I've written to them. I've requested information from them. I've written to Mr Noonan and specifically said to him, if your union is recovering underpayments from employers, why don't you tell the regulator about it? Why don't you report it to us? I'm not in competition with the unions to recover the wages. I'm happy for workers to have their wages recovered from any one senator, but I've said, we're the regulator, we can take action, we can take court action. Give us the names, refer the companies to us, let us do our job, and nothing in return, Senator. I can't do more than that.
Senator Sheldon, I might just, I've got a few questions, so we might just rotate the call unless you have...
Yeah, I've got just one final on that track.
Okay, no problem, you go.
There are other questions I've got, but
that's fine. If you want one more on this topic, that's fine.
So just so I'm clear, that you've got, you do proactive investigations, as you describe them, for wage underpayments that you say you do a proactive investigation for.
Yes.
Proactive investigations are based on complaints.
We do reactive investigations based on complaints, and we do proactive investigations where we become aware of a potential contravention of a designated building law, either the Fair Work Act or the BCIIP Act or the Building Code.
So you've become aware of no sham contracting arrangements applying the same criteria that you apply?
So again, Senator, I refer you to our reports. We've had a small number of sham contracting investigations conducted over the 5 years. We've previously given evidence to this committee about what the outcome of those sham contracting investigations was. There are a variety of outcomes to an investigation. Ms Jones can take you to those if that would assist. But Last year we only had 4 sham contracting investigations or complaints. Ms Jones will clarify for you, because I'm not sure whether it was complaints or investigations that was reported in our annual report. Quite often the outcome may be a full recovery of wages underpaid. But we will come back to you. We've taken your earlier question on notice, and we will come back to you with a breakdown of the figures as best we can, Senator.
Ms Jones, just on the invitation, Mr McBurney, how many of those 4 sham contracting arrangements were found, in your view, to be, or the authority's view, to be sham contracting, and how many of those companies have been prosecuted?
We haven't prosecuted any companies for sham contracting. You'll appreciate that the bar to prove sham contracting is very high, because not only do we have to prove that the person was engaged as a contractor and they should have been an employee, but we also have to get over the hurdle that the employer did not know and they weren't reckless as to the engagement. But I can tell you that since December 2016, we've responded to 172 inquiries regarding sham contracting. We've received 52 complaints and undertaken 34 investigations. We have 1 investigation ongoing.
So no prosecutions?
There was 4 investigations last year.
Mr McBurney, you'd be aware that sham contracting is a major blight on the construction industry?
I've heard that characterisation, Senator.
Okay.
So I guess I'll go to you.
Yeah.
So, yep.
All right.
Thanks.
Thank you, Senator Sheldon. I just have a few questions. I wanted to ask a little bit about some of your recent litigation matters. First of all, I mean, does your litigation tend to focus on particular unions or organisations that are conducting alleged contraventions in a repeated fashion?
Yes, Chair, the Act requires us to police and monitor appropriate standards of conduct by all building industry participants. And so our litigation profile covers a broad range of matters. Having said that, there is one respondent who's significantly overrepresented in our litigation outcomes. That is the CFMMEU, and they account for well over half of our investigations, over half of our cases before the court, and over half of our results from the court, and a lion's share of the penalties imposed by the court in the last 5 years.
Over that last 5 years, what is the total amount of the penalties that courts have ordered against the CFMMEU?
Since 2 December 2016, we've run 106 cases. 97 of those cases have been resolved in our favour for a total of 2,498 proven contraventions. In respect to the CFMMEU, the figures are 87 cases brought against them and 79 resolved in our favour. In those 79 cases, the CFMMEU and its representatives have been found by the courts, primarily the Federal Court and the Federal Circuit Court and Family Court, to have committed a total of 1,659 contraventions. And in those 79 cases, the courts have imposed $14,697,263 in penalties against the CFMMEU and its representatives. And of that 14.6 million, I need to just add that 1.481 million is subject to appeal or further decision.
Okay. Could you just give me those? I think you said 1659 contraventions.
1,659 individual contraventions. By the CFMMEU and its representatives.
They weren't alleged, they were actual...
They were actual findings by the court.
Yes. Contraventions found by court or tribunal. And how many in total were there? I just missed the further, you mentioned it earlier, 2,000.
The total contraventions across all of the industry is 2,498 contraventions in all ABCC cases.
So I've got that as two-thirds of the proven contraventions have come from just one organisation, the CFMMEU. That's roughly correct, is it?
That's correct, Chair.
Thank you for that. Is this number of contraventions decreasing or increasing or staying about the same over the past 5 years? I mean, are they learning their lesson given the size of these fines and contraventions?
Senator, the figures are fairly consistent over the 5 years, and I might just ask the Deputy Commissioner Legal, Matt Kelleher, to address you on this, because he's better across the case results than I am.
That's fine.
Mr Kelleher, thank you.
I think you might be on mute, Mr Kelleher. We can't hear you at this stage. No, it's still on mute. Oh, well, we can't hear you. I don't know. It's usually the problem we've all experienced, but maybe there's some other technical issue.
Can you hear me now, Senator?
Yes, got you. Okay, loud and clear. Thank you. Mr Kelleher.
Matt Kelleher, the Deputy Commissioner Legal. The fact is that the disproportionate representation of the CFMMEU in our litigation is increasing, I would say, to the extent that of 32 current matters before the court, 28 of those involve the CFMMEU and or its officials, and certainly a number of recent cases that have been decided by the Federal Court and the Federal Circuit and Family Court have involved the CFMMEU, recently in New South Wales, the Wheeler Cranes matter, in Queensland, the South Bank Performing Arts matter, where the CFMMEU was described by Judge Egan as being a rogue union, the Coffs Harbour matter in New South Wales, where the judge in that matter described the conduct as being industrial stalking, in the Kiama aged care facility matter, again, that involved the CFMMEU and two of its officials. Two recent cases of abusive conduct in the WestConnex matter and the Callot Oval matter, WestConnex in New South Wales and Callot Oval in South Australia. So of those cases, they were all CFMMEU matters.
Okay, thank you. Thank you for that. Moving on, are you able to provide some information, a specific case, I believe it was involving the Coffs Harbour expansion project. Can you provide a summary for us on the details of that case and its outcomes?
I'll ask Mr Kelleher to address that.
No problems. Mr Kelleher.
Yes, Senator. That was a decision handed down on the 28th of January this year, where the Federal Circuit and Family Court penalised the CFMMEU and its official Dean Riley a total of $90,000 for threatening, inciting and encouraging a contractor to enter into an enterprise agreement with the CFMMEU and terminate its contract with a labour hire company because the company did not have a CFMMEU agreement. I think it's important to note there the significance of that particular infrastructure project that was impacted. That expansion project of the hospital will provide the community with a new emergency department, operating theatres, critical care and inpatient beds, as well as increased capacity for chemotherapy. That decision of Judge Driver, His Honour described Mr Riley's conduct as premeditated and said that it was a form of industrial stalking of employers who were considered non-compliant with the union's industrial objectives. The judge said that the union was in the midst of a demarcation dispute with its rival union, the Australian Workers Union, which was a motivation behind Mr Riley's conduct, in addition to the usual industrial objectives of the union. And he went on to describe the behaviour there in respect of the CFMMEU as its ongoing conduct being institutionalised. The size of the union, he said, was significant. It had real power and influence in the building and construction industry, and went on to say that the respondents, as is the case we see in a lion's share of decisions, had no evidence of remorse or contrition for the conduct that led to the contraventions.
You mentioned there that the case involved threats and intimidation by the CFMMEU to a certain contractor. Do you have some specific examples of what those threats and intimidation involved? What were the specific details of that?
Yeah, Senator, the threats related to Mr. Riley, the official demanding that the contractor ensure that all employees at the yard leave the Australian Workers Union and join the CFMEU, or that he would arrange for a labour hire company covered by a CFMEU enterprise agreement to replace the employer. And he cited previous blockades that had been affected by the CFMEU of precast deliveries to construction sites to give force and substance to those threats. And we allege
just quickly there, blockades. What does that mean? What would they do in that case?
Well, typically, Senator, a reference to a blockade would be preventing access or egress of particular access to a site or a yard or product.
Who would do that? Who would they get to make these, to block the entrance to that business?
Senator, in general terms, not specific to this particular matter, that would be, for example, often we see in a picketing context, individuals that are organised, whether it be members or otherwise, usually members of the union, to congregate to affect that.
Right. Sorry, I might have stopped you there too. Were you going to any other examples of threats or intimidation?
That was the substance of the threats in that case. They were deliberate and in direct manner, and found to have, at times, be part of a heated conversation where Mr. Riley, the official, swore and raised his voice.
What did the AWU think of this? Were they party to this this case at all? Did they provide evidence, or were they completely outside its remit?
They were not a party to it, no. But it was obviously a finding of the judge there that the underlying context related to a demarcation dispute with the AWU.
Okay. Thank you for that. Just one final question. I think you might have mentioned, I can't remember, it was you, Commissioner, or Mr. Kelleher mentioned the 32 cases, I think, before, or you're taking action on involving a CFMEU. I mean, what's the sort of nature of that conduct? And I'm particularly interested, I mean, if we didn't have a building code, if we didn't have the ABCC, would these cases be able to be prosecuted? Are there other ways of doing it, those 32?
Senator, there are 32 indicated 32 cases currently before the courts, of which 28 involve the CFMEU.
Right. Okay. Sorry, Mr. Interpreter. So 28 of the 30. You got 32 in total. 28 involve the CFMEU. Okay. Go on. Sorry, Mr. Kelleher.
Presently, there's a composition of cases across contraventions of both the Fair Work Act and the Building and Construction Industry Improving Productivity Act. There are a significant number of right of entry cases in which 107 contraventions have been found this financial year to date, or as at the 1st of February this year, with $1.194 million in penalties imposed, $472,000 for 12 contraventions of coercion contraventions. Under the Building and Construction Industry Improving Productivity Act, there is an unlawful picketing provision that is particular to that piece of legislation, and there are obviously unlawful industrial action provisions across both pieces of legislation. The Building and Construction Industry Improving Productivity Act carrying with it a higher maximum penalty for contraventions of those provisions as compared with the Fair Work Act.
Okay, thank you, Mr. Kelleher, and appreciate your evidence. Okay, passing back to Senator Sheldon. Thank you.
Good, thanks. Last year in estimates, we recall you were asked questions, Ms McBurney, about Kiama Aged Care Centre. In that case in which one of your key witnesses in the case was criticised by the judge for appearing to make up evidence as you went along. In that same matter, the judge also found you had been too ambitious and described the authority too ambitious and described the case as misconceived. Further to that there is a more recent, in the same case, a Justice Katzman criticised the ABCC for misrepresenting evidence, for filing unnecessary inflammatory pleadings, and said the ABCC bears some responsibility for media reporting which unfairly and wrongly alleged, based on the ABC statements, that a CFMEU organiser had made a throat-slitting gesture when in fact he had not done so. Will the ABCC apologise to the organiser involved and to the CFMMEU for engaging in this disgraceful behaviour?
Senator, before I hand over to Mr Kelleher, when I was previously at Estimates, I was not in a position to answer the questions because the matter was before the court. Since the last Estimates hearing, the court has published its final judgment in the Kiama matter. My agency's been successful in this matter. The court's made no finding against my agency. The court's made no finding of contravention against my agency or the way we conducted the case. Mr Kelleher will take you to the two issues you raise, but I just want to make it clear that this is now yet a further example of contraventions committed by the CFMMEU in this case, serious contraventions, and the judge has passed judgment on that. The judge, our position, Senator, is that we put the evidence before the court, and we do so cognizant of our model litigant obligations, and it's for the court to weigh up that evidence. In this case, it heard from, Mr Keller will correct me if I'm wrong, heard from 9 witnesses, and the judge made an assessment of those 9 witnesses. And we don't have the benefit of the accounts or the evidence of the respondents in this matter because they exercised their right to refuse to talk to us. And that is their right. I make no judgment of them on that. So we hear one side of the story, we gather that evidence, we put that evidence before the court, and we do so cognizant of our obligations. Now, I'll just ask Mr Kelleher to take you to the 2 specific issues you raise, being the first issue regarding the witness that I think Senator Pratt asked me about on the previous occasion, and the second issue goes to the throat-slitting gesture as you describe it. Thank you, Mr Kelleher.
I'll leave, if Senator Pratt wants to pursue that, I respect that she may.
You're just interested in the throat-slitting gesture?
I am asking very clearly about what the comments were made by Justice Katzmann, criticised the ABCC, which is a significant thing to be doing in any matter, for misrepresenting evidence, for filing unnecessary inflammatory pleadings, and said that the ABCC bears some responsibility for media reporting, which unfairly and wrongly alleged, based on ABC statements, that a CFMMEU organiser had made a throat-slitting gesture when in fact had not done so. That's what I'm asking. Will the ABC apologise to that organiser involved?
So Mr Kelleher will now take you to the hand gesture that was made by the official that was accepted by the court, and he will give you an answer to your question, Senator. Thank you, Mr Kelleher.
Thank you, Commissioner. Senator, the reference that you made to a throat-slitting gesture, you'll be aware, was the subject of a finding of Her Honour where she said that it was common ground that the Commissioner did not use the term a throat-slitting gesture either in his pleading or in his media release. It was a reference used by an external publication, and you are referencing one single word, essentially, that issue was taken with that we acknowledge in the decision out of a 31-page statement of claim. Matter that was pleaded based upon advice by experienced senior counsel in that case that was considered to constitute a material fact in the matter. As the Commissioner indicated, that trial, which was fully contested over the course of a week, involving 9 witnesses, none of whom had a vested interest in the outcome of the matter, all of whom were cross-examined, led to an outcome that was substantively successful for the agency, with $184,000 in penalties being imposed. Penalties against Mr Dinala.
Mr Kelly, I'm not asking you to go back through evidence that you're already given in some of these matters to questions that were asked earlier. It's not up to Mr McBurney to ask you questions, it's up to me. I'm asking you the question about the unnecessary inflammatory, quoting Justice Katzmann, that was unnecessary, inflammatory filing by the ABCC, and are you going to bear some responsibility for the unfair and wrongly alleging that there was a throat-slitting gesture, I quote, where in fact there wasn't one? That's what I'm asking you about.
Senator, we acknowledge that finding. The comment to which you refer,
So you acknowledge that finding, and can you explain to me how you acknowledge it?
We acknowledge it by reason of the fact that it was included in the judgment. It was not an issue that the union raised with us as to the state of the pleading. And in cases before now and cases after now, it will be the subject of a strikeout application, for example, if a particular statement of claim under rules are embarrassing or prejudicial. That did not happen here. It did not, on our reading of it, impact the penalty that was imposed on Mr Danalis or the union, $11,000 for Mr Danalis, correspondingly $150,000 for the union. And it is one word that was, on the advice of our Queen's Counsel, a material fact that was properly alleged.
Mr Kelleher, I'm not suggesting this towards you or to anyone. I could just say this generally within the room. If someone was alleged to have said that a throat-slitting exercise, they were alleged in a court and the judge says that that's not appropriate, that the judge says that the allegations are unnecessary and inflammatory, then wouldn't you expect there to be an apology? I'm certain that in here, if somebody was using that action, we'd have a bit to say about it.
Senator, I need to correct you. It was not alleged by us, and it was found that we did not allege that. That is a finding.
So the throat-slitting gesture was never alleged?
It was never alleged.
I'm going to have to come back to you on that. Can you explain?
Can I
I just want to go to another matter.
Just before you leave that, Senator, you asked about an apology. In this matter, there was misreporting by a newspaper of the fact of the throat-slitting gesture. And I understand, Mr Kelleher will correct me if I'm wrong, that the newspaper responsible issued a retraction, Mr Kelleher?
There was a correction to it, Commissioner, yes.
If there is an apology due in this matter, it ought to be from that misreporting that, as the judge correctly pointed out, was not accurately reported based on our pleading. And just while we're on the subject of apologies, the ultimate finding of the court was consistent with how we pleaded our case. And the judge found that a common feature of the conduct of the officials exhibited a certain arrogance or sense of entitlement. Each involved deliberate acts, obstruction on the first day and defiance on the second.
Ms.
And
McBurney, if somebody else wants to ask you questions about that, they are welcome to.
Yes.
I am not asking you questions about
Well, you asked me if I'd be
matter.
making an apology. I'm
You're
giving
saying
you
you're
my
not,
answer.
yes. I appreciate that. If you're saying you're not.
Senator Sheldon has embarked on a line of questioning. He has insinuated certain things. I might even say more than insinuated certain things. And it is only fair that the Commissioner be able to answer with sufficient context to be able to make sure the record is accurate. Whether or not Senator Sheldon likes that, he should nevertheless allow the Commissioner to finish his answer.
Chair, that's not a point of order. The fact is that I was asking a question about the apology and specifically about the apology that was involving the throat slitting. Ms McBurney wants to go into other matters, and I said if somebody else wants to ask that question about the other matters, then they are welcome to.
Look, I think we just need to return to the questioning. Obviously, it will be helpful for the committee if we do not talk over each other. As I mentioned earlier, it would also be helpful if questions were not repeated multiple times. Thank you, Senator Sheldon.
I refer to the matter of the Australian Building Construction Commissioner versus Desmond Savage and Construction Forestry. Maritime Mining and Energy Union. Are you aware of the matter in which I'm referring?
Yes, Senator.
In the matter, the ABCC was heavily criticised by a full bench of the Fair Work Commission. The full bench said that one of the ABCC's arguments was so directly contrary to the case it advanced at first instance that it would be entirely inappropriate to grant permission to appeal in respect of it at Section 18, which is a direct criticism of your organisation for misusing its rights by appealing a decision relating to CFMEU organisers' right of entry permit and then putting an argument forward which directly contradicted an argument it had made in the decision being appealed. Why would the ABCC waste taxpayers' resources appealing a decision on grounds that directly contradicted what the ABCC itself had said in the first instance?
Yes, thank you, Senator. I'll just introduce this because Mr Kelleher can go to the direct matters raised in your question.
Thank you, Mr.
But I need to explain my position on this. And my position on this was we received a successful outcome in the Adelaide Airport prosecution. And in that case, the CFMEU was penalised $390,500 and the individual you're asking about, Mr Desmond Savage, was penalised $4,500 for contravention of the Fair Work Act. That triggered consideration of whether he was a fit and proper person to continue to hold a right of entry permit, a federal right of entry permit. And Mr Kelleher will take you to the conduct which triggered the consideration and then the appeal. And I'll ask Mr Kelleher to address you on that now.
Yeah, thank you, Commissioner. Senator, the case that went before the application or the Commission's commencement on its own initiative of a Section 510 application involved obscene and abusive language to which the relevant CFMEU official to which you referred told a site representative to go do your effing colouring in books, you see, beep, beep, beep. Those statements were described by the federal court as having a belittling, denigratory and bullying tenor, and that they were a form of abuse. The Commissioner, as is his right under the Building and Construction Industry Improving Productivity Act, intervened in the application before the Fair Work Commission to contend that it would that Mr Savage's permit ought be suspended. The Commission did not agree, and the Commissioner then sought permission to appeal to the full bench of the Fair Work Commission, the decision to which you referred, and such permission was refused. Now, having reviewed that decision, we don't consider that the position run was directly contrary to the position advanced below. Senior counsel who appeared on behalf of the Commissioner recognised that the point argued was not run at first instance in the Commission. And on appeal, in short compass, the contention raised was that the corrective and protective purpose of Section 510 was relevant in relation to the public at large, that is, general deterrence. At first instance, we said that general deterrence did not have a role to play in respect of the length of suspension, not whether suspension was needed at all. So we respectfully don't consider that the position was directly contrary to what was argued below.
So you don't agree with the full bench's view on that particular matter?
Senator, for the reasons that I just described, the position that was advanced, we consider not to have been directly contrary.
At the last estimate, thank you. At the last estimates hearing in 2021, Mr McBurney, you were asked about more strident criticism of the ABCC. That time it was Justice Kerr who said that the ABCC had over-egged its case and was acting like a battleship in full steam, which had difficulty turning. Only a few months later, we're back asking questions about two more cases of heavy criticism of the way the ABCC conducts itself. A pattern is starting to, in my view, starting to emerge, which shows the ABC to be ideologically driven against unions and the CFMEU in particular. There's been comments made by now 3 judges, which I've referred to. Why does the ABCC continue to act in ways which attract judicial criticism?
Senator, The reality we deal with, I think Justice Kerr was right on several points, and one is that we are facing heavily contested litigation every time we go to court against the union. There's no quarter given, and that's from both sides. We pride ourselves on conducting our litigation in accordance with the model litigant principles. And all I can do is point to our record. 19 successful cases out of 19 this year. Senator, 29 successful cases in a row for the agency. We set ourselves a benchmark of 80%, and we've exceeded that, 29 successful outcomes. Now, along the way, not everything is going to go how we expect it. Litigation is uncertain. We put in good faith the evidence of witnesses before the courts. Some of those witnesses are accepted as witnesses of truth, some aren't, and that applies on both sides. But as Mr Kelleher pointed out, our witnesses don't have a vested interest in these proceedings. They come to court, they give the evidence, and it's not for me to pass judgment on the union or its officials. I leave that to the court. And again, our record speaks for itself. 29 successful cases, millions of dollars in penalties, and the one recurring feature is an entire absence of contrition and remorse. That's what we're dealing with. It's not going to change anytime soon, but we as regulator must hold law breakers to account, and that's what we'll continue to do.
Mr. Mayor, I just want to ask a question about what the evidence you just gave. So are you giving no quarter to sham contracting, no quarter to the massive underpayments running into tens upon tens upon tens of millions of dollars? Because from your own figures, it's not very successful, is it? It doesn't appear to be there's no quarter on sham contracting from the ABCC or for wage theft.
So, Senator, I mentioned earlier, first ever age discrimination, successful prosecution. Peter, a 72-year-old worker, applied for a job and was refused and was sent an email by the labour hire company saying, sorry mate, you're too old for this job. Peter contacted the agency. We took it seriously. We took both the host employer and the contractor to court, and we successfully prosecuted that matter. And we said to the federal court, and they accepted our submission, that half of the penalties should be paid to the genuine victim in this, which was Peter, who was denied employment, denied a job, denied the opportunity to be employed. The Act requires that I be there for all building industry participants. So whether it's an employer who breaks the law or whether it's the union, and Senator, I just point to the unions in our sector who are doing the right thing, who are complying with the law. We've had one case in the last 2 years against the AWU. We've had two against the CEPU. We've had one against the MWU. And as Mr Kelleher points out, we've got 28 in court at the moment with the CFMMEU. That's where it sits, and that's why we'll continue to prosecute these matters, because there is only one building industry participant who the courts have said are operating a business model of breaking the law.
So there's no quarter given to, as you said in your own words, as a model litigant, no quarter given, except when it comes to sham contracting and wage theft, putting aside your one individual case you've recited,
yes,
which doesn't reflect on dealing with the damage that's going on in this industry with wage theft, does it?
So let me talk about wage theft. Let me talk about open tiling, Senator, because it goes directly to your question. On no quarter given, we accept nothing less than repayment in full. And that's how we've recovered $4.796 million for 7,826 employees.
And have you prosecuted them for breaches?
When we don't get payment in full, when the employer sticks their head in the sand, when the employer doesn't engage with the agency, we put them into court. And we did that with core staff, and we did that with open tiling. And open tiling is probably our best recent example of where we achieved an outcome for a worker who'd been let down by his employer and then let down by his union, the CFMMEU, which recovered less than a third of the money he was owed and didn't pass on all of the money they recovered to the worker. And if it would assist, Senator, I'm conscious of the time, but Mr Kelleher can take you to the facts of that case, because it demonstrates the same approach we take to the union when they break the law is the approach we adopted with open tiling in the open tiling.
Mr Keller, can you take that question on notice? Because we are running out of time.
I can take that on notice, Senator.
Thank you. Back to you, Chair.
Okay, thank you, Senator Sheldon. I do not believe there's any more questions for the Australian Building and Construction Commission, so thank you very much for your attendance and evidence. We will move next to the Coal Mining Industry Long Service Leave Funding Corporation. I believe they're here, are they? So we might just suspend while we'll just quickly suspend the broadcasting while we rearrange. Reconvene. Broadcasting is on. I welcome officials from the Coal Mining Industry Long Service Leave Funding Corporation. Thank you for your attendance. Miss Perks, is it? Is that right? Thank you. Miss Perks, do you have an opening statement?
No, thank you, Chair.
Okay, thank you. I will go to Senator Roberts.
Thank you, Chair, and thank you for attending again. And my first question is going to be to the Minister. And I note that the KPMG review of Coal LSL report came out today.
Yes.
I haven't seen it, but it came out.
Yes, it's out.
So we're looking forward to reading that, and thank you very much for arranging that.
Thank you for working so constructively with government on it.
Well, it's a big concern, as you know, for us, the coal miners in Queensland and New South Wales. Now, I note that KPMG was engaged to undertake the review of Coal LSL in relation to the underpayment and abuse of casual coal miners. KPMG has also conducted the audit of Coal LSL. Doesn't that create a conflict of interest? And what did you do to manage this conflict? Because the audit could have influenced the review and the review could have influenced the audit.
Look, I don't regard that as giving rise to a conflict of interest. There was no direct financial interest for KPMG to do anything other than act consistently with its duties as an independent examiner there.
Senator, I'm aware there was an audit commissioned by the corporations. It's conducted by PwC. During the procurement process, when we selected an independent reviewer and a KPMG, we looked at any consultant at the time was engaged by the corporations may causing a perception of a conflict of interest. We have excluded. So at the time we engaged KPMG, and the KPMG wasn't working with the coal long service corporations on any other projects, but Ms. Perk may have give an update on are they engaging KPMG on a consultancy?
Thank you, Helen Perk, CEO Coal LSL. Thank you, Senator. I can confirm that KPMG has not been engaged by Coal LSL to conduct any work. They've not been involved in our internal audit programs. They're not engaged by the ANAO to do our external audit. So I think we're confident to say that any conflict of interest certainly wouldn't exist with KPMG conducting that work on us.
Now, I'm going to leave out my second question because the report may, the review report may address that, so I'll just go straight to my third. When will Coal LSL fix its broken system that disadvantages coal miners, casual coal miners everywhere? And when would you remove the biased and conflicted members from the board so workers get a fair go? I'm talking here specifically about what I see and what we've talked about for a long time now, the conflicts of interest with having significant, 50-50 Minerals Council New South Wales and CFMEU from New South Wales involved. When will that be addressed?
Senator Roberts, without wanting to spoil your reading, because, spoiler alerts are sometimes needed on these things, one of the recommendations in the report is that there be independent directors added to the board, and the expectation that that would assist with dealing with the problem you raise.
Okay, thank you. We're pleased to hear that. Last question, Chair. The One Key Resources case, where many casual coal miners missed out on their fair pay, back pay and conditions, seems to have been blatant phoenixing to us. Yet this rip-off of workers was accepted by your government, the courts, Labor and the CFMEU in the Hunter Valley. More needs to be done to protect casual coal workers to get equal pay, entitlements and safety. One Nation has proposed the Equal Pay for Equal Work Bill to protect casual coal workers. What are you doing to make sure that this doesn't happen again? People have lost their...
The KPMG report, and I will paraphrase somewhat here, acknowledges that there has been difficulties and confusion associated with a lack of clarity on what constitutes a black coal worker, and also the changing environment and timetables on which people work. It plans out ways in which that can be dealt with so that we don't face that problem in future. It also provides some good recommendations for how to resolve those concerns as they have arisen in the past. I'm optimistic that as we implement the government's response to those recommendations, we will have that in a more satisfactory place for everyone involved.
Okay, because this is affecting tens of thousands of families who are significantly underpaid compared with permanent workers doing the same job. But it's just one of a suite of issues. This is just, it's very important to coal miners, and we've been relentless in this, and we're pleased to see what you're doing. But it's one tiny aspect of the bigger picture, which we don't need to discuss here.
I share your sincere concern for making sure that this works for everybody, and that's why I'm really optimistic that what's come to us through the KPMG report and all of the recommendations to government have been accepted in one form or another, and I'm really pleased to say that we'll be working to do what's necessary to make all of that much more functional for the future.
I look forward to reading the report, and thank you, Chair.
Thank you, Senator Roberts. Ms Perks, this morning, as Senator Stoker just mentioned, that the government's accepted the recommendations to it from the KPMG review. Has the Coal LSL, have you responded formally at this stage to the recommendations that relate to yourself?
Chair, we haven't as yet. The report is quite fresh in our hands as well today, so we have had the opportunity to read it, but we'll be digesting it, and then we'll have a response through to government shortly. We do acknowledge that 10 of the 20 recommendations are, I guess, identified as opportunities that we can take the initiative with, and we'll be considering that in our strategic planning process, and certainly be looking at what resources can be allocated to see those initiatives progress to address the recommendations that have been put forward to us.
Okay, well, thank you very much, Ms Perks. I don't believe there are any other questions. Is that correct? Okay, well, thank you very much for your evidence. You are now released. Have we got our next witness, the Fair Work Commission? Are they online? Or they're remotely, aren't they? I think, yes. We might just, doesn't look like they're online, so we might just suspend. We'll reconvene and welcome to officials from the Fair Work Commission. I'm just searching here. Who is it you, Mr Furlong? Are you the lead witness, so to speak? It's just a bit harder online to know.
Yes, Chair.
Okay.
Yes, I am.
Thank you. Mr Furlong, would you like to make an opening statement?
No, thank you, Chair.
Thank you. And we'll go straight to Senator Pratt.
Thank you. Good evening. Mr Furlong, you may have been listening or may not have been listening to earlier evidence today regarding the unilateral termination of expired enterprise agreements. But regardless of that, I referred to the report by journalist Ben Butler published in The Guardian on the 22nd of January, which indicated that employer interest in unilaterally terminating enterprise agreements is surging. It may not have come to your attention, that specific article. It has been tabled, but I'm sure you've seen it in your role. Employers rushing to terminate enterprise agreements. The president of the ACTU was quoted saying, "It looks to us like companies are seeing this as the moment as their best chance to cut workers' wages and conditions while Scott Morrison is in power." I'm not going to ask you to comment on that, but may I ask, please, what data have you got on the number of applications made to terminate expired enterprise agreements?
Senator, the agreements, as you'll be aware, continue to operate after their nominal expiry dates until they're either replaced by a new agreement or they've been terminated by the Commission on application. So for the year, this financial year, from 1 July through to 31 December, we have received 176 applications to terminate agreements, which is largely consistent with the number of previous years.
Okay, so that's 176 last year. How many to date this financial year?
Senator, that is so far, that's from this financial year, from 1 July through to 31 December this financial year. So for 2020-21, so the previous financial year, there was 330, 2019-20, 380, and for 2018-19, it was 484.
Okay, are you able to break down that data according to the type of employer or employee that's made that application?
I don't have that information in front of me. We can do that, but I'll have to take that on notice.
I would be grateful if you could take that on notice.
In relation to that, no problems.
What proportion of those applications historically are approved? And are you able to break that down for us by applicant as requested just now?
I can take that on notice.
Do you have any indication, not on notice, of what proportion of applications are approved?
I don't have that information in front of me, Senator, but anecdotally I can say that, and the witness who has this detailed information is attempting to join us at the moment. So hopefully he can get into the session. But essentially my understanding is that it's over 80% of those applications. But the vast majority of them aren't contested, or a very small number of them are contested.
Do you have data on where the circumstances in which entitlements decline or increase as a result of that termination?
No, I don't. But as you're aware, these are matters that are allocated to members of the Commission for determination, and Section 226, depending on if goes to the matters that the Commission must consider in determining whether or not to terminate an enterprise agreement.
Okay. Thank you for that answer. I hope I'm not complicating things too much by asking this, but in terms of the data on applications and employer or employee applications and approvals, can you also please give us data on withdrawals of those applications? I
have some information available here, Senator, if it may assist. So for application for approval or termination of an enterprise agreement, the agreement is terminated. So in terms of the applicants, 97% have been the employer, and 2% have been individuals. Of those matters, so far 50 have been terminated, 2 the agreement was not terminated, and 8 the application was withdrawn or discontinued.
Sorry, and what year does that data belong to? This year?
2021.
Thank you. When a worker's pay and conditions are no longer governed by an enterprise agreement because of that application is successful in termination, I understand that the irrelevant award applies. So before the Commission approves an application by an employer to move off and their workers to then move back off the award and back into an enterprise agreement, the Commission has to be satisfied that moving to the enterprise agreement will leave the workers better off overall compared to the award. Is that right?
That's right. Every employee and every prospective employee will be better off overall.
Okay. So then if the employer subsequently makes a unilateral application to terminate that same enterprise agreement, how does the Commission ensure that putting workers back onto the award won't leave them worse off?
On the termination of the agreement, on an agreement, then the terms and conditions will fall back to the underlying industrial instrument, as you indicate, Senator.
Okay.
It is generally the modern award, but it is a matter that's determined by, and those arrangements are determined by the members of the tribunal.
Okay, so it'll be somewhere, but either the award or somewhere between the EBA and the award. I know there are trade-offs inside it, and therefore it's hard to compare like with like, but can I therefore ask what kind of safety net applies to workers who are forced back onto the award because their employer has sought to terminate the enterprise agreement?
Essentially, they will fall back to the terms and conditions that are provided for on that modern award, unless there are other arrangements that are made through the termination application.
Okay. Is there any limit on what kind of pay cut or cut in conditions other than the previous award at a statutory level in terms of the powers of the Commission?
Can't talk in the abstract matter to matter. Essentially, they're dealt with the information or the facts by members of the tribunal on the application to terminate the agreement.
So is there any limit on the amount that a worker's pay is allowed to be cut but as a result of being forced back onto the award?
Essentially, it will move back in terms of the minimums, the statutory minimum. Will fall back to whatever is provided in that underlying modern award.
Okay, so we looked earlier today at the award for Qantas workers cabin crew, I think, category number 1. It was about $75,000 a year as their kind of base condition under the EBA, but the award is only $45,000. So a termination would mean a salary cut of at least 30 or 40% in that case, would it not?
Based on those figures, yes, that sounds accurate.
So
the only... I just say on that, the application, there's an application to terminate that agreement. It was lodged on the 20th of January this year. It's listed for hearing for a single member of the Commission between the 19th and the 22nd of April. I obviously can't talk in specifics about that matter because it is an active matter before a member of the Commission.
Okay, so using not that example, but an example where you've got an award that hasn't evolved over time. You could have your holidays, you've accrued holidays and you're being paid at a rate of, say, $70,000 a year for those holidays on a week-by-week basis versus holidays in the award. Does that mean someone's holiday entitlements can also be cut? How does the Commission deal with that?
Senator, I think that question in terms of how that would apply, I think that question may be better answered by the Federal Ombudsman who are appearing before you later this evening.
I understand that in terms of, we're talking here about the termination of an enterprise agreement though, and I've seen historic cases where termination of the enterprise agreement does point back to, in effect, translating the accrued entitlements back down to the rate that they would be paid at under the award. Am I not correct in that?
That may or may not be the case, Senator. Just reiterate that it's the termination, the application and the termination and the decision issued by the member will be based on the circumstances and be dealt with on a case-by-case basis. So it is it's impossible to talk in absolutes in relation to this.
Okay, so the Commissioner might decide that you can't, they might determine that holiday pay entitlements can't be cut to the paid back right to the award, but hypothetically they could be, could they not? It's up to the Commissioner to decide.
The member of the Commission to determine the nature of the termination. I might ask Ms. Luby if she has anything she'd like to add.
We can't hear you, Ms. Luby.
She's on mute.
I apologise, Senator.
There you go, we got you.
Thank you, sorry about that. Just reiterating the point Mr. Furlong made is it's all on a case-by-case basis where the member will consider the effect of the termination on the employer and the employees. So they may determine that there's certain conditions that are in the agreement that may or may not be retained. Also to your point about the rates of pay, and I think Mr. Hare spoke about this earlier today, where it's not necessarily just the salary. You're not always comparing apples with apples because there can be things that are rolled into the salary in the agreement that aren't in the award and vice versa.
There's nothing in, the base though is just the award. There's nothing in there, for example, that emphasises the loyalty of someone to the company that means they've stayed in effect because of those accrued entitlements.
No, Senator, there's nothing like that in the award, no.
Okay. So there can be, therefore, a cut right back to the award level, including in accrued entitlements for sick pay, parental leave and redundancy entitlements. Is that correct?
Hypothetically, yes, if there was more beneficial benefits in relation to those areas in the agreement.
Okay. And the award might also mean longer hours in addition to a rate of pay, to a change in a reduction in the rate of pay?
Yes, hypothetically, there could have been a shorter working week in the agreement than there is under the award, or conversely, it could be the other way around.
So for employers, it's a bit of a free-for-all, and for workers, it's all downside, and purportedly they're supposed to be lucky if they keep their job. Anyway, I won't put that. I apologise for putting that as a question. I will just.
But to be fair to the witness as well, that they have been answering your questions, and I think this is something that we had canvassed earlier today in terms of what you're actually putting in the answer that you want. You are dealing in hypotheticals, and I think you have to go back to the evidence that Mr. Furlong gave. I mean, he basically said the member of the Commission will deal with the facts of a matter in accordance with the rules set out under the Fair Work Act. And the point that I made earlier today was that was obviously the Act that the Labor Party introduced in 2009. So I think, to be fair to the witness, she has dealt with hypotheticals and speculation in terms of the answers. Just to be fair to
and we'll
her.
see what data we get back in terms of the value of, say, the rate in the EBA versus the value of the rate in the award, and what was eventually arrived at in a determination. May I ask if you are able to tell us, through the Commission, what the process is when you receive one of these applications?
Broadly speaking, the application will be received and it'll be allocated through a regional allocation model. Essentially, it goes to one of two very senior members who then makes an allocation, an on allocation to a member who will then deal with that application.
Okay, and can I ask if there's any process for judging whether accrued entitlements are assessed against the fair in whether they are above or below the fair entitlements guarantee once a determination is made?
Ultimately, once the matter is allocated to a member, they will conduct the matter as they see fit, but obviously in accordance with the Fair Work Act. At section 226A, it determines or indicates that that the Commission will terminate agreement if it's not contrary to the public interest to do so, and it requires the Commission considers that it is appropriate to terminate the agreement, taking into account all of the circumstances, including the views of the employees, each employer and each employee organisation, if they're covered by the agreement, and the circumstances of those employees and organisations, including the likely effect that termination will have on each of them.
Okay, so it has no link, therefore, to the fair entitlements guarantee, but unless you consider that, then of course some of these workers are better off that the company that they're working for goes broke rather than, working to reach agreement.
So I just wanted to just check with that. So I think Mr. Furlong read out the clause of the Act, which actually gave the Commissioners quite a breadth of capacity to consider a range of things.
Okay.
I don't think there's anything in there that suggested that they're excluded from considering the FEG. It's entirely possible if they think it's relevant to the circumstances of the individuals.
Has the Commissioner ever pulled the FEG in as a relevant point?
Not that I'm aware of, but that's not to say that it hasn't occurred. As we indicated, there's over 300 applications terminate enterprise agreement every year. So it would be a very significant undertaking to go through each of those decisions to determine the answer to that question.
Okay, I think we're going to move on to casual conversion now.
If that might be a good opportunity, just Senator Rennick had some questions, so I might rotate the call at this stage and come back. He apparently won't be very long. Senator Rennick.
Hi guys, how are you? My first question is, how can Fair Work Australia morally justify the mandating of vaccines by employers in the private sector and Commonwealth employees, which goes against the explicit statement in the immunisation handbook that people cannot be forced into taking a vaccine?
The Fair Work Commission deals with matters on application, also about the termination of employment, in particular general protections and unfair dismissal applications. In recent times we've received a number that relate to vaccinations. Each of those cases are dealt with on their merits. Senator.
So I've been contacted by numerous people who've been put off because they cannot get a second vaccine. They've been given a medical exemption. They've had an allergic reaction to the first vaccine, or they've had prior anaphylactic shocks to prior vaccines. How on earth can we justify sacking people who've been injured by a vaccine and don't want to take a second vaccine and have a medical exemption to justify not getting the second vaccine?
Senator, the evidence that I can provide, the information I can provide, essentially goes to the functions in the administration of the Fair Work Commission. It's not the Commission's role to provide general advice on the lawfulness of vaccination requirements.
Okay, so you're not really explaining the process, because my understanding last year was that Fair Work Australia actually ruled that it was okay for employers to sack employees if they didn't follow the mandates.
There have been a number of recent Commission decisions on unfair dismissal applications where an employee has been dismissed after refusing to get a flu vaccination. In those circumstances, the cases are dealt with on their merits and they are determined by members of the tribunal.
Well, that's interesting. I'm glad you say on your merits, because in 2019 there were 139 adverse events reported from the flu vaccine. In the last 12 months, there's been 108,000 adverse events reported from the COVID vaccines. Given that's almost 1,000 times higher, despite the fact that 13 million people got the flu vaccine in 2019. Do you think it would be possible that there would be a merit in people not having to take the COVID vaccine given the high rate of injuries from it?
I think that, Chair, well, sorry, Senator Pratt, I don't need your interjections unless you want to raise a point of order. But look, I just wanted to restate that we typically do not ask officials' opinion on matters. But obviously, Senator Reddick, if your questions go to particular decisions that the Commission has made and asking them to explain, that is fine. But this may be straying into an area which is simply asking Mr Furlong for a broad opinion. But Mr Furlong, you're welcome to respond any way you choose.
Thank you, Chair. I just wanted to reiterate that it's not the Commission's role to provide general advice on the lawfulness or otherwise of vaccination requirements.
Okay, so if an employee is
Hang
injured...
on, sorry, Senator Reddick, I think Mr Hare wanted to add something.
These questions might be more appropriately put to the Fair Work Ombudsman, who do have advice around vaccinations on their website, so it might be a better place to ask those questions.
Okay, no worries. We'll see if you can answer this one. If an employee is injured by a vaccine forced upon them by a mandate, can the employee sue the employer for damages?
Again, Senator, that's probably not a question for Mr Furlong. So my recollection is that there was a scheme set up, but again, I think that's under the Department of Health's policy. So you'd probably be better off asking your...
So if it's a public health issue, okay, why are employers mandating it? Because it's not a workplace health and safety issue. Is that what we're saying? I'm not talking about hospitals and aged care centres. We'll put them to one side for the time being. I'm talking about normal, working environment outside of those two areas.
So, Senator, again, I'd encourage you to put those questions to the Fair Work Ombudsman. Their website provided a set of criteria to assist employers in determining it. My recollection of the position is that the common law does allow, in certain circumstances, employers to mandate things such as vaccines, but there is guidance provided on the Fair Work Ombudsman's website about when it's appropriate to do that or not. In addition to that, Safe Work Australia also have advice
And they're on later tonight
around
as well.
vaccinations in terms of work health and safety obligations.
Okay, so who am I going to ask whether or not the employee can sue the employer via work cover or whatever? Who's going to answer that question for me tonight? Is that the Ombudsman or yourselves?
So the scheme of arrangement which has been put in place, I think is a matter for the Department of Health. In terms of the protections. Thank you. So to give you a brief overview, but recognise you need to go to the Department of Health for this because they're the administrators of the scheme.
Okay, so I understand that scheme. So just to be clear, employers aren't liable either?
It's a no-fault COVID-19 vaccine claim scheme.
So if an employee gets injured by the vaccine, it's not work cover they go to, or it's not their own personal damages out of their superannuation
So that's
insurance?
the scheme that's been referred to, and Mr Hare can take you through the scheme.
I'm aware of the scheme. It's like I get people contacting me all the time. They want to know how they go about surviving financially because they've been put out of their job. Yep. So I've said to them they've got a number of things. Yes, they can use the indemnity scheme, but that indemnity scheme won't cover them if they haven't spent a night in hospital or the doctor won't write a medical exemption. Right? So I've spoken to numerous people who can't get out of bed in the morning. Right? They cannot work Okay, and doctors won't say that they've got myocarditis or something, right? So they can't claim under the indemnity scheme. That indemnity scheme doesn't cover everyone. And secondly, it only goes to $20,000. So what I want to know is for people who've been out of work for like 6 months now and lost tens of thousands of dollars, where do they go because their employer made them get the vaccine?
So the scheme does not replace existing workers' compensation arrangements, recognising that workers' compensation arrangements outside of Comcare are the responsibilities of the states and territories. So they can make claims there, is my understanding. And it also does not remove an individual's right to pursue workers' compensation if eligible. So, or to seek to litigate in relation to an adverse outcome. So the scheme is there to support on a no-fault basis. It, however, doesn't remove the existing rights under workers to make a claim under a workers' compensation or to seek to litigate.
Right, okay. Thanks for that. So is Fair Work Australia responsible for occupational health and safety?
So Safe Work Australia provides policy advice.
Right.
Individual states and territories are responsible for their own legislation, recognising that majority of states and territories have model legislation based on a common model, but enacted individually. And each of those state and territories have their own regulatory agency.
Right, okay.
So, but for the Commonwealth, that would be Comcare would be the regulatory agency.
Okay. So are they appearing next, or do they come under you as well? Sorry, there's just layers of
Safe Work Australia last on
and
tonight.
Comcare's second last.
Right.
They're later, and the schedule will be here.
So Fair Work Ombudsman is next, and Safe Work Australia is scheduled for 10 p.m, Senator Rennick, but
right.
Perhaps we could go quicker. So you're finished?
I just, yeah, okay, we'll leave it. I'll go to the next item.
I've just got a couple of follow-ups on Senator Rennick's questioning, if I can intervene here, given on a similar topic. I just particularly wanted to go to the decision, Mr Furlong, in regards to BHP versus the CFMEU, and in particular both the Mount Arthur Coal decision, I think a more recent decision, in regards to the validity of BHP's requirements for vaccines to be applied to those entering their site. Are you able to comment or provide some information to me on that case just before I launch in?
This decision stands for itself. Senator, it's publicly available on our website.
Yep.
I understand the nature of the decision, but in essence, it's not my position to talk to the, I suppose, the content or the substance of those decisions.
Well, I suppose, I mean, you decide whether you can or not. I've got the decision in front of me here, and just quoting from the decision on pages 3 and 4, the decision at paragraph 15 says that with respect to the second category of findings, the full bench in Mount Arthur Coal found that the following uncontentious factual propositions were established on the evidence, and I won't read them all, but that particular one relevant to me is point 8. While other measures such as mask wearing and social distancing are demonstrated to reduce the transmission of COVID-19, the effectiveness of these measures depends on people applying them consistently or correctly. They do not provide a substitute for the constant protection offered by vaccines, nor do they reduce the risk of developing serious illness once somebody acquires an infection. Point 9, vaccination is the most effective and efficient control available to combat the risks posed by COVID-19. My first question on those statements is, what did the Commission or Commissioners seek external health advice about the validity of those conclusions? Or were they just accepted facts, if you like, and weren't explored in terms of their validity?
The decision of the full bench stands for itself, Senator. I think that there would be information available on our website about any documents that were submitted in relation to that case. If there's not, if they've...
Well, I'll just be more specific.
I mean,
in fairness, I think these are simple questions you might be able to provide some light on. I realise some of them might be in the deep, dark depths of your website, but I just simply wanted to ask, I mean, did the commissioners, or in this case, take any evidence from different experts, health experts, on these particular conclusions I've highlighted here?
I'm not aware if they did or if they didn't.
I think Mr Hare's got some information.
Sorry, and look, technically, Mr Furlong's role
is the head of the administration arm, and given the quasi-judicial nature of the commission, it's normally not appropriate to ask the administrative arm to make comments or try and understand the basis of the decisions from the commissioners, including the full bench. So when Mr Furlong is referring you to the decision as that stands for itself, he's really not able to seek to interpret it.
Well, I'm happy to take on notice, but I mean, this is a little bit strange given Mr Herro. This is a simple factual question. I'm not asking for the rationale or the reasoning. I'm simply asking, did health experts provide advice to the Commission in this case? It's a very simple question. Could someone take that on notice? Perhaps the department could? Or...
Yeah, I'm happy to take that on notice in terms of seeing if there's a list of witnesses or information provided.
Okay. And that, to be clear, that's in relation to points 8 and 9 listed on page 4, I believe, of the decision. And look, perhaps you'll take this on notice as well, but reading those two paragraphs, it doesn't actually seem to say or provide whether or not this measure, this vaccine mandate imposed by BHP is aimed primarily at reducing transmission and the risk to third parties of people who, or third parties from people who are not vaccinated, or whether it's simply actually a health measure that BHP is imposing on each individual to reduce the risk, because these two paragraphs both seem to mix the issue of transmission to third parties and, as I said earlier in quoting this, that the vaccines reduce the risk of developing serious illness. I mean, what was the objective of the PHP's vaccine mandate here, as interpreted by? Because I mean, I'm asking this question, Mr. Furlong, because I think you would need some kind of rationale to dismiss someone from work. That's your job, isn't it, or that's the job of the Commission? What was the rationale to dismiss someone? Was it to protect their own health or the health of third parties?
Mr. Furlong, if you're happy for me to take this. So again, happy to have a look at the decision to try and provide the clarity there. There are a range of obligations that an employer has under the work health and safety regime. In addition to the guidance provided on the Fair Work Ombudsman site. So my understanding of the obligations do go to trying to make sure that the employee's health is protected. Now, how that plays out is a complicated question which might well be better placed to Safe Work Australia, who've got the policy responsibility.
Okay, well, I might take it up with them tonight too, but just to give the rationale for why I'm asking this, I'm not seeking to double guess the decision. I'm really interested as a legislator to understand what the current law is, because as you just highlighted there, Mr. Hurrett, one interpretation here is that somehow an employer has the right to dismiss someone if their health or medical choices are not in the best interest of that person, in accordance with the employer's views. Now we're particularly rating... Hang on, Senator Pratt. I know you don't want to defend workers. You wanted to see them dismissed. None of you have said anything in support of the CFMEU on that side. You haven't. None of you have supported the CFMEU here, but it seems to me we're going to dangerous territory where an employer could hang on, Mr. Herrick, an employer, what I'm reading from here is an employer could say, look, cheeseburgers are bad for your health. If you eat cheeseburgers, you're not allowed to work at this site. You can be dismissed. That's where we're heading here, if this is more than just about transmission.
So the legislation is a workplace legislation, or
yes.
So it doesn't extend into someone's personal life.
Well, you wouldn't have thought so.
But so it is constrained to the workplace, recognising that's broadly defined, covers a wide range of workplaces. So the cheeseburger example may not be relevant. But again, I think Safe Work Australia are best placed to answer the detail of that. But certainly there are limits on it, and it is constrained. And it is the obligation is to make sure that the not just the employee, but others in the workplace are safe.
Well, look, I'm glad to hear that. I would have thought that would have been my interpretation of what the law should be, or probably would have been. But as I mentioned here, that those particular quotes I read out do stray into saying that, look, COVID vaccines can help protect someone from serious illness, and that's not something I dispute. But I just wonder what the relevance of that particular fact is in regards to a workplace standard, when it's more akin, the issue of whether a vaccine stops you from developing a serious illness is more akin to a personal health choice rather than one that necessarily involves risk at the workplace itself. Does that make sense where I'm going with that?
I understand.
Any information you could provide for me on the current state of the law, is it because I'm just interested in that, where the laws are at and if they truly protect workers?
Yeah, so I would refer you to Safe Work Australia.
Okay.
They're the national body.
Yep.
And they'll be able to talk you through.
Thank you, Mr. Hare. Who am I? I might just get an indication of how long, because we have a dinner break scheduled in 5 minutes, so that might determine.
I could finish off my questions in relation to cancellation of EBAs, and then I think we'd be ready to come back to other issues with the Commission.
So you still have the Commission after the break?
Yeah.
So how long are these next set of questions, I suppose? Is a little bit late.
We're breaking at 7:15
6:45 is the original schedule, but how long do you think your next set will be? If they're 10 minutes, that's fine.
Can we go till 7? Do you reckon we'll get through appointments in 15? No. Do you want to go to dinner now?
We should probably go to dinner.
Okay, well, let's...
Let me finish off just very quickly on cancellation of...
All right, okay, we'll keep that to 5 minutes or so. We're on schedule. All right, thank you. Senator Pratt.
Okay, are you able to tell us when a commissioner makes a decision about whether to agree to cancel an EBA? Is it done by negotiation, or do they make their own decision considering all of those factors?
As I provided in evidence, section 226 of the Fair Work Act goes to the considerations that the commissioner or the member of the commission is required to take into account. Those being the views of the employees, each employer and each employee organisation, if any, covered by the agreement, and the circumstances of each of those employees, employers and organisations, including the likely effect that termination will have on each of them.
Okay, so you don't need agreement of the parties to make that decision. You listen to them and then you make your own decision as the commissioner.
And it's terminated on the basis that the commission is satisfied that it's not contrary to the public interest to do so.
Okay, but the termination might include conditions on it that mean you're not just left with the award, you'll have some variation that have been put in place by the commissioner.
That's right.
Okay, and are you able to give us data on those variations in terms of how they vary from the original EBA or the award?
Each of those decisions is publicly available, but given the
has anyone done the research
to
do that?
Applications. No, we certainly haven't. It would be our position to do that. There's over 300 applications every year. That would be a very significant undertaking.
Okay, and can I just ask very quickly, when you have an application that's not contested, do they all automatically revert to the award, or is there agreement to vary conditions that would be put in place by the commissioner?
It's impossible to talk in the abstract.
I'm just asking about the existing decisions. All of the uncontested applications where it has been reverted to the award. Well, an application has been made but not contested.
Very few of the agreement applications or to terminate agreement applications are contested. We're talking about a very large number of agreements here.
Yeah, the very large
and
number.
A lot of agreements, yeah.
Sorry, just they're not contested, so they are. By that you mean most of them revert to the award without any hearing? Okay, what do you mean?
A lot of agreements are terminated. A lot of agreements are terminated, but they're replaced by another agreement.
They're not the ones I'm talking about. Okay, thank you. So they're all contested other than the ones that are replaced with another agreement.
I'm sorry if I've confused you there, Senator.
Yes,
of
you
the
have.
applications that we receive to terminate enterprise agreements, very few of those applications are contested. The vast majority of them are not contested. There can be a number of reasons why an agreement is terminated. It could be that there's no more work for it to do as well.
Okay, so it's expired and you're in a new EBA negotiation, or there's already a new agreement to replace it. Where there's an application to revert to the award, can you explain where are they all contested? To unilaterally.
I'm sorry, Senator, I'm having trouble understanding your question.
So it's all of the other circumstances where an agreement expires, it's not contested, and therefore it's not seen to be unilateral. Okay? In these cases, you've got an application to terminate agreement to revert to the award, specifically, without the consent of the people who are subject to that EBA. Are you able to give us the data on how many of those applications are accepted without there being any variation in the ultimate outcome?
I can take that question on notice, Senator.
Okay. Is it possible in those circumstances that you apply to revert to the award, it's not contested, but the outcome is for something other than the award? I'm assuming it would go to the award unless a case was made to vary it.
It's the discretion of the member of the tribunal that's dealing with the termination application.
Okay, thank you.
Is that, we're ready to break
Yeah.
then? Great, we're on roughly time. So just to be clear though, I believe we're asked to need the Fair Work Commission back after dinner. That's true?
Yes.
Yes. So we will just break now for dinner though, and reconvene at 7:45.
Thank you, Chair.
We'll suspend the committee. For those online, we'll recommence the additional estimates of Education and Employment Committee. We are continuing with the Fair Work Commission and Senator Sheldon.
Thank you, Mr. Phil. Team joining us. I just want to go to casual conversion and some of the impact on casual conversions, but regarding some information, just some factual information. How many disputes has the Commission dealt with in respect to the new casual conversion provisions?
For the period 1 October 2021 to 31 December 2021, we received a small number of disputes about casual conversion, 25 in total. 13 of those were award agreement reliant employees and 12 were award or agreement free employees.
And that was, I just missed the, might have been my hearing, but I just missed the original figure you gave us. Was it 100?
No, 25, Senator.
Right, 25. Thank you. What was the nature of the disputes, for example, where the challenges to reasonable grounds or eligibility or anything else?
Ms. Legg will be able to assist you with that question, Senator.
Thank you.
Senator, I don't have information about the nature of those disputes. The disputes are dealt with as part of a conciliation, so it doesn't generally go on the record.
Is there a possibility there may be some there may be something in writing about the nature of the disputes that something in writing that we can peruse. Like, is there some analysis you can do? I appreciate the fact that what you said about matters that are in conciliation and the way conciliation operates. But are you able to give us any other detail?
Senator, we may be able to look at the forms that were lodged about the nature of the dispute, but I'll have to take that on notice and see if we're able to provide that.
Thank you very much. Noting that both parties have to agree, which makes it highly unlikely, but has the Commission been asked to arbitrate any matters relating to casual conversion?
No, Senator.
Is there any information available as to whether any employees have assessed the small claims process within the federal court?
Not to my knowledge, Senator.
Do you have any observations of the way the new casual conversion provision is operating?
That wouldn't be for me to comment on, Senator.
Minister, would you like to make any comment about how you see the casual conversion provisions are operating?
No.
So you may, in fairness to you, Minister, you may have been in other estimates hearings, but from the Job Security Committee inquiry, there was of 30,000 casuals, there was only 3% that were offered casual conversion. And in a number of instances, including universities and New South Wales TAFE examples were given, where there was no offer made. And in some cases, in the case of New South Wales TAFE, there was many, many thousands, running over 7,000. So have you any observations about the new casual conversion provision and how it's operating?
Just before you answer, I think it's in fact, but given the Minister wasn't here this morning, those statistics were the subject of a significant debate, particularly around the eligibility of those 30,000 to meet the requirements of the casual conversion clause. I believe you might have, I think you did this inadvertently, Senator Sheldon, the 30,000 were just one employer, weren't they? They were
No, they were a combination of employers. We went through universities, TAFE, and many other employers.
Well, there was some conjecture this morning, Minister. Obviously, you probably didn't see that, but I think that context is important. Over to you.
I don't think no one was conflicting with the total figures. There was a discussion about how those figures could be read.
As I said, whether they were eligible, I think Mr Hare went at length at that if you wanted him to provide for more further context, Minister, but we did go over all of this morning.
Look, I will throw to Mr Hare in a minute, but my initial decline of the opportunity to comment on them is based on the idea that some of the information that you supplied would need to be verified in order for me to be able to comment on it usefully. If you want to give me that detail and I'll take it on notice, I'm very happy to do that. But my understanding is that things like, for instance, TAFE are state-based. They are, arguably not eligible just at first instance, but I'm very happy to delve in there if you're prepared to give me the detail that's necessary in order to do that in a fair and in context kind of way. I'll throw over to Mr Hare to
Minister,
to add his... let's finish our answer
so
first.
we might give Mr Hare.
Mr Hare, can I just, Chair, if we're going to appreciate Mr Hare will have an answer, but if the answer's the same one he gave earlier, we've already got it on.
Okay, that's fair enough, but it is also fair enough to point out that you asked that question this morning as well. So,
and
these are questions now for the Fair Work Commission.
It is appropriate. Sorry, Chair, I didn't mean to cut you off.
I'm not going to tell you what you can or can't ask, but I think the Minister's perfectly reasonable here to take it on notice or flick to officials, given these are questions for the Fair Work Commission and that question you just asked is not that relevant to the Fair Work Commission itself.
In light of the figures that were just given by the Fair Work Commission, Minister, do you think the casual conversion arrangements are working?
If you have evidence to suggest that it's not working, I'm happy to take that on notice and respond to it. But based on what I have before me at the moment, the casual conversion provisions are operating as they should and for those who are eligible to use them. If you have evidence to the contrary, as I say, I'm happy to engage constructively with you, but that's not what I have before me at the moment.
The only comment I was going to make was the legislation, as I've said before, requires that a review be undertaken. That review will commence shortly after late March. It can't commence before late March, and we'll look at that. We'll look at the range of evidence and provide advice to the minister at that time in terms of what the review finds. I think it's hard to speculate on whether the fact that there's been 25 conciliations around or disputes lodged with the Fair Work Commission indicates whether it's working well or not. So at this point in time, certainly the department's preference is that we undertake the review that the legislation is required, as the Parliament clearly intended us to do, and that we provide the evidence from that review to the relevant minister.
Thank you. Mr Hare, just appreciate the Minister is going to now take into account and come back as a matter of on notice on the evidence that was given earlier about whether the casual conversion is working effectively in light of the evidence that was given.
I need you, just to be clear, to provide to me with some clarity.
I will give you a question on notice.
Thank you. That's what I've asked for.
So that I just said I would do. Thank you.
If you would do that, that would be
Now,
great.
how many vacancies are there in the Fair Work Commission, Mr Furlong?
It's currently 45 primary appointments to the commission.
So 5 vacancies? Yep.
No, that's...
No, sorry, Senator, there are 45 primary appointments. At the moment, the Fair Work Commission is funded for 44, but in the coming weeks there are 2 members who are due to retire.
Thank you. Where is those retirements likely to, what locations are they likely to come out of, and where is the one vacancy, as I understand it, that presently exists? This location?
In terms of the retirements, there is one in Sydney, one in Brisbane, and one in Melbourne. My understanding is that should there be an appointment, because we'll move back to 43 primary appointments, I understand that it would be at the commissioner level in Sydney.
Are you expecting more appointments to be made before the end of May this year?
Appointments of members to the Fair Work Commission are a matter for government.
Thank you. Minister, do you expect there to be more appointments to be made before the end of May this year?
That's a matter for Cabinet.
Is the President consulted on appointments, Mr Furlong?
I'm not aware of those. I'm not across the conversations that the President may or may not have with the Minister or the Department.
Mr Hare, could you...
There's no requirement in the legislation for the attorney to consult with the President. I think that would be up to the individual practices of relevant ministers.
Is the President able to indicate any areas of expertise, Mr Hare, that the Commission needs for future appointments?
Yes, the President is able to communicate with the Minister, of course, and does identify either locations or areas that he may need additional commissioners to focus on, but again, that's a matter for the President.
Minister, I note in the public media comments, the Australian Mines and Metals Association said, and I quote, "It strongly encourages the government to make further appointments in the new year with additional funding provided in the March federal budget if necessary." Minister, are you taking instructions from the Australian Mines and Metals Association?
No.
Thank you. Can we therefore expect to see additional appointments made soon, or and an above inflation increase in funding for the Fair Work Commission?
That's a matter for Cabinet.
If we do see additional appointments and extra funding, can we therefore assume that you'll follow the instructions, or the Cabinet has followed the instructions of AMA?
Well, this is ridiculous. Of course not. We make our decisions in the interests of the Australian people, and that never changes. And you know that full well, Senator Sheldon.
Minister, can you remind the committee when the most recent appointments were made?
Take that on notice.
Mr. Here, can you inform us?
Sorry, I need to check the exact dates. They were relatively recently, Senator, but I can check that.
Would it surprise you that it was the 18th of December 2021?
So as I said, they were relatively recently. I was on leave at that period, but no, that doesn't surprise me. It was recently.
I think someone's just giving you some...
16th of December, commencing on the 18th of January, for Mr Bell and Ms Multani to commence on the 21st of February.
So the Fair Work Commission was aware you would be making the announcements, that the announcements would be made on just before Christmas?
Again, the communication between the relevant minister and the president is something that they would engage in. I wasn't there at the time, so as I said, I was on leave. I'm happy to take on notice what the communication process was.
Thank you. Are you aware that you say that the appointments were made on the 16th of December, but a press release on those appointments was made on the 18th of December?
That's, as I said, I wasn't at work at that period, but certainly the appointments were the 16th, but there may well have been a press announcement on the 18th.
So the minister, on the 18th of December, the minister, that was a Saturday. Are you aware of that?
Not off the top of my head, but if you want to tell me that that day was a Saturday, I'll take your word for it, Senator Sheldon.
Thank you, Minister. So the release was put out in the afternoon of Saturday. Was the Fair Work Commission aware that you would be making the announcement on the Saturday afternoon before Christmas? I just want to be clear about that.
I've taken that on notice, Senator.
Mr. Here, Minister, were you aware of that?
I wasn't, but in relation to the minister, I'll take it on notice. Yeah, I'll take it on notice.
Could I just sorry, I put this in a slightly different way. Doesn't it seem to you that, Senator Stoker, that why would you sneak out an important, why would a important announcement like this be snuck out on Saturday afternoon the week before Christmas?
It's an odd characterisation. I'd suggest that it's an indication of how hard the attorney works, and that this is not an announcement of some unusual nature, but rather it's the routine, ordinary work of government to appoint people to the posts that are funded by governments. And as somebody who's familiar with media matters, like you, Senator Sheldon, Saturday isn't a day when one takes out the trash. It's where one celebrates big things for the Sunday papers that everybody buys. So any suggestion you've got that there's anything sneaky going on here is utterly confected.
Well, thank you. Thank you, Senator Stoker, for giving that observation. There's clearly, we have a press statement put out, snuck out on the Saturday.
It's not snuck.
It's the week before Christmas, which is the Saturday before Christmas. So, you know, is this, surely this is a, when you consider that there was also appointments that, noting the previous of 4 appointments were announced on Good Friday in 2021. So doesn't this raise concerns about how this, you know, with Good Friday, you say Good Friday on the basis of your analysis of how media operates, you say Good Friday would be a good day to put out appointments and notification, or is the government just trying to hide some of these poor appointments they've been making?
I utterly reject the premise of your question. The announcements that were made in the usual way, following the usual process of appointments, to the letter. And any kind of insinuation you would like to give that it had some other kind of nature is something I reject entirely. The appointments that were made are outstanding appointments, and I'm very happy to stand by that.
So Saturday before Christmas, when people aren't around, is not taking up the trash. And you say that, I'm using your language, now you're saying that Good Friday in 2021, where 4 previous appointments were announced, is not taking up the trash either.
Of course not. Over the Easter long weekend, people have time to read papers in a way that they don't for the rest of the year. And quite frankly, I'm disturbed by the idea that you might have clocked off entirely in that week before Christmas when the rest of us were all still working hard.
Oh, that's a very interesting response, Minister. Quite clearly,
the rest of the country
quite
was still
clearly,
hard
you're
at
very
work.
desperate to lay some sort of responsibility somewhere else.
Everyone who works at a petrol station, a shopping centre,
right.
a Coles or a Woolworths,
Chair,
You're out of touch, Senator Sheldon. Out of touch.
That's enough. Order.
Out of touch.
We'll get back to questions,
So when
please.
I'm
Senator
going to
Sheldon.
just define. You can define me when taking up the trash is. You use that language. You said taking up the trash is not Saturday. Now it's not Good Friday. What's taking up the trash?
We don't have any to take out because we make
All right.
great appointments and we make them using the usual process as we did in every appointment to this
Minister,
agency.
I'm asking you a question that evidence you gave. You said that there is opportunities to take out the trash. What would you describe as the appropriate time to, using your language, take out the trash?
You suggested that we were trying to hide something nefarious, something not good. I would suggest that taking out the trash is announcing something not good. But here we have reason to celebrate because these are outstanding appointments made using the usual process, and I will not have you disparage the good work that they are doing and the good work of the agency, and indeed the good work of the Minister who has followed the protocol to the letter.
And we've been dealing with some of the good work from some of those appointments that this government's put in over the last number of estimates. So I just want to then just remind you that your suggestion that on Saturday, it was actually Saturday afternoon that it was put out. It was the latter part of the afternoon when this press statement was put out. Obviously, it's again trying to miss coverage.
I
taking out the trash.
suggest it's proof that the attorney works hard, including all weekend.
And it sounds like someone's taking out the trash. That's right.
I didn't say that.
Minister, is it not
You
the
said
case
that.
that your appointment, Teresa Maldini, was formerly the head of Labour Hire Company WorkPac?
I'll take that on notice.
So, as the minister repping the minister, as the assistant minister, you're not aware that Teresa Maldini was formerly the head of Labour Hire Company WorkPac?
I'm happy to look up in my brief, if you'll give me a moment, her details, but I know that she's highly qualified in the area and is more than equipped to do the work that is required in the job description for this position.
This is the same Labour Hire Company notorious for undercutting the wages and conditions of hundreds of workers in the coal mining industry.
That's your characterisation, and I reject that slur.
Minister, can I just ask you again, are you planning for any, Acting Minister, are you aware, Assistant Minister, thank you. Are you aware that there are planning for any more appointments before the federal election?
That is a matter for Cabinet, as I said earlier.
So I guess it's getting close to Easter, which I probably should keep an eye out for them because it usually happens on that very busy day of Good Friday, where everyone's eyes are. Large numbers of people are actually going. Large numbers of people are actually going to services, but they're all busy, in your view, looking at the paper, and Good Friday's not taking up the trash.
Well, I didn't say that at all, and you can verbal people as much as you like. It doesn't make it the case that that's what they said. The next thing to say is one instance doesn't make a pattern. The mathematical definition of a pattern is 3, and I do not think you can possibly evidence the notion that it has happened 3 times on a Good Friday. The third thing to say is that, going back to your criticism of Ms Moltoni, I won't wear the notion that she is anything other than a highly credible choice for the job. She's been director of a law firm specialising in this field. She's been president of the Queensland Chamber of Commerce. She's been a CEO of WorkPac, and she's been awarded, wait for it, Senator Sheldon, the Medal of the Order of Australia for services to, wait for it, industrial relations. She's highly qualified for the job, and I won't let you disparage or defame a very capable woman under parliamentary privilege.
And working for a company that undercut the wages and conditions of hundreds of workers in the coal mining industry
premise
in
that I have
central and
rejected.
northern Queensland. So I just want to turn to the department. Can you advise how many appointments to the Fair Work Commission has been made since September 2013?
I'd need to take them. I sort of don't have that in front of me, Senator.
Mr. Furlong, is that something that you would have at hand?
I don't know that information at hand.
Thank
As
you.
I stated, appointments are a matter for the government.
Mr. Hare, if you could take that on notice, thank you.
Yes, Senator.
Can you advise how many employee representatives appointments have been made to the Fair Work Commission since September 2013?
Senator, I'm happy to have a look at that. Recognising, of course, that appointment to the Fair Work Commission means that members put aside any of their previous roles and undertake to operate in accordance with the law and the evidence that's placed in front of them. So they're certainly not, the requirement is that they don't bring their previous roles beyond their expertise into the Commission in their decisions.
Very good point,
But
Mr. Hare.
happy to have a look at the backgrounds and provide you information on the background of the appointments.
Thank you, Mr. Hare. For the record, are we aware of any forthcoming appointments to the Fair Work Commission?
Senator, the Minister's answered that, which is that's a matter for Cabinet.
Are you aware of any discussions about forthcoming appointments to the Fair Work Commission at all in any fashion?
Senator, that's a matter for Cabinet.
You've asked the same question 4 forms now, Senator Sheldon.
Thank you, thank you, Senator Soka. If you want to answer the question, then that's fine. Thanks for your
I've already
thanks for
answered
your commentary.
it twice.
I've got no further questions. Thank you.
Okay, thank you. And are there any further questions for the Fair Work Commission? Going.
I think we've done casual conversion, done appointments, we've done that, haven't we?
You're right. I think you're right to start off with the
I
next
beg your
one.
pardon? Yeah, okay. I've got one more bracket, thank you, Chair,
Okay.
just that I'll do as quickly as possible.
possible.
At last estimates with respect to Fair Work Deputy President Lyndall Dean, her anti-vaccination views that caused her to be reprimanded by the President of the Commission and to take the step of writing to the Minister. I just want to follow up on that matter, given the seriousness of writing to the Minister. Can I confirm that Deputy President Dean is still hearing cases?
She is, Senator.
Can you outline the sorts of cases that Deputy President Dean is permitted to preside over?
Most of the information about this matter is now on the public record, Senator. The Commission described the substance of the letter from the President to the Deputy President and obviously the subsequent sort of letter to the Minister in its response to a question on notice. I think that too is EECSBE 21-045. In that question on notice, it outlined that the President concluded that the Deputy President's conduct constituted a misuse of her statutory office, and that as a result, the Deputy President had been directed to attend training on the responsibilities and standards of professional conduct expected of a member of the Commission once a suitable course was identified, that she be excluded from any further bench work, at least until she has completed the training, and finally that she's disqualified herself on the grounds of bias from adjudicating disputes relating to workplace vaccinations in the future. In response to your direct question, regional coordinators who allocate the work to the Deputy President being requested not to allocate the Deputy President such matters, and that the Deputy President is to inform the President if a dispute of that nature arises in a matter that's been allocated to her.
Thank you. I'm assuming all the requirements as outlined in the letter from the President have been met? You've highlighted,
Yes,
I think,
that's my
some of them.
understanding.
How many
That's my
matters?
understanding.
I beg your pardon?
That is my understanding, yes.
Okay, if you can let us know if there's any variation to that on notice. How many matters has Deputy President Dean presided over since being cautioned?
In terms of the allocations, specific allocations, and providing information on the allocations of matters to individual members of the tribunal, there is High Court authority on this. But in essence, the Commission has held the position that information of that nature may go to the essential independence of the tribunal. So, if you don't mind, I'll take that question on notice, please.
Thank you. I think you referred to the letter. I don't have it, but I know we have an outline of it. Is that correct? Can I ask if you are able to table it, or was it provided in the answer to that question on notice?
The substance of that letter was provided in that question on notice, significant detail.
If I might ask the Minister if you're in a position to table that letter?
I'll take that on notice. Again, I'd like to consider the authorities on this in terms of ensuring that we maintain the independence of the members of the Commission, so I'd like to take advice on that.
Okay. Did Minister Cash provide a written response to the President of the Fair Work Commission to the President's correspondence to the Minister?
I'm not aware of that correspondence, and in the normal course of things, communications correspondence between the Minister and the President would not.
And what about the department? You're able to inform us about the fact of correspondence, even if you don't tell us what was in it?
I need to check that, Senator. I don't have that in front of me.
Okay. If you could take on notice what advice was, what was said in that letter, if such a letter was provided. Is the government now satisfied that since this incident, that Ms Dean has conducted no further breaches or misconduct?
So the President is responsible for the running of the Commission, and he's indicated, and you've seen an outline of the actions that he's taken. The President hasn't referred this matter to the Minister, and as Mr Furlong advised, our understanding is that all the requirements that the President put in place in relation to Deputy President Dean are being complied with.
Okay, given the seriousness of that caution and that misconduct, has the government made it clear to the President that it expects to be informed if there are any other breaches or findings of misconduct?
The President of the Fair Work Commission is an independent statutory officer with judicial status.
I understand that, but that doesn't prevent the government.
The ability to direct him is limited. I'll take that on notice in terms of whether there's been any requests
to be informed
to the President.
What I can add, Senator Pratt, is that at the last estimates, the attorney said that she would raise the matter with the President. She did that on the day after estimates, and so.
Okay, as the Assistant Minister for Industrial Relations, Senator Stoker, do you have confidence in Ms Dean's suitability to hold office as a member of the Commission?
Until I am presented with information to the contrary, I have confidence in all of the members of the Commission.
Notwithstanding the previous findings of misconduct and breaches in standards?
Look, I understand all of the things that you've said. That's a framework that is there to drive improvement. She's not the only person who has had matters like this raised and dealt with over time. Those are there not to witch hunt, but to lead to the resolution of any problems. I am instructed that has had the desired effect, and I've seen no problematic evidence since. If you have problematic evidence that I need to know about, by all means share it with me.
Thank you. May I ask Mr Hare, has the Minister, the member for Pearce, the former Minister, received any other letters of this nature from the President with respect to any other Commissioner or Deputy President?
I'd need to take that on notice, Senator. I'm not aware of any, but I'd need to take that on notice.
Okay.
Sorry, I should say, I'm not immediately aware of anything.
I beg your pardon?
I'm not immediately aware of anything. I'll need to go back and check.
Thank you. Have all inquiries and reports into the behaviour of Deputy President Boyce now been concluded?
Senator, since the crack of the fireworks incident in December 2020, there haven't been any issues reported about Deputy Boyce.
Has Mr Boyce completed all requirements imposed on him by either the President of the Commission or any other authority?
Comcare made an inspection, and while they did not find any contraventions of their assessment was that there were no contraventions of the WH&S Act in relation to the incident. The report has been tabled by Comcare, and it's the question on notice number is EEC SBE 21-081. Comcare, the Inspector of Comcare made a series of recommendations, and each of those recommendations have had significant remediation work. In short, yes, Senator.
Okay, so they've had significant remediation work. Have those requirements from Comcare and the President all been completely fulfilled? What is still outstanding?
Comcare provided an audit late last year in relation to our response, and my understanding is that there is a further piece of work that needs to be concluded there.
What is that?
We provided them with information. Well, we used the opportunity to provide them with a significant number of documents about how we've responded to it. My understanding, and Mr Lambeck may wish to correct this, is that they're currently assessing that, and they'll come back to us with to provide some information on the adequacy of that response.
Okay, thank you. Are there any new matters involving Deputy President Boyce, or have there been any new or further complaints about him?
No.
Has everyone from the Fair Work Commission now received training on the Code of Conduct?
Yes, that occurred from memory in July last year.
Okay, we're nearly done. How much what's the current workload of the Commission relative to times past and the resources you've got to meet that?
In the applications that were received for this year to date are slightly lower, but commensurate with our workload over the past 5 years.
How much of the Commission's...
So it's consistent, essentially it's consistent.
Substantially the same. If you say it's slightly lower and yet unemployment is purportedly lower, what do you put that down to?
Our internal research indicates that there is some correlation between the strength of the labour market and applications for particularly individual rights-based matters relating to the termination of employment. But in general terms, while there are some sort of peaks and troughs over the course of the reporting cycle, the workload that we have at the moment, so far this financial year, is ever so slightly lower, but largely consistent with our 5-year average.
Thanks. How much of the Commission's time is currently spent on vaccine-related matters?
with unfair dismissal and general protection applications, we've seen a significant amount of applications that were made as vaccination mandates came in. They are very well progressed. They're moving through the system, and we anticipate that that workload will be resolved, ultimately be resolved in the very near future. Just the other Senator, that we are currently meeting all of our portfolio budget statement KPIs across the three metrics.
Thank you. And if you're able, potentially on notice, to give us a breakdown of the matters, the variety of matters and the proportion of workload that they occupy in broad terms, that would be terrific. And I think that is us done with the Fair Work Commission. Thank you, Chair.
Thank you, Senator.
And thank you to the Commission.
Yes, thank you, Senator Pratt. Thank you to all the officials from the Fair Work Commission. You are now released. We will move to our next witness, which is the Fair Work Ombudsman. Do we have those officials close by? Or?
Yes, they're just...
Okay, we will suspend for a brief period. And I welcome officials from the Fair Work Ombudsman. Ms Parker, do you have an opening statement?
No, I don't.
Okay, thank you. And I will go straight to Senator Rennick.
Hi, and I hope I've got the right department here within Fair Work Australia. My first question is, how can Fair Work Australia morally justify the mandating of vaccine by employers in the private sector and Commonwealth employees, which goes against the explicit statement in the immunisation handbook that people cannot be coerced into taking a vaccine?
Sandra Parker, Fair Work Ombudsman. Thanks for your question, Senator. So I'll just unpack that a little bit. So employers, there's certain, so I'll just explain our role. It might be useful. So we provide quite a lot of general information on COVID testing. We do provide information to the public on vaccines, rapid antigen tests and workplace laws. And we also work with Safe Work Australia and of course there's quite a bit of overlap there with TGA and so on around this area. And you're asking about employers requiring staff to be vaccinated, is that correct?
That's correct.
Yes. So,
in the context of what the immunisation handbook says, that people can't be coerced into taking a vaccine. So we've got, to me, what may appear to be two conflicting laws, or the employers are acting against what the federal government's representing through a contractual statement that you can't be coerced into taking a vaccine.
Okay, thank you. So I'll try to answer and let me know if you need more information. So employers can only require employees to be vaccinated where there's a specific law, such as a state or territory public health order that requires an employee to be vaccinated. So that's your first point. So you've obviously been talking to some employees or employers. It would be useful to check, where they are. They can also require an employee to be vaccinated where the requirement is permitted in an enterprise agreement. So it's been negotiated and ratified, if you like, by the Fair Work Commission. And they can also require an employee to be vaccinated where there's another, like an employment contract that says you need to be vaccinated. So an obvious example is in the health sector where part of requirement... And the other way that an employer can require employees to be vaccinated is where it would be lawful and reasonable for an employer to give their employees a direction to be vaccinated, and that is actually case by case. So it's difficult to sort of answer a specific question.
Well, can I just stop you there if you don't mind?
Of course.
Where say lawful and reasonable, given that we now know that the vaccines don't stop transmission, and we know that people can get injured from the vaccine, surely the employee has the right to say no to a vaccine that doesn't stop transmission because their risk of spreading it's no different to a vaccinated person.
We do take a case, so it's a case-by-case approach.
Sure.
So if there's a specific health order, for example, that says in these sectors, and that's what's been happening over the period of COVID.
So I was referring so the initial question was in regards to the private sector and Commonwealth employees. I understand with state sectors, state-run public hospitals, that's going to be state law.
Yes, but sorry to interrupt, but if in the ACT, for example, there's a lot of Commonwealth and other, but the ACT law applies, doesn't matter what type of employee you are. If you're in the ACT and there's a public health order, you have to follow that public health order. So we here in Parliament House are following the ACT public health order. I mostly work in Melbourne, but I'm following the ACT order while I'm here in this building. So if an employer, so another fact I suppose is it's one of the things that an employer can do to keep a workplace safe. It's not the only thing. So what we advise is that if employee doesn't want to be vaccinated or they're refusing, and it's a lawful and reasonable direction, and that is a case-by-case assessment. And what we advise as an employer to ask the employee to provide their reasons of why they're not wanting to be vaccinated or whether they're refusing to be vaccinated. If the employee has a legitimate reason, such as an existing medical condition, and therefore it's not recommended for them to have a vaccination, they need to consider whether there's other options to keep things safe. So it might be social distancing, might be mask wearing, could be a whole range.
Or taking a rat test before they go to work?
Potentially, yes. So, but if they refuse to be vaccinated and it breaches a law, including that it's a reasonable direction, which can be determined by a court, Fair Work Commission can get involved, then the employee is not able to argue against that. So they can do so, but they'd have to take it to court.
Right, okay. So let's just narrow that down to whereby an employee has taken a vaccine and got injured, and then they've still got sacked because they haven't had the both shots of the vaccine, which I generally get 5 to 10 of those constituents contacting me a week in that very scenario. And in a lot of cases, they've actually also been given a medical exemption, and the employer won't recognise the medical exemption. It's a blanket 2 vaccines or you're out. I fail to see how any jurisdiction can justify having forced the person to get the vaccine in the first place, then becoming injured, then turning around and expect the person to be injured a second time, or risking, taking that risk, which would appear to be, quite high if they've already been injured the first time. Surely, can the Commonwealth introduce a law into the Fair Work Act that says, protects the workers from basically medical harm about these vaccines?
Look, I would need to see the specific circumstances of the matter. So with COVID, with vaccinations, with the whole response to it, in terms of workplace arrangement, it has been very much a case-by-case arrangement. We've put out information on our website that talks about scenarios, types of workplaces. I'm not trying to be unhelpful, but it really is difficult to speculate. What I would say is if you have a list of people, as you say, we would welcome them contacting us. So we have a phone number they can ring, they can email us with their particular circumstances, and we will provide assistance. So we will get some advice for them. We'll find out what the circumstances are, and we'll give them advice on what they might be able to do.
Right, okay, thank you.
Senator Rennick, it might also be helpful for anybody listening at home to know that the government's position is that vaccination is encouraged, but it is a decision for the individual, and it shouldn't be forced upon them. And it is inherent in the Fair Work Ombudsman's advice that a requirement to be vaccinated would only be lawful and reasonable in pretty narrow circumstances. And so those people who find themselves faced with this requirement would need to be confronted with evidence of the ways in which it is lawful and reasonable. To the extent that that gets overridden by state and territory laws, that is itself out of the federal government's remit, but the guidance that's been provided from the federal perspective really does ask that employers balance the reasonableness of what they're asking against the reasonableness of any concerns that an employee has, and I hope that that would deal with the circumstances of the people who are coming to you and raising their anxieties or past experiences.
Yeah, thank you. Just one question in regards to that. Given that we don't believe in mandates, the federal government, why don't we just turn around and tell the state governments to buy their own vaccines and tell the employees to buy their own vaccines and let them indemnify them?
I think that might be going beyond the remit of this committee, but Minister?
Look, it's probably a bigger question than that for the Fair Work Ombudsman,
Sure.
but I know you're passionate about this issue, and I hear the frustration. There has been some really draconian measures taken by some state and territory governments.
Yeah, thank you.
Perhaps if I could just ask the Minister one question in association with Gerard. Thank you. The states would not be able to do it without the federal government's enabling them to do it. So where do we take those issues? Because I'm right behind Gerard.
Again, I'll just make the point here that some of these matters, I think, go beyond the industrial relations framework we're talking about here. But Minister, you can answer that to the extent you can.
They do go beyond the remit of the Fair Work Ombudsman or indeed industrial relations. Your question suggests that we're enabling, and I'm not sure the means by which you say we are enabling.
About 10 identified. So we can have
well,
a long
maybe you and I
discussion.
can take that offline. But look, I think it is an accurate assessment of constitutional law as it currently stands to say that matters of public health are dealt with by the states, and that has been the case for some time because they are the frontline agency that delivers matters in relation to health. It's true that the federal government has been involved in procuring vaccines and making supply available to states.
And regulating and indemnifying.
Yes, and regulating and indemnifying, all of that is true. But I don't accept the premise of your question that says there's 10 ways to stop it by enabling. But I'm happy to take that offline for you and me to chat
I didn't say there
about.
are 10 ways to stop it, Minister. I said the federal government has enabled in the list I've managed to get about 10 items that enable 10 ways of enabling the states to do it.
Okay. Sorry, I didn't mean to
No, I know that's
to
sincere.
misstate what you were after.
Okay, sorry, can I just... I'm going to ask a few questions as Chair. I'm happy to come back to Senator Rennick, but before we go round and round, Ms Parker, I had some follow-up questions from Senator Rennick and from the Fair Work Commission earlier. I believe you're the body that educates Australians on our industrial relations laws, etc., so you might be able to help me out. I'm a little confused here about whether or not it is reasonable for an employer to require, and I want to put vaccines aside here, Is it reasonable for an employer to ask, mandate, force, whatever word you like, an employee to take a certain medical treatment if the employer thinks it's in the best interests of the employee's health? Is that reasonable?
So I think, I mean, I do try not to answer questions where I have to kind of speculate. The way that we, again, not trying to avoid the question.
Yes, sure.
You're asking for an opinion on a hypothetical, aren't you?
I'm asking for an explanation of our current laws. I mean, we have a set of laws, a set of industrial
Don't
relations.
smoke at work because it harms other people.
That was not my... That's a very good analogy, Senator Pratt, so I'll take the interjection.
So
Absolutely, if there's a situation where someone's decisions is harming someone else at work, that is a different question. That's not the question I asked, though. The question I ask is would it be permissible under our industrial relations laws, so I'm asking about our laws, and you're the body that apparently educates Australians on our laws, is it reasonable under our laws for an employer to make as a condition of employment a certain medical treatment that is only and wholly of benefit to the individual taking it? No third-party effects, no spillovers. Is that reasonable?
So, look, most employees are employed under awards or enterprise agreements, or they might be employed as under individual contracts. In the awards and the enterprise agreements, they obviously negotiate certain conditions within those that have to meet safety net requirements, etc. I think it would be highly unusual to have anything in a contract that requires someone to take a certain medical procedure, but I would have to say...
Well, it's happening right now. It's happening right now. We can
So
bring it back to facts. Why I raise this? Why I raise this? Why I raise this here is because it seems to me in the Fair Work Commission decision on BHP, they do seem to be mixing this issue of, yes, on one hand, the COVID vaccine may stop transmission. That's one angle, and if you can substantiate that, there may be a case for mandates. But they also then mix it with this idea that, well, vaccine's the best way to stop people getting ill and going to hospital. Well, hang on. That, to me, seems to be going far beyond the rights of an employer to impose requirements on their employees as a condition of employment.
Yeah, so,
Do you see my distinction here about that?
Yeah, look, it comes back to the general answer I gave before, which is you can only require an employer to be vaccinated, or if you want to extend that to other things, that where there's a specific law, and I've mentioned state and territory public health orders, where it's in an enterprise agreement or another agreement or a contract, so you could potentially contract it, whether it
But
would
I'm
be...
particularly asked questions about that last leg you mentioned, the reasonable you mentioned,
so
so
we're-
going beyond the contracts
so if it,
or a voluntary agreement here, if there's no voluntary agreement between
so
an
in
EA
testing whether something's lawful or reasonable,
that's- yep.
it is absolutely a case-by-case basis, and I can't speculate.
Okay.
So in order to test it, on a case-by-case basis, it would depend on the circumstances. Now, that's an answer that's hard for people to hear, but there's no black and white.
There seems to be a lot of uncertainty here. I mean,
There's uncertainty, yes.
And I am personally concerned here about Australians' rights at work being trammelled on, their right to work, and their right to have not reasonable requirements placed on them in an employment context without their agreement. That's where I'm asking, without their agreement. Have you looked at the Fair Work Commission decision that involves the CFMEU and BHP?
In what context?
I presume that those rulings make up our law to some degree, and you've got to explain our laws. So I would have thought those rulings would be something you watch quite closely as the Ombudsman, because they would inform the advice you provide to employers and employees.
Yes, it is. So what we do is we do monitor very closely all the court decisions, and then we adjust our advice accordingly. So we've been doing that for a long time, but we've also been obviously watching this pretty closely during particular COVID situations. So yes, that
Perhaps someone can help me out. I'm happy for other officials to jump in. On page 4 of that decision, so this is just so I get the decision correct for you. This is the CFMEU versus BHP Coal. It was a decision made in Brisbane on the 21st of January by Deputy President Asbury. And on page 4 of that decision, they list a bunch of findings, they call them, and they say they're uncontentious factual propositions that inform the reasonableness of the BHP's requirements for vaccination. And in that, in point 8, they mention that alternative methods than vaccination nor do they reduce the risk of developing serious illness once somebody acquires an infection. And I look at that as what is the relevance of that to a decision on mandating, forcing people getting a vaccine? I'm not disputing the facts. Keep it put on the record. I believe that is the case. It is true. But is that relevant? Is that a relevant consideration now in deciding whether an employer can force an employee to take certain medical treatment?
So Fair Work...
Perhaps you could, look, I'm happy if you take this on notice. Time is late, and I realise this goes to complex law, but as I mentioned, I would have thought people at the Fair Work Ombudsman would be assessing these decisions and seeking to at least somewhat summarise them into usable
it depends.
Forms for employers and employees who do not have time to read through all the decisions.
I think time it might be fairest to Ms Parker to allow her to take it on notice. I think it's also fair to say that as a matter of general principle, it is right for an employer to make decisions that take into account the health and safety of others in the workplace.
I completely
It is
accept
right for employers to take into account the health and safety of customers, but it is not right for employers to make paternalistic decisions about what is best for the health of the individual who is the employer.
That's the point I'm seeking to make. Thank you, Minister. I think Senator Rennick, did you have some follow-up? Because I'm just mindful of. I might have.
Oh, no.
Is it quick? Because
yeah, it's just a quick one. Like, who should I direct that question to about the issue before around state powers in estimates? I mean, who's the department to speak to about that?
So it depends on which aspects, Senator.
Well, I mean, it was the one about why is the federal government, why can't we let the employer just buy the vaccine and let state governments buy the vaccines? Why are we indemnifying these people if we don't believe in what they're doing?
So that's Department of Health, would be my view, in terms of they're responsible for the purchase of the vaccines and they're responsible for the management of the scheme.
Yeah, okay, I'll go back to them. Thank you.
Okay, thank you, Senator Rennick. And we're going to Senator Sheldon. Thank you.
Good, thanks, Chair. Thank you for being here tonight. I want to go to some matters regarding the migrant worker exploitation and potential exploitation. Is the Fair Work Ombudsman currently investigating a labour hire firm which hires workers through the Pacific Labour Scheme or seasonal worker program called Regional Workforce Management?
I believe I may ask for some assistance here. Mr. Ronson?
Steve Ronson, Executive Director of Enforcement. I hope you can hear me. Senator, yes, I can confirm we are investigating.
Thank you. There was an article published in The Age on Monday this week which reported on some of the conditions experienced by workers at Regional Workforce Management, including, and I'll quote, "Workers brought to Australia by the labour hire company allege they have been placed in substandard housing, in some cases going without heating and smoke alarms. The workers also complained about unsafe working conditions, denial of medical treatment for injuries, and allegedly non-transparent wage deductions that left some with the pay rates of just $9 an hour." Is this a matter that the Ombudsman's investigating, or is it a matter of concern to the Ombudsman?
Well, it's definitely a matter of concern, as all those allegations and instances of exploitation are. And as part of our investigation into the labour hire entity you just referred to, we will be looking at all those issues that relate to, say, for example, unauthorised deductions that relate to their pay. So our jurisdiction is focused on, if you like, the industrial relations settings, their remuneration and so forth. And if there's anything that's unreasonable or unauthorised, we'll consider that and work out whether it's a contravention of the Fair Work Act.
Thank you. In the article in The Age that was titled "Pacific Workers Face Deportation Despite Probe into Their Employer," the article says that Home Affairs has written to those workers threatening them with visa cancellation and deportation because they have stopped working for Regional Workforce Management. Were you aware that Home Affairs was moving ahead with cancelling their visas while you had an ongoing investigation?
Senator, we were not approached by the workers because having saw that media article, we've done a check inside the agency just to see whether any workers or their representatives or supporters have contacted us. So that hasn't happened. If it had happened, we would have, and those witnesses, employees, were of assistance to our investigation or were part of our investigation. Our protocol is to contact Home Affairs to advise them of the same. So Home Affairs may not have been aware of our investigation or our interest.
Have you spoken to Home Affairs? Just not quite clear about this, these allegations.
I haven't. I'm not sure whether any of my colleagues have. I'm not sure. I can take that one on notice.
Just then, is there any, maybe to the Ombudsman, is there anyone within your team that has been in contact that you're aware of with the Home Affairs?
We'll certainly check and we'll do it urgently. Obviously, it's a key issue. As we said, we're investigating, and we do talk to them regularly, so I'd be surprised if they're not aware of it, but we'll find out as soon as possible.
Yeah, if you can come back to us on that urgent, I think as you rightly pointed out, it has a great deal of urgency to it. We've spoken in previous estimates that the assurance protocol, which is an informal rather than a legislated agreement that Home Affairs will not deport those who come to you for help. So is there any reason why, we're aware of any reason why the workers were being threatened with deportation?
Well, we're not aware of the threats of deportation, and that's what we'll certainly follow up with that. But yes, we do work closely on the protocol, and we find it to be effective. And we've found that every time we have referred a matter to Home Affairs where the protocols come into being, if you like, where we've said we're working with these workers, they're alleging underpayment and we don't want them to be removed, if you like, that's been the case. They have, and we've referred 77 to them under that protocol since we started it in 2017. And these visa holders, to our knowledge, have not had their visas cancelled. And they confirmed that in a recent, in your recent job security inquiry, that they've not had their visas cancelled. So that's reassuring. And of course, I think we mentioned too, we refer them only when we get their consent. So there's some discussions with them, but we do work closely. But 77 is quite a good number, I think.
Just in light of where, on the surface of what Home Affairs appears to have done in this particular circumstance, if that's correct, do you think that message that it sends to exploited migrant workers is a negative message about coming forward on exploitation and, in some cases, abuse?
Well, it certainly doesn't help, no. So I think, but as I said, it's not been our experience. So I'm surprised to hear that. If that's the case, we'll follow up. But it hasn't happened before that I'm aware of.
And in fairness to the Fair Work Ombudsman, they go to great lengths to support migrant workers to come forward and to seek advice and assistance on making sure they're getting the right workplace entitlements, including by having a dedicated section of their website for migrant workers with professionally translated information and resources and videos. They have a free translating and interpreting service that's available to anybody who has difficulty with English. And they have a range of engagement activities on the ground that are about increasing awareness of the agency and to assist migrant workers to understand their rights and entitlements. That goes hand in glove with the matters you've been discussing with Ms Parker.
I'm just asking in the Fair Work Ombudsman, is there an established process where Home Affairs will contact you before they begin trying to deport people who have come to Australia to work on the Pacific Labour Scheme or Seasonal Worker Program?
Look, as part of the protocol that we talk to each other and discuss these issues on a regular basis, we think it's effective. I mean, what is often the case is that we hear of employers threatening workers with reporting them to Home Affairs, and that then, we'll report you to Home Affairs and then Home Affairs will deport you. But in fact, when they're working with us, that's not the case. So they're misleading workers in that situation. And we hope that the message will get out that in fact they will receive our help if they come to us.
I'd also suggest it's probably worth asking Home Affairs for details of their protocol on how to handle these matters, just so that you've got both sides of the story.
Just back on this question, so just so I'm clear, that Home Affairs would normally speak to you about it before they approached. Appreciate there's a couple of things happening here. There's on the Seasonal Workers Program, Pacific Labour Scheme, now PALM, that the protocol regards those workers is that if Home Affairs intended to deport people, they would contact you, and equally, if there was cases that you were involved with, that you would inform them. Can you just clarify the process?
It's generally the case that the way the protocol works, it's generally the case that where workers have breached the work-related conditions of their visa, we would seek to ensure that Home Affairs is aware of that and their visa is not cancelled.
Has Home Affairs ever contacted you about issues of cases of exploitation?
I'll have to ask Mr. Ronson that. I don't know.
Yes, that they do. We've received a number of referrals over the years, including also from Australian Border Force, where there are concerns about workers being exploited. We can provide figures. I've taken that question on notice, but the answer is yes. We receive referrals from Home Affairs and from Border Force.
Good, thank you for that.
Senator, just to quickly clarify a point. So the point of the protocol is that it sits. It's called an assurance protocol. It sits under the overarching MOU between Home Affairs and the Federal Ombudsman, and the protocol is, I suppose, it seeks to do what it says it is, and that is to provide assurance to a migrant worker that even if they've technically breached a visa, work-related condition or any other conditions of the visa, we will strive to put their position to the Home Affairs and ask them not to cancel the visa, as Ms Parker said, so that we can continue our investigations against alleged exploitation. So the whole point is to provide a safe place and assurance to a worker who may be feeling threatened in some way.
Thank you, Mr Ronson. Whilst this terrible situation's occurring with regional workforce management, the Select Committee on Job Security has just had to obtain an extension to investigate a privilege issue. That issue is that the committee was informed that some Pacific workers who had provided evidence about the exploitation they had suffered were then threatened that they would lose their jobs and be deported. It seems to me that the government-approved labour hire employers are operating as though they're completely above the law. And if any workers speak out, Home Affairs throws them out of the flight, throws them on the next flight out of the country, which is in the case of this disturbing circumstance and freezing effect on people coming forward. If this report is correct from The Age, isn't it fundamentally important that we actually make sure that there is a proper circumstances where Home Affairs are operating? We've now got two situations, two examples of where the system seems to be breaking down.
It's not our experience of working with Home Affairs, Senator. We find them very helpful and cooperative, and as I said, we've referred 77 matters and they haven't taken action with any of those. They've been cooperative and joined up with us, I guess, in those matters. So we're not aware of the ones that you're talking about. They sound concerning and we'd certainly want to look into them.
There may be a disconnect between what goes on, I guess the rumour mill, for want of a better word, versus what actually happens, and it's hard for us, in the absence of more information, to be able to assess which category that is.
So you're suggesting this is a part of the rumour mill, Senator?
Now, we don't need to be like that, Senator Sheldon. I'm suggesting that we may need more information to be able to flush out entirely whether or not the things that you raise are going on. We're prepared to take that on notice if you'd like.
Through the inquiry, heard workers are taking home $100 pay for a 64-hour work week because of massive deductions taken by their employer. Is the Fair Work Ombudsman responsible for protecting workers from excessive, unreasonable or non-consensual deductions from the pay of temporary migrant workers?
Yes.
Thank you. If so, what are the actual restrictions on deductions that you can enforce? So if it's a harsh deduction, if it's a misrepresented deduction, as examples, I didn't want to isolate just to those, you may be able to give me some more.
Yeah, so exactly that. So the program, seasonal worker program, for example, had allowable deductions, and it's up to us to advise on what's reasonable and fair in those circumstances. Deductions are reasonable and fair, so some contribution towards accommodation is reasonable and fair. Contribution to food and other things is probably reasonable and fair, but these are judgments, and we work with the relevant department that runs that program to advise on that. And if things are unreasonable, workers can come to us directly and tell us, and we'll investigate the matter.
On the surface, evidence was given, and there was documents handed up in the previous inquiry that workers would have been charged $14.50 to be given water. Would you consider that as a reasonable deduction?
I probably will need to ask Mr Ronson again on that one.
Yeah. We'd need more information to be able to understand it properly. I've seen the document to which you refer, and if it's for a cup of water, it's unreasonable. If it's a brand new stainless steel water bottle, top of the range, and able to be reused for the rest of the year, maybe not. We just need a bit more detail to be able to assess whether or not that is something that is within the realms of the sensible and fair, or whether it's exploitation, and it could well be either.
And Mr Ronson, you'll be aware that there was and as Senator Stoker said, she's read through the evidence of the $14.50. You should be aware that there was eskies with water in it. The eskies were returned. It was the water they consumed. There was nothing else that was given to them in any other sort of fashion. There was no silver cup. It was $14.50 for the sake of having water. Have you investigated that matter?
We are investigating the matters, those entities that have been referred, those entities that were mentioned and discussed last week in the job security inquiry. We've commenced investigations into those firms and related entities that were discussed are involved. And just to draw back to Ms Parker and the Minister's statement, basically what we'll be looking at is this. Is there an agreement? Has it been entered into by the employee without coercion? Is the deduction reasonable? Is it to the benefit of the employee? They're the principles we'll be applying.
Thank you. How does the Fair Work Ombudsman, just to give me an understanding, assess whether the quantum of an accommodation deduction is unreasonable, and do you compare it to market rates for housing in that area? Is that one of the techniques?
That would be one consideration.
We've seen pay slips at the Job Security Committee, workers being charged $150 each to sleep in a room with 3 other people in bunk beds. So $600 for a small room with no air conditioning, no fan, sleeping for 4 people. They also share a kitchen with among 60 other people. Does the Fair Work Ombudsman have an ability to say that this is unreasonable and actually take action?
Yes, we do.
Yeah, thank you.
On the accommodation, I have to say we're not responsible for accommodation, but we are obviously responsible for referring matters where we see them and where we consider that to be unacceptable or questionable. On the other matters, certainly we will investigate.
So you investigate the quantum charged, and then if the facilities were inappropriate, you would then hand the matter to, sorry, just so I'm aware.
Yes, and are we talking about under prescribed programs?
Yeah, at this point, yes.
Yeah, so these would be matters that we would raise. The programs are run in a whole of government way, so there's a number of departments involved in those, and we work with them all the time. So it's a matter of sharing information, which is very much how we operate in these. So I'd say that the departments involved, DFAT, Home Affairs, we're involved, obviously Agriculture and others, are putting a lot of effort into this and working closely on it to try to make sure that they have a good experience when they come out here, and that when issues happen, they're dealt with quite quickly. And we're aware of what others are doing. So it's not a matter of we only do our own piece, if that makes sense.
Thank you. No, that's very helpful. Has there been any prosecution of any employers for giving substandard conditions, substandard accommodation? Substandard accommodation.
Mr Ronson?
Senator, I can confirm that the Fair Work Ombudsman is well advanced in an investigation in the horticulture sector which touches upon unauthorised deductions, and it's one that we're currently considering what enforcement outcomes should follow or should event. So the answer to your question is this is an area we look at. I cannot identify a recent filing of such a matter, but it is one where we're currently looking into a number of instances, and there's one in particular which is well advanced.
Thank you. Where you discover issues with labour hire firms, whether on farms or anywhere else, Are you permitted to share that information with state-based regulators in states like Victoria, Queensland and South Australia, which regulate labour hire firms?
We do work with states and territories that have their own labour hire regulators, and we share information, yes, but it depends on the circumstances. But it's not an automatic sharing because we have our own requirements under our legislation, what we can and can't share, but we certainly talk to them regularly. We could probably expand on that if Ms Peters...
That would be helpful. What can and what can't be shared would be helpful.
Louise Peters, Executive Director of Engagement Branch. Thank you, Senator. The Fair Work Act has a provision, section 718, which limits what information a Fair Work Ombudsman can share with other entities. One of those areas where we can share information is where the information will assist a state or Commonwealth authority enforcing the law. So obviously in those cases we will refer matters. I know in the horticulture space we have previously referred labour hire entities to the Queensland Labour Hire Compliance Unit, and I believe there were five entities that actually had their licence cancelled as a result of that referral.
Thank you. Earlier this month, DFAT put on an updated fact sheet on the Ag visa, also been referred to as the Anything Goes visa, seeing as Minister Littleproud has been bragging in the media about how little protections it will have for workers. The fact sheet says, I quote, "Discussions with Indonesia are advanced. Details are expected to be finalised shortly." What protection have you been? Has there been discussions with what protection that the Fair Work Ombudsman would be giving to if this Indonesian Ag visa is implemented, and would it be equivalent to the PALM scheme that happens at the moment, which we're seeing obviously many instances of exploitation?
Yes, the answer is we will. We're anticipating that our role will mirror that of PALM, so that will cover things like we will conduct compliance enforcement activities. We will conduct workplace compliance history checks for the administering department on potential employers. We'll conduct on-arrival briefings for workers in the seasonal worker program. We'll be developing in-language educational resources for participants. They're about their rights and entitlements while working in Australia, and also where they can go to get help. And workplace relations education advice to stakeholders, so that will include employers and program participants. So we certainly, we've been provided with some additional funding to support us undertaking a range of educative and program support and workplace compliance activities. So we'll support DFAT. They're obviously administering the program. And there's a whole of government approach, as I mentioned, Home Affairs, Agriculture, AGD, PM&C, and ourselves involved. There's a range of jurisdictions and regulatory regimes, but we'll work closely to ensure it's working as effectively as it possibly can be.
Thank you. Just could you explain what the role of the Pacific Labour Facility is in terms of providing support to Pacific workers in Australia?
Yes, I think I can. Can I refer to Ms Peters again for that one? Just for the detail, or I can go to that, I'll just find it.
The actual role and functions that are performed by the Pacific Labour Facility is probably more a question for DFAT. It's DFAT that has the contract with that organisation. My understanding is that the Pacific Labour Facility are involved in the on-the-ground support for workers. I believe that they run, for example, a 24/7 helpline. They have processes for issues that may arise, both critical incidents and non-critical incidents, and they provide support that way. Something that would need to be confirmed with DFAT. I believe there may also be sort of liaison officers and the like that also work with Pacific workers in the country, but the actual details of that contract and what functions the Pacific Labour Facility deliver under that program is more appropriately directed at DFAT.
Thank you. During the inquiry into job security the Pacific workers who appeared said they'd never heard of it. And I understand that Palladium was given $77 million. That was just before Julie Bishop, the then Minister, left Parliament to run the Pacific Labor Facility. If Pacific workers haven't even heard of it, I'm wondering if the government is getting value for money, Minister, acting or Assistant Minister. How's that?
Everything that the government does is designed to make sure that the measures represent value for money. If you have evidence to the contrary, I'm happy to look at it, but that is the motivation of the government at all times.
Well, I think the evidence was also in the Job Security Inquiry, and the evidence is in front of us almost monthly of more cases of exploitation going on. I'm also very mindful that even Australian Border Force has said that there's a serious concern about what's happening with regards how the workers have been treated on these sites. So
I might suggest that the Fair Work Ombudsman is here and ready and engaged. Well, let me finish, please, Senator Sheldon. And engaged and interested in making a difference in this field. And I suggest that you work closely with the Fair Work Ombudsman to make sure the right complaints are made so that they can be followed up, rather than waving around a Sydney Morning Herald article and suggesting that's sufficient for them to do the job.
Can I also just ask a clarifying question or an additional question? Because I completely acknowledge Senator Sheldon and agree that there are concerns about some people who come over through these programs and are not, the employers don't comply with what we expect the program to deliver. So I'm not trying to belittle that, and I'm not trying to pretend it doesn't happen. It absolutely happens. But have we got an understanding of the number of Pacific labour force visas on issue compared to the number of complaints we've had? And a secondary question is, I acknowledge and I know that when a complaint is received, the investigation takes place. On the flip side, an employer who has gone to the trouble of entering this program, employing people, often paying a lot of money to provide accommodation and the likes for their workers, and the workers abscond, who is in charge for doing those investigations? Because we know Fair Work Ombudsman investigates claims that the employer has breached their obligations. Who is in charge of the flip side, which I have several examples of, but trying to get to the bottom of who, you talk to Border Force and they're only obligated to do a portion, and there are companies who are feeling very left out in the process.
Look, I'm happy to take on notice the difference in the numbers in terms of how many visas are issued versus how many problems emerge from what we can call bad apples. It is true that you recognise the upfront investment that a lot of employers go to in order to facilitate hosting people under visa programs like this. It is my understanding that it is a matter for Border Force when a person absconds. Of course, Fair Work Ombudsman is about making sure people are remunerated fairly and treated fairly and safely at work, but nobody's indentured, nobody's forced to work. And so in circumstances where a person absconds...
That's simply not true.
I'll direct my answers to Senator Davey, because it's Senator Davey who's asked the question. And so in circumstances where nobody's forced into... I mean, we're not a country that does slavery, right?
Yes, you are. We have been, unfortunately, in previous years. Just like the Prime Minister denying blackbirding, which is occurring in this country right now.
Well, when you finished your tantrum, Senator Davey,
I am angry and frustrated about how this government's responding to those people.
No, you're disrespectful, and if you want to ask a question, you can do it when Senator Davies finished.
Finish her answer, and then you can have the call back.
And so if a person no longer works for their employer and they abscond, it becomes a visa matter that is dealt with through Border Force.
Thank you.
Senator Sheldon.
Thanks. Just on this question of palladium. Is there, have you come across palladium in your dealings with, as the agency on the ground? Have you come across palladium and its operations? I appreciate you've given an answer there before about some other questions about palladium and how they operate, but do the inspectors run across palladium on the ground? Because it appears where the problem is.
I'll just check with Mr. Ronson.
No, it doesn't tend to occur. I think the engagement would be more with Ms. Peters and her team.
Through the
Thank
department.
One of the activities that we do conduct to support the Pacific Labour scheme and also the seasonal worker program is to run technical briefings for the program administrators, so the department, so that they know what to look for. And the Pacific Labour facility has been involved in some of those briefings.
Thank you. Back to you, Chair.
Okay,
Senator
very good.
Pratt.
Oh, sorry, Senator Pratt.
Okay, I'll try and whiz through these. May I ask, please, it's been 5 months since the deadline for employers to make casual conversion assessments. Can you tell us how many complaints or requests for help you've received from casuals about conversions?
So we are seeing quite low numbers of requests for assistance about casual conversion. So our records indicate in the 6 months to 31 December 2021, we received less than 20 requests for assistance.
20, did you say?
Less than?
Less than.
Just under. That included a casual conversion issue. That's a very low percentage. We can finalise more than 9,500 disputes in that period. So
Okay.
yeah,
so what do
it's
you
low.
take that as a sign of? Is it that the provision's not being used? Is it that casual conversions happening without people needing to come to the ombudsman, or is it that is there something else going on?
I believe it's so the dispute process for casual conversions there's a number of steps, and the flow is only one of those. So firstly, the employers and employees must follow the process set out in their award agreement or employment contract when they're dealing with a dispute about the casual conversion, so that won't include us. And if they don't have a process in their award or contract or agreement, they are to try to resolve it at the workplace level, and they can refer the dispute to the Fair Work Commission. So again, we wouldn't be involved in that. If it's about certain casual conversion issues, they can commence proceedings in the Federal Court and the Family Court of Australia as a small claims proceeding, but they can contact us for additional help and information.
Okay,
so there's steps first. Is the
Okay,
answer
so
to that.
in terms of those steps, if someone was eligible but hadn't yet been offered a conversion, an offer of conversion by their employer, do they go to you or the Fair Work Commission?
So they can certainly come to us, and we'll provide them with advice and assistance.
How many offers of that advice, how many requests for that kind of advice have you had?
We've only had less than 20, so that's the totality of requests in relation to casual conversion matters.
Okay, even on the phone when people call?
Yeah, that's right.
So do you therefore think that means, given the number of casuals that are out there, 2.5 million of them, I don't know if you know how many of them may or may not be eligible for conversion, but it would seem pretty odd not to have had more calls to say, hey, my boss hasn't yet offered me casual conversion to permanency.
Yeah, look, I might refer it to my colleague, Mr. Hare. They are doing a review of the provision, so I've explained the steps that come in first. It is early days, I would say, as well.
Yeah. So again, Senator, I wouldn't want to speculate on whether low numbers means the program's it's working well or not. I think that's the intent behind the review, is to take a look at the substance of the amendments to the Act, the outcome that was sought, and then provide advice to government on following the outcome of that review. It's too difficult to speculate.
Okay,
on
so
what
you
would
wouldn't have
happen.
any data yet, please, that would tell us if someone has been fairly or unfairly assessed for eligibility, if phony grounds are being used to deny them, or any of those kinds of issues, because you wouldn't even have the data yet.
Not yet, no. And,
Okay.
And we're certainly monitoring and we're collecting it, so we will know.
Right, so once there's some data, if there's some data, you'll be able to tell us.
Yes.
Can I ask, are you able to undertake investigations to find wage theft or sham contracting? Are you also therefore empowered to investigate workers being refused a conversion offer?
We don't have an enforcement role in relation to, use of dispute resolution or small claims or how those matters are managed. We do have standing, they're in the NES, they're in the National Employment Standard, as you know. So we can bring proceedings seeking civil penalties, as we do with any contraventions of the National Employment Standard.
Okay, so that's how they would get it.
Yeah, that's how that's the role we could have through the National Employment Standard.
So it's not that someone's only hope would be if their employer consents to arbitration, it would be that you would be able to make a judgment as to whether a worker has been unfairly refused or not offered a conversion offer.
I think that, sorry, but I think Ms Parker identified that it wouldn't necessarily be about whether the workers refuse something. That would be an assessment of whether the employer is complying with their obligations under the National Employment Standards.
And if they're not complying, what is the remediation for
So
that?
we could, for example, we could issue a compliance notice, which is basically a notice that says you must do a certain thing if an inspector forms a reasonable belief that something that should have occurred didn't occur. And if they don't comply, if the employer doesn't comply, we can take the matter to court. So one aspect of this is, for example, the employer is required to issue a letter that sets out why a conversion isn't going to be offered. And in that letter, they need to provide reasons why a conversion isn't going to be offered.
Okay, so
And
in
so we
that
can-
context, I understand your answer, thank you. In that context, the University of Newcastle sent out identical form letters to thousands of casuals. Can I ask, does that raise concerns that a fair individualised assessment of each casual employee has not taken place? What action could you take?
It depends on, so we, as I said, we could look at whether the steps were followed correctly, as in, I mean, they're not required to convert, so it needs to set out why they didn't convert.
But is it not also supposed to be an individualised assessment for each person? Because if you're required to do an individual assessment, then that is part of what makes it difficult to just not say, to say, well, we're just not going to do a conversion. Because if you're required to make an individual assessment, then you'd have to invite people to be assessed, and therefore you would probably have to opt people into not being casual and to becoming permanent.
Sorry, can I just clarify that, Senator? So there's no requirement for the employer to invite someone to be assessed. The obligation is on the employer to do the assessment. It is possible, it is possible that people where an employer has found a set of criteria, such as they haven't been employed for 12 months, they don't have 6 months worth of regular pattern of work, there's not an ongoing basis for the work going forward. There's a range of exceptions there, that people will receive the letter setting out those conditions, because the requirement is that the reasons behind the non-offer are provided in the letter.
Okay, so the department's of the view that therefore the University of Newcastle could be compliant, because in sending out identical form letters, it doesn't mean it hasn't assessed whether people have done regular hours.
There's not enough information for us to say that, and nor is it our role, that they haven't done the assessment. That would be something that I think Ms Parker's identified the Ombudsman could look at in terms of have they complied with their process. That's the Fair Work Ombudsman.
All right, so given you've had only 20 odd, would you encourage staff at the University of Newcastle who got one of those letters but was interested in becoming permanent to contact you?
Potentially, but as I mentioned before, there's other steps they need to look at too. So they have, I haven't looked at the Newcastle award or agreement, but they probably have a dispute resolution procedure in there, and they need to actually have a look at that. And if they don't have one, then we do have the Fair Work Commission's dispute resolution powers, and there's small claims as well. So we would be saying, as I said, ours is about looking at process. Did they actually provide reasons in the letter? There are these other dispute resolution mechanisms they do need to look at first.
Yes.
So we would certainly take the call and hear the views from the person, and then we'd provide advice and assistance.
Thank you very much, Ms Parker, and thank you very much, Chair. We don't have any further questions.
Thank you very much, Senator Pratt. Sorry, did you have questions for...
Just a couple of minor questions.
Okay, sorry, Senator Rennick. I didn't realise.
Thank you.
Oh, Sir Robert, sorry. Sorry, it's late.
That's all right. I don't mind. Ms Parker, I'm not aware of the details of the Fair Work Act, immense as it is. I'm concerned with companies, employers, including universities, backfilling risk assessments. It's a topic Senator McCanavan touched on earlier. Backfilling risk assessments to justify their decisions on mandating injections. Is that part of your remit to explore that?
Look, it's a work health and safety matter. So if they are undertaking a health and safety risk assessment, as you say, they're doing it afterwards to make it look like...
Well, what I meant by backfilling is exactly that, to make it look like. They do it up front, but it's rubbish.
I understand, yes.
Yeah, you know
Look, it's a work health and safety issue, and they would need, I would encourage them, whoever you're talking about, particularly, to contact their work health and safety regulator in the state that it's occurring in.
Unfortunately, that's a state government.
Yes, that's correct.
Which is quite often putting the pressure on to mandate injections.
It depends on, there's a difference between mandating and actually coming up with a risk assessment after the fact. I think that's a different issue.
What I'm talking about is the risk assessment is done supposedly up front.
Yes.
But it's rubbish.
Yes. I still think they could contact the work health safety regulator, because that seems to me a breach of the requirements, but it's on the face of it, but we'd have to see it in...
Rather than the breach of due process in negotiating something.
Speaking in the general...
It appears that way, yes.
Speaking in the general, to reverse engineer a risk assessment rather than genuinely taking into account the risks and benefits and...
consultation.
And the genuine matters for consideration would, without giving you legal advice, be something that's fraudulent under workplace health and safety laws. And so I would suggest people in that situation take a good look at that and consider the safety regulator that's relevant to their workplace.
The only thing I'd add to that, Senator, is the work health and safety authorities are independent statutory authorities. So they operate independent from government, and it's not unusual for work health and safety authorities to take departments to court, etc., for where they feel they've failed in their duties. So people should have confidence in going to their regulators.
Thank you. One final question, just getting a gut feel from you. The massively thick Fair Work Act has got a hell of a lot of... I can see you smiling before you burst into laughter. Got a lot of complexity in it. And it works for the members of the IR Club, HR consultants, legal lawyers, large union bosses, employer associations that are kept in work by having problems to fix. The employer-employee relationship, which should be the fundamental and primacy of that relationship at work has been ignored, shoved aside, and too often vested interests get involved. Do you see any sense of that?
So what I would say is that it's our job to try to cut through that. So we've been established to try to educate and help people with that. So absolutely agree there's complexity, there's individual arrangements, they're all different, people have case-by-case issues. It's a complex system, but so's work, so's life, so's going, you know, everyone with different jobs has a different arrangement. That's the nature of the business we operate in. Our job is to try to cut through that and help people to determine what's the right thing to do. So if an employer rings us, then we will talk them through what it is they're concerned about, and we'll help them to make it right. We can provide them with outsourced legal advice. We can give them written advice. We have very good education products, very good websites. We try to make them simple. We consult on them. We get feedback on them. We have a small business hotline. We work very hard to try to simplify the system as much as possible so they don't have to feel overwhelmed, which is what I think you're talking about.
In fairness to Ms Parker, she only gets to work with what we parliamentarians give her.
Exactly.
And it is a very large and it is a very complex act. But as you and I know, Senator Roberts, it's the kind of sensitive area that requires all the different parties in this parliament to work together in order to get it through. And as we saw recently with the last industrial relations bill to come before this parliament, some in this parliament would stand in the way of the kind of simplicity and transparency that makes it fairer for everybody, and that generates the kind of economic opportunity that works best for the people who need it most in our community.
Can I just highlight, hang on, Senator Roberts, can I just highlight we are 20 minutes over our supper break, is it? What do they call it? Late break. I like supper better than traditional.
There are many workers now not getting smoko because of this.
It's too late for a smoke, Senator Roberts, but did you want to continue, or as I say,
yeah, just very briefly in response to the Minister.
You can be very brief, thanks.
The complexities make it impossible for some small businesses and especially for some workers, including those represented by so-called big unions, because the union bosses are part of the club.
They are.
And so what we need, and Ms Parker alluded to it, the primacy of the workplace relationship between employer and employee needs to be brought back with unions if the workers want representatives. Got no problem with that. But I've already got Dave Noonan, Michael Ravbar, the BCA, other groups interested in exploring that issue, because the CFMEU Legal Council, the ETU Legal Council have both said we've got too many damn lawyers in this mess. They're lawyers.
Well, look, I don't disagree fundamentally with what you've got to say there, but the barrier doesn't lie with government. The barrier lies over that side of the room.
I would say the barrier lies with a lot of people in this room and other rooms.
Okay, well, I think we're getting into a debate. Thank you, Senator Roberts. Thank you to officials from the Fair Work Ombudsman. I believe there are no more questions for yourself.
Thank you.
So you are released. We will break now for supper. We will come back at 10 to 10 with Comcare, and I suspend the committee. Education and Employment Committee, we now have welcome officials from Comcare. Ms Weston, do you have an opening statement? Sorry?
No.
No, you do not? Okay. So I will be giving the call to Senator Sheldon.
Thank you. There's a copy of this press coverage from the Courier Mail, headed Comcare accused of unethical behaviour when dealing with police officers' claims.
I'll just second, yeah, that looks fine to me. Everybody happy for
Sorry, I should say
tabled?
Good evening, everybody. Just jumping in there too quickly.
Thank you.
Ms Weston, are you aware of the newspaper article in the Courier Mail from the 5th of February that you have in front of you? Are you aware that this Comcare has been accused of unethical behaviour when dealing with police officers' claims?
Yes, Senator, I'm aware of that article. We responded to a request for information from the media outlet.
Thank you. According to the article, Comcare, which charges the Australian Federal Police $42 million per year in premiums to care for cops hurt on duty, has been accused of aggravating AFP officers' injuries with adversarial, confrontational and deceitful behaviours. Would you like to make a comment on this?
Senator, for privacy reasons, I can't talk about the specifics of a person. However, I note more generally that claims relating to psychological injury that are work-related can be complex, and also that workers' compensation claims can be, in some cases, distressing for individuals.
Thank you. A former officer, Kylie Walls, was reported in the article stating that despite her, and I quote, despite her well-evidenced PTSD claim, Comcare litigated against her using expensive private law firms, and doctor shopped while she was left without pay, funding her own medical treatment. What's your response to this?
Well, Senator, a couple of things I can say there. Comcare does have mechanisms in place to support individuals, including feedback and complaint services to help address service issues. And I certainly do encourage individuals or the representatives to contact us. We have reached out to the lawyer mentioned in that article and to find out more about the concerns. We have been working very closely with the AFP to improve the experience of AFP members, particularly those with psychological injury. We have a dedicated team to manage the close to 800 AFP open claims. We have a service commitment setting timeliness, critical claim pathways and other services that are above the general pathway timelines we have, specifically for the AFP. We have structured senior management oversight, so we meet regularly, quarterly with respective senior leaders and fortnightly with the operational teams in the AFP and Comcare. And we've been working to streamline processes. I note the AFP Association has recently noted that Comcare has been streamlining compensation processes to cut the paperwork. It's in an ABC article last October. I would note, Senator, that the acceptance rate for PTSD claims in the 21-22 financial year is 89%. And on timeliness, the average time taken to determine a claim in 21-22 for an AFP member has dropped to 22 calendar days, down from an average of between 34 and 39 calendar days in previous years.
The former AFP officer, Brad Turner, said the Department of Veteran Affairs rescued him when he was suicidal and couldn't get Comcare to fund a life-saving treatment because it was for depression and not considered a compensable condition of PTSD. Can you explain to me why did Comcare deny critical life-saving treatment, which has proven successful in the past, for an ex-Australian Federal Police officer, Brad Turner, who was suicidal?
Senator, as I said to you, I really am not in a position to talk about the individual circumstances. It's a privacy issue, and I can't do that. But I reiterate to you that we have been working very closely with the police. Some people, I won't go there. That's in the privacy space. Sorry, Senator. Yes, we have been working close, as I have indicated. I do encourage people to give us feedback. We have been working really hard on making efforts to put teams in the system, in the Comcare system, that are looking at the experience of people in the system. I do note that the Federal Police have a new program called SHIELD, which is providing evidence-based health and wellbeing services into the day-to-day operations of AFP employees, former employees and their families. And we are currently working, for instance, with the AFP to make sure that anyone who's in the SHIELD program has a smooth pathway to a claim, if that's where that needs to go.
And what does that mean? That means that what's planned with that streamlining is that they won't need to, the information they've already provided to Shield can be put through into the claim without them having to repeat the injury, which we understand from the police is a particular area of concern for them to have to repeat, and also to overcome some of those concerns that we have to explain the claim process and go through all of that, which can be distressing, as I said before.
Sorry, did you want to? We had something else. I'm going to cut you off. Can you explain to me why depression is not considered a compensable condition under a post-traumatic stress disorder claim?
Well, depression, there are people who have depression who get compensation claims. I'm not sure about what you're alluding to there, but certain, I might have to get one of my colleagues to help here, but certain, PTSD manifests in certain ways, and obviously it's important that we work with our clinical panel. We understand the sort of things that a PTSD claim may give rise to in other health conditions.
Why, in the case of the ex-Australian Federal Police Officer Brad Turner, did Comcare fail to reveal for 6 years to his wife Vanessa that she was eligible to receive home care assistance?
Senator, in relation to home care, I would note that there is information available on our website. We encourage our occupational therapists and our claims managers to advise clients of that information. I'm not speaking about the Turner matter, but I can assure you that there is information available, and we encourage. The implication there is that we are not allowing people to know about services and entitlements for which they are eligible, and our website does make that clear.
So, I mean, and you say that there's clinicians, if I understood correctly, are expected to make people aware of those sorts of arrangements. Are you investigating the allegations regarding regarding the Brad Turner matter and the allegation of his wife Vanessa not being revealed to her for 6 years that she was eligible to receive home care assistance?
Senator,
on the surface, something appears to have gone wrong.
We take feedback and complaints seriously, and as I said, we are reaching out and have reached out to the lawyer mentioning the matter, and so we are taking steps to follow up concerns that are raised with us.
How many ex-Australian Federal Police officers have active claims with Comcare?
They wouldn't necessarily be ex. I'm sorry, I can probably take that on notice, but I can say that we have just under 800 open claims of Federal Police members, including ex-Federal Police members.
Thank you. If you can come back to me on notice about how many are ex, thank you. How many are currently being fought by Comcare in the AET?
I take that on notice, but I do reiterate the acceptance rate for PTSD claims in this financial year is 89%.
And how many claims have been denied in the past 3 years?
I take that on notice.
Does anyone else there have that information there, Ms. Weston?
Aaron Hughes, General Manager, Claims Management. Not for the last 3 years, Senator Sheldon.
For the last year, or for what period you do have?
Is your question how many claims, what's the acceptance rate?
How many claims have been denied in the past 3 years? But if we can break that down to 1 year, 2 years, 3 years.
Yeah, so we would have to take that on notice in terms of the actual numbers, yes.
So you don't have 1 year, just last year?
Not the numbers, no.
Is Comcare considering giving Australian Federal Police officers a blue card similar to Defence and accepting a non-liability scheme for psychological injuries like the Department of Veteran Affairs does? And to me, this seems like a quite critical consideration in light of the pressures that, there's a great deal of similarity between the Defence Forces putting themselves on the line as police officers putting themselves on the line. And as I'm sure Ms Weston and your team are aware, it's not only those people that are actually directly involved in an action, it's those that are affected around those people that are involved in an action. It can be their colleagues fearful of the same circumstances befalling them. So what's the, are we going to give a blue card to the Federal Police, just like the Defence Force appropriately has?
So, Senator, that's not a question for Comcare. That's a question for the policy agency, which is the police's portfolio agency, which is Home Affairs.
Yeah.
Thank you. No further questions from me.
Senator Pratt.
Thank you very much, Chair. Can I ask in relation to, I haven't got any advice as to how we would like to use the rest of our time, but can I ask very briefly about the Border Force Marine vessels and their COVID episodes?
If I can just, sorry, Chair, my colleague, let's interrupt you for 1 minute. Just want to clarify something.
Yeah.
Just make sure I've got this clear. Just so as I understand it, the agency that's responsible for the Commonwealth Workers' Compensation Scheme, the agency responsible for the Workers' Compensation Scheme has come here to estimates, and you don't have the figures for the number of rejected claims for either last year. Is there anybody that can actually make those available to us that would have that information available to us tonight?
Well, Senator, not at this time of night. No, we can make inquiries while more questioning occurs and see if we can find that number for you, but I can't guarantee it for you now.
In light of the fact that this has been a topical issue in the Courier Mail, I'm just deeply concerned that there wasn't further preparation done. I'm very mindful this is the last estimates before the election, and I'm particularly concerned that something that logically would be a matter of potential concern of any senator, that the answers, some fundamental answers that are important to these allegations, isn't being presented to this estimates committee.
I'd just slightly, not to quibble, but we probably will have some estimates after the budget. I'd say like we did in 2019.
Very pleased to have followed up.
Take your point. Okay. Senator Pratt, are you ready?
Thank you very much, Chair. What's the status, please, of your ongoing inquiry into the management of COVID-related health and safety risks on ABF vessels?
So, Senator, are you referring to the Marine Unit?
Yes.
Yeah. So we have a number of inspections underway in relation to the management of the risk of COVID in the Marine Unit. I think last week, Senator, we had Comcare inspectors conducting a site inspection on board vessels in Darwin.
Okay, I understand that the improvement notice in January asked for a total of 8 weeks to complete COVID safety protocols, but in that time up to 6 officers tested positive and had to quarantine on a Cape class vessel. What's the hold up on those protocols?
It's 24th of January, as you say, an improvement notice was issued in relation to the WHS Act Section 19(3)(c), which relates to the safe system of work. I might just ask my colleague who is in Victoria, on the screen there, Mr Napier, to provide you with a little bit more information. It's very loud.
We're getting a
Can you
lot
hear
of...
me, Amber?
Yeah, where are you coming from? Outer space? It's
Victoria.
we're getting a fair amount of feedback of some nature. It's a bit different than normal feedback.
Is everyone else not speaking on mute? Yeah, okay.
I think, but did you? But if they, do those officials want to speak? I suppose they. Anyway. Okay, we'll move on.
Okay. Can I ask?
We certainly take that on notice, Senator, to give you an update on that. But there were certainly some directions and some recommendations that was in that improvement notice, our inquiries are ongoing. As I've mentioned, we were undertaking a site visit.
Okay.
Sorry, did Miss
So
Smith?
your inquiries-
Sorry, Senator. It's a bit hard, obviously, with people online. But did Miss Smith? Did you want something? Did you want to add something?
So this is Bev Smith, who is Director of our Regulatory Operations, Senior Director of Regulatory Operations.
Okay, call is yours, Miss Smith.
Yes, Senator. The improvement notice was a 2-week turnaround, and the date for completion for that was the 8th of February, and we had inspectors on site from the 9th to the 11th of February, and the inspectors were reviewing the controls that were recommended in the improvement notice. I spoke to the inspector today, and his view was that the department had put in place procedures that were reasonably practical in the 2 weeks since receiving the improvement notice, that the risks are now being controlled.
Okay, are you able to tell us what those improvements are?
Essentially, the improvements were in relation to the a risk assessment in terms of looking at control of transmission, in terms of moving with staff, with the Border Force staff entering the boats, and so there was an issue about transmission coming onto the boats and clarity about procedures in relation to that. So they had addressed that and they were looking at a testing regime. At the moment, there is an issue with access to RAT testing as part of that, I understand, but that procedure is under development. The other issue was around the isolation of Border Force officers on the boats.
Yes.
In terms of the facilities that were available on the boats.
Yes, that's my concern too.
Yes, so the inspector went on board. Initially there were some, I think the inspector reported that there were 2 officers who had volunteered to go into accommodation that was used in relation to detainees that were brought on board the boats, but that was voluntary. They had asked, they were quite happy to be put into that accommodation. However, since then, they've been working through looking at appropriate cabins on the Cape-class vessels, which essentially now they've identified cabins that are much better situated in terms of the ventilation. So it's sort of at the end of the ventilation cycle, if you know what I mean, like it's the last cabin on the ventilation. So
I think if you're locked in the one room, you should be in the best cabin on the ship rather than the worst one. If you're not able to leave that room, I wouldn't really care who the officer was or who had the best room. You'd think, right, if you've got to stay in the one room, provide to keep everyone else safe, that would be reasonable.
Absolutely, and our inspector spoke to marine officers. He spoke to the commanders of the vessels, and there is now a sort of, in terms of the procedure, to look at what is appropriate. There is discretion there for the commanders, so they can actually speak to the staff to work out what would be appropriate accommodation in relation to the in relation to isolation if it was required.
Okay, so in terms of the issue still being monitored, it's the implementation of new protocols and addressing those improvement notices. And is there further scope to that ongoing investigation?
Yes, we still have an ongoing inspection in terms of, because the improvement notices related to the Cape class vessels. We have an inspection which was initiated in relation to a separate complaint that came through from the CPSU, and that's looking more broadly at controls across all classes of vessels. So that is ongoing.
And when was that initiated? Because as I understand it, the CPSU has been asking for 2 years to call on for the Department of Home Affairs and the Commonwealth Government to ensure safe working conditions and adequate COVID testing on vessels. When did you start action on this?
So for this monitoring compliance, the CPSU wrote to us in January regarding their concerns, and so this one was initiated in January when the CPSU wrote to us with their concerns. So we met with the CPSU and we met with health and safety reps to understand those concerns.
Okay, so the CPSU didn't get any joy from going to the department, so eventually came to you. And do you know how many officers have contracted COVID on board?
It's probably a question there for the Home Affairs Department to confirm, I think, Senator. But we're certainly aware that some did.
Can I ask, would you not agree that, as the CPSU says, Marine unit officers do a dangerous and a tough job, separated from their families for many months of the year? They shouldn't be left out to dry by a departmental secretary that hasn't shown adequate concern for their safety. What did you...
Senator, we didn't say that.
Well, the union did. I asked...
Everybody agrees they do a very important and serious and valued job. But the remainder of your proposition isn't something about which the officer is capable of commenting, because it's not within their knowledge.
Thank you. Let me put it this way. Were you aware that a COVID positive officer who was forced to quarantine on a vessel for 5 days became seriously unwell and was only removed after intervention from the CPSU, and that COVID positive officers were forced to stay on the vessel in port without being provided the opportunity to get off the vessel?
So I'll take on notice that we have all of that information.
I don't think it was a question.
Ms Smith, do you have that awareness?
No, I'd have to take that on notice.
Would such a situation be acceptable, noting that we're 2 years into this pandemic?
I believe the officers really need much more context and the detail of the situation to be able to answer properly. If you'd like them to take it on notice, they can, but you can't expect them to provide what is in the order of legal advice based on cherry-picked statements from a CPSU media release.
Well, this is Senate estimates, and I've simply asked for a view from Comcare, and it's their job to assess these situations, and I know you don't have all the information, but if someone's seriously unwell and the department or those in control of the ship don't initiate having a sick person removed from the vessel and the union has to do it, surely that is a significant issue.
I'm sure all those matters would be taken into account, along with all of the other facts in the constellation of circumstances that would accompany any claim.
So,
Have-
Senator, we do still have 3 inspections ongoing in relation to that, and they will result in reports that will highlight.
All right, so
potentially
by
some of the
inspection,
issues.
that means past conduct of Border Force in relation to how it managed those issues will be reported on?
So we will assess the concern or the issue. Some of these were came from HSR representation. So we will assess the issues, and we will obtain information and work our way through our position on those.
Have you made any findings at this stage? Would you consider prosecution of Border Force for breaches?
So at the moment, what we have done, and my colleague will correct me, but we have issued an improvement notice with directions and recommendations, which have been reviewed by our inspectors who have conducted site inspections.
Okay. Are you investigating Border Force with respect to any other issues such as deaths in their holdings or COVID quarantine facilities or any other matters?
So I'll check whether we have any inspection activity underway on that front.
Hello, Justin Napier, General Manager of Regulatory Operations Group. Can you hear me this time?
Yes, thank you.
Oh, good, excellent, thank you. Senator, if I can just find my data on that one. We do have a number of matters at any given point in time that are underway involving the Department of Home Affairs. As at 30 September last year, we had 26 inspections that we had underway during that first quarter of this financial year. So that will include the matters you just mentioned, but there'll be other matters that we have.
Thank you. Are you investigating any other government agency with respect to preparedness and management of COVID and its workforce?
Since the outbreak of the pandemic, we've done a lot of work with a range of entities. In fact,
including Parliament, I would expect.
Yes, indeed. And at the end of last year, we completed a piece of work where we engaged with all PCBUs, all employers that we regulate, to ensure that they had satisfactory COVID controls in place within their organisations.
Thank you. In closing, I want to thank Comcare for the support that it's given to the CPSU in seeking to get these issues addressed with Border Force. That's it, Chair.
Thank you, Senator Pratt. I don't believe we have any more questions for Comcare, so thank you very much to all the officials. You can go home. And we now call officials from Safe Work Australia. They're here by the look of it, but are they actually, they're not in the room, so we'll just, but they're not here in the room, I don't think, so we'll just suspend briefly while we rearrange. Officials from Safe Work Australia. Ms Baxter, do you have an opening statement?
No, thank you, Chair.
Thank you. And we will proceed to Senator Sheldon.
Good, thanks. Good evening.
Hi.
Good to see you again. What is your agency's view regarding the use of rapid antigen testing for workers across the economy?
Excuse me, Senator, in terms of the agency view, it's probably more relevant in terms of what Safe Work Australia, the member body view is. We in the agency have been developing draft rapid antigen test guidance. That's currently out with our members for their approval. We've developed that guidance in conjunction with the AHPPC, and we're expecting our members to come back to us, although we asked them to come back to us by COB today. So we're just waiting on the last of, well, in fact, a few more comments from our members.
Can you fill us in what the proposal is?
Yes, it's essentially the same as all of our other COVID-19 guidance, which is under work health and safety laws, there's an obligation on the person conducting the business or undertaking, the PCBU, to ensure as far as reasonably practicable that either the risk and hazard are eliminated, or if that can't be achieved, that controls are put in place that ameliorate that risk and that hazard as far as practicable. So our draft guidance talks about that obligation on the PCBU, talks about the requirement to undertake a risk assessment in terms of the risk to the workforce and to workers and others in respect of COVID-19, talks about then what are potential control measures that may be reasonably practicable in either eliminating or minimising the risk or harm from COVID-19, and discusses the fact that a rapid antigen test may in fact be one control measure that may be reasonably practicable, but our draft guidance does note on its own, like all of the other control measures that we're aware of in relation to COVID-19, on its own, it's not going to be a silver bullet. It's not going to be the only thing that a PCBU would do or employ in terms of control measures. Ms Johnston is probably able to give more detail in terms of what the draft guidance says, if you'd like to hear from her.
Yes, thank you.
Amanda Johnston, Deputy CEO. So Ms Baxter has covered a lot of the guidance. The guidance does emphasise that we need to look at a RAP program in the context of all the other control measures that you need to keep employing in your workplace: physical distancing, good hygiene, mask wearing, all of those things. But it does make clear that a RAP program may be a control measure that would be suitable, reasonably practicable for some workplaces.
Can you outline for the committee any differences other than informed consent between an employer being required to wear personal protective equipment, PPE, example masks, gloves, to control, so far as reasonably practical, the risk of contracting COVID-19 and the requirement for a rapid antigen testing?
So, Senator, under the work health and safety laws, an employer PCBU has to do all that's reasonably practicable to eliminate or minimise risks. PPE is one way of eliminating or minimising risks. A RAP program is another way of doing so. So I'm not sure. So the work health and safety laws don't say you must do a particular thing in relation to a risk necessarily. It's principles based, and it says that you need to eliminate or minimise risk. So all of those control measures are available to employers or PCBUs. So I guess they're different control measures, but the duty on an employer is the same.
So they could be required to be, they could be, I'm saying, but they could be required to be operated in conjunction with each other.
They could be. It would depend on the circumstances of the workplace, the workforce. After you've consulted with workers, what you determine is reasonably practicable for your workplace.
How does the agency reconcile that under Section 273 of the Work Health and Safety Act, employers, PCBUs, requiring rapid antigen tests to be undertaken by employees but do not provide them? So when an employer doesn't provide, the PCBU doesn't provide a rapid antigen test, how do you reconcile that Section 273 of the Workers' Health?
Senator, I don't have Section 273 to hand, but if an employer determined that they were required under the work health and safety laws to provide a RAP program, our agency position isn't then that workers would have to pay for those RAP tests. That's not our view.
Thank you. What guidelines has Safe Work Australia provided to workers and employers regarding rapid antigen testing, which of course, as we know, is one of the control measures that can be utilised to minimise the risk of transmission of COVID-19?
So, Senator, as Ms Baxter said, we have that draft guidance that has been prepared. It's currently being considered by members for publication, but it hasn't been finalised yet.
Appreciate there's members involved, but is there an expectation on what the timeline would be for the policy and how it would apply for rapid antigen testing when that would be delivered for the community?
Yes, we're hoping to finalise it as soon as possible. Unfortunately, we do depend on our members to approve it. And so, as Ms Baxter said, we received comments from the AHPPC on the draft guidance on Friday. We've finalised that and provided it to our members on Monday. So we are trying to move quickly with the guidance, but we are now waiting for members to respond. We're hoping that they'll respond as soon as possible so we can publish as soon as possible.
We just have just a slightly different stab in a different way. Has there been an indication that that's likely to be quickly dealt with, and do you have an expectation where it's likely to be settled, or it's still some time off?
Senator, when I spoke earlier, I indicated that we've asked our members to get back to us, or we had asked our members, I beg your pardon, to get back to us by COB today. We have a number of responses from our members, but we have a number that are still outstanding. As Ms Johnston said, we are dependent on our members providing their approval to the requisite majority that we require.
The members that are outstanding, have they indicated that they've put a degree of urgency on responses?
I don't believe we've heard back from any of the members who haven't yet responded, but we will be following up with them tomorrow as is our usual protocol.
You're able to tell us who the members are that have responded and which ones haven't as yet?
No. I could take that
We can
on
take that
notice.
on notice. I wouldn't want to mislead you, Senator. We've had probably 4 members come back to us, but and we've also had other members who have not yet come back to us, obviously. So I'll take that on notice, and I can get you that response.
If you can give that to us, is that possible to give it to us quickly? Is that capacity to do that?
We don't have anyone waiting back in the office to chase things up this time
tomorrow,
of night.
practically.
Sure.
Good, thank you. Also, just how many rapid antigen tests have been provided to workers at Safe Work Australia?
How many have been provided by our agency?
Yes.
None.
Righto.
Do you mean to our own workers, Senator?
Yes.
Yeah, I think
Yes,
you did.
none. So currently we're not working in the office, we're working from home.
Thank you.
Okay, Senator Pratt.
Yes. May I ask, please, the appointment of Joanne Farrell as Chair of Safe Work Australia, are you aware of the report released by former Sex Discrimination Commissioner Elizabeth Broderick into the workplace culture at Rio Tinto?
Yes.
How would you summarise the findings of that report?
I actually have a briefing in relation to that.
Rather than asking the witness to summarise a report, do you just want it tabled?
No, I've got the report. I want to know what Safe Works Australia's view of the issues at Rio Tinto are.
Well, Senator, I'm aware of the report that Elizabeth Broderick has done in respect of Rio Tinto. Officers in my organisation have read the report. As I indicated, I have a short briefing in terms of the matter, but in terms of any further analysis in respect of the report, we haven't undertaken that as yet.
Well, it's made findings that are fairly significant in terms of the in terms of a culture that has widespread sexual harassment, and including sexual assaults having taken place at it. So accordingly, does the report describe a safe workplace for workers, particularly for women?
I'm aware that there were 26 recommendations in that report. I personally... Oh, sorry, Minister.
This is of dubious relevance in circumstances where this isn't estimates for Rio Tinto, this is estimates for the agency Safe Work Australia. I think it's important that we focus on what's relevant to the budget.
Okay.
Point of order.
Yes, Senator Sheldon.
We had this discussion earlier prior to you being here, Senator Stoker. This is this is going to the question of the appropriateness of people that are engaged in this particular case, the chair of Safe Work Australia. And looking at the appropriateness is looking at the terms of what the person was engaged in, and what environment were they working in and what environment were they involved in when they were selected to actually chair Safe Work Australia. So it is appropriate for us to be raising it. Second thing is, Senator, you seem to be interfering on every matter that comes before any degree, the slightest bit of controversy.
That's not a point of order.
It would be extremely useful that we don't have to go over to spillover, but if that's where we end up going, unfortunately, that's where we'll end up being.
Okay, I think I'm ready to
Senator
rule.
Sheldon,
I'm ready.
I will choose not to take that as the veiled threat it was.
I'm ready to rule here. I've got two issues with the questioning that's being pursued. I do agree with you, Senator Sheldon, that your questioning this morning was appropriate of the department and the government, given they had made the appointment. You're welcome to ask those questions. However, I would note that officials here from Safe Work Australia were not responsible for that appointment, and it would be unreasonable for them to ask to comment on that. Those questions are properly made to the government or the department who made that appointment. They were raised this morning. And the second point is, look, Senator Pratt, I've been listening closely. Some of your questions are starting to stray into the field of asking for an opinion, particularly here in the instance of an opinion on the work practices at a third party or a company. Again, I'd ask you to seek to raise questions with officials that relate to government policy or facts and issues that they have authority over.
Rather than dancing around it, since it was a decision for government, would you like me to directly address the substance of...
Well, no, we went over it at length this morning, Minister. I appreciate, but given the time, we can review the Hansard.
Ms Baxter,
Senator Pratt.
were you aware, of course, your new chair started in the position as chair on the day this damning report was released, is that correct?
Yes, I think that's correct, yes.
Okay.
If it assists, Senator, I just want to confirm I actually have no role to play in the selection or the appointment of a chair of Safe Work Australia. You'd be aware that in the Safe Work Australia Act there are provisions that require the minister to consult with her ministerial counterparts in the jurisdictions. There is nothing in the Act that requires any level of consultation or discussion with me, so I am not at all involved in that process.
We have established that this morning, and I will try to avoid that in my questioning. Was your agency aware of the Broderick report and its imminence when it was about to be released?
Not as far as I'm aware, no.
No, we had no prior knowledge of the report.
Until it was
Published.
released. Have you been involved at any point in discussions with the Minister's office about the content of that report prior to, well, I guess if you didn't know about it till it was released, since its release?
No.
So you haven't raised the content of the report with the Minister since it's released?
Senator, if I might, Safe Work Australia is the national policy agency in response to work health and safety. In terms of the subject matter within the report, that's far better placed with the state-based regulator, which is responsible for regulation in that state. They are the entity that is more likely to have an understanding of what's happening in workplaces within their jurisdiction. So at this point, I'm not sure that Ms Baxter is in a position really to comment on a regulatory arrangement or lack thereof in terms of workplaces within Western Australia.
Thank you. The perception for Safe Work Australia of its capacity to set policy in relation to safe workplaces for women, and we've had some discussion about this previously in the context of psychosocial harms and dangers and the need for those policies to be updated in the context of the work that the Respect at Work and that report. What consideration have you given to this report into workplace culture at Rio Tinto in the context of developing guidance on psychosocial hazards?
So, Senator, as I indicated, I am aware of the report, the agency is aware of the report, some of my staff have read the report, but we haven't undertaken any further analysis beyond that. I'm also aware that this is an issue particular in the jurisdiction of Western Australia, and I am aware that Western Australia has itself taken a number of initiatives in respect of fly-in, fly-out workers and some of the issues attendant upon those particular practices. And I think most recently Western Australia is developing or has just developed a code for their jurisdiction in relation to, and I'll correct the record if I'm wrong, but in relation to fly-in, fly-out workers and issues of psychosocial safety, including sexual harassment.
Senator Cash has given evidence to this committee that the government doesn't want to introduce a duty of care in relation to sexual harassment because it considers that the existing duty of care, which is still, by your evidence, previously being developed in relation to psychosocial hazards, needs to be assessed as to whether it acquits itself against that request and recommendation.
Respectfully, that's not the evidence that's been given by Senator Cash.
Okay, well, tell us what you think the evidence is. That's how I interpreted it.
So, if I may, it's my recollection of the Attorney-General's advice on that was that the model laws, the work health and safety laws that the majority of jurisdictions have in place, have a requirement that PCBUs work to keep their employees and others in the workplace safe, and that includes on a psychosocial basis. The further work that's being undertaken following the joint agreement, the unanimous agreement of ministers in their consideration of the Boland Review, was that guidelines be developed to support people's understanding of those obligations, those already existing obligations, and that indeed a code of practice also be developed to further support understanding there. My recollection is that Safe Work Australia has guidance up on its website in relation to supporting PCBUs and others to reduce or stop sexual harassment within the workplace. So it's quite clear that the duty already exists within the work health and safety laws. And the Minister was also clear in terms of the consultation.
Thank you for that explanation. That's a much longer explanation of what I was trying to paraphrase. Can I ask, Ms Baxter, do you have any concerns about the perception for your organisation if you have the chair occupying the position as chair, Ms Farrell, who presided over such a terrible workplace culture?
Opinion.
Has it had any ramifications? Has it come up as an issue? Not at all?
We haven't had any meetings of members' meetings, I beg your pardon, since Ms Farrell was appointed as chair, and no Safe Work Australia members have made any direct representations or representations indeed to me in relation to any issues relating to Ms Farrell.
Okay, my expectation, Senator Pratt, is the reason for that is that Ms Farrell is amply qualified for the role and was not the subject of any adverse comment or adverse finding or anything adverse of any nature in the report. So I'm deeply concerned that what's being engaged in here is a mudslinging match under parliamentary privilege that's designed to disparage a woman who's already had a formidable career and is now engaging in an important service to the Commonwealth of Australia by taking this role. It is really important that people understand just what a well-qualified, capable appointee she is, and just how much this report did not indict her in any way.
Okay.
So did you reach page 71 of the report, human behaviour and reporting?
Let me flip to page 71.
While you're doing that, maybe Senator...
So in the context of the Respect at Work report and agency data, recommendation 3 asks agencies that handle workplace sexual harassment matters work with the Workplace Sexual Harassment Council to collect data, de-identified complaints, claims, settlement outcomes, etc., establish formal arrangements for information sharing and data exchange, etc. So in that context, I understand Safe Work Australia is, as one of the relevant agencies referred to in that recommendation, is only intending to create a reporting framework that includes notification of serious acts of violence, including sexual assault. Is that accurate?
No, Senator. I think you're referring to an incident notification paper that we've prepared for consideration for members, and that is looking at exploring options for dealing with the notification provisions in the Work Health and Safety Act and trying to expand it to cover sexual harassment and psychological injuries where it doesn't already do so. So that's not actually related to the Respect at Work report. That's a different piece of work.
It should operate in isolation either.
Okay, can I ask in that context, if you're moving towards a positive duty, which we don't need to debate whether it's in Safe Work or in the Sex Discrimination
Sorry, Senator,
Act.
just to intervene, we have a positive duty. We're not moving towards one. We have an existing one.
Correct.
In
This is the
that
thing that Labor
context-
policy
No, no,
just
I'm not
refuses
gonna-
to accept.
I'm
There is
not
already
going to
a
debate
positive
it
duty.
now.
Well, it's not a matter for debate, it's a matter of fact.
In
There is a
exercising
positive
your
duty in
positive
place.
duty, which you maintain there is, that's fine.
Because there is.
Can I ask, how do you record inquiries, complaints and claims relating to workplace sexual harassment matters?
So inquiries and complaints are not within our remit. We're not a regulator, so we don't record those at all. For claims of sexual harassment at the moment, they're characterised as, or sorry, I don't know if I should get coded. That's the word I'm looking for. They're coded as depending on the type of injury that occurred, a mental health injury or a physical injury, if that is one, but they're not coded directly as sexual harassment. They're coded as harassment, and that could be racial or sexual.
What I'm trying to work out is I don't understand how you can say that there's a positive duty if you are only being notified of serious acts of violence, including sexual assault,
So I might
in
try
that
and-
data obligation.
I might try and clarify. So there's a distinction between the policy agency, which is the role that Safe Work Australia feel, versus the regulatory agencies who actually receive the notifications. So the responsibility for addressing the what's actually happening on the ground in terms of complaints, etc., is the responsibility of the individual regulatory bodies within the states, territories and the Commonwealth.
Okay, so
that's the other part in terms of the basis for saying that there is a positive duty sits within the Act, where it's quite clear that an employer must do things to prevent. And indeed, when you have a look at the penalty clauses, it's quite clear that people can be prosecuted for offences that haven't resulted in injury, but they have the potential to cause injury. So the Act is quite clear on the matter.
Okay, Thank you. Can I ask where reporting will take place in terms of the data for sexual harassment that falls below the high threshold of serious acts of violence or sexual assault?
Well, again, Senator, you're referring to the incident notification scheme. So that's not a reporting scheme. That's where the PCBU reports to the regulator that there has been an incident at their workplace that falls within the definition required by the Act. Reporting and the Respect at Work Council work, that's a different matter, and we're looking at ways that we can improve data collection. We're working with them, but at the moment it's workers' compensation data that we rely on.
Okay, so why won't you pull in, if that other data is being reported through those other processes, why is that not also being reported?
Sorry, Senator, which other...
The incident notification data. I think it's a question that goes to volume. Our understanding is that there would be thousands, if not hundreds of thousands of incidents reported to regulators across Australia each year.
It would also rely on the states and territories providing us with all of that information, and at the moment there's not agreement that they do so.
So doesn't the volume of hundreds of thousands of notifications point to the extent of the problem and the reason the data should be collected?
So Ms Baxter is referring to all types of notifications under incident notification, not that there's hundreds and thousands of sexual harassment notifications each year, or would be under the new system that we're developing.
So why don't you seek to capture, if it's not therefore hundreds of thousands, why don't you capture the notifications that relate to sexual harassment?
Well, at the moment, it's not always the case that sexual harassment will fall within the notification scheme, which is why we're doing that piece of work that you referred to, looking at expanding the definitions and capturing different types of notifications, and is currently the case. So at the moment, those sexual harassment may or may not be notified to regulators, and so they may not be collecting that data at the moment to give to us in any case. But there's not a line where we get incident notification reporting.
Even though reportedly this positive duty already exists.
Yes, because as Mr Hare said, that positive duty refers to a prevention that we have in place, and notification is after an incident has occurred. So all PCBUs have a duty to eliminate or minimise risk. That's the whole scheme of work health and safety, is prevention, and so that is the positive duty. Just because there may have been an incident occur, that's a different matter to setting up a safe system of work to ensure prevention, and that's what regulators are looking for.
Who decides whether employers do or do not have to report on forms of sexual harassment that may not meet the threshold of serious acts of violence or sexual assault?
So that's not in place at the moment, so that's a proposed definition. So at the moment, that's not relevant.
Is it within your power to propose that the definition does collect that data?
Yes, and that's what the work is that we're undertaking.
So you haven't decided you'll rule it out yet?
We don't decide those matters, Senator. That's a matter for our members to decide what's in, and then ultimately WHS ministers to agree to amend the work health and safety laws. So no, we won't decide that. It hasn't been decided at all. At the moment, what you're referring to is an options paper.
Okay. What can you tell me about whether that process, the process you're in charge of as Safe Work Australia, will meet the standard expected within what the sex discrimination report into sexual harassment recommended?
I don't think that the Respect at Work report was specifically referring to incident notification collection under the work health and safety laws. I think it was talking about reporting more broadly and working together.
Okay, but it was certainly expecting a higher level of reporting and data other than just serious acts of violence or sexual assault.
Yes, so I guess that's why that piece of work will go much more broadly than just what we're doing in terms of incident notification.
Okay, and when do you think that will be concluded?
The Respect at Work or our work?
Your work.
As I said, Senator, at the moment we're only at an options paper, but we're hoping to have the work progressed by the end of this year. It's a actual recommendation falling from the 2018 Boland Review, and so it's work that we're hoping to have finalised by the end of 2022.
Thank you. Thank you, Chair, and thank you for taking me through those matters.
We don't.
Just a very brief
Senator
question.
Sheldon's ruining the party, but go for it, Senator Sheldon.
Yeah, I can't help myself. Minister, you drew your attention to page 71, harmful behaviour and reporting, and it raised concerns about the operations and HR. A number of those report backs. There's a series of examples and concerns that are raised.
I've read the page.
Does that?
Yes.
Thank you. Are you concerned that that's the environment that was occurring at as described by these people in this report, very important report, describing what was happening in the HR office and perception of the HR office at Rio Tinto?
I think the report draws out many things that are troubling and many things that require action. But I noticed that you only refer to one page and you don't go to any of these things in context. It's the cherry picking for which you are becoming famous, Senator Sheldon. And so I think as we acknowledge those problems, which on the report, on this report seem real. Well, let me finish my answer. On this report, there is also a commendation at page 74 on the significant shifts that have occurred to improve culture in recent times, that there's been an everyday respect task force, that there's a change agenda. Now, I'm not going to read that out to the room either, but if you're going to try and suggest that the actions of a bunch of unnamed people need to be pegged around the neck of a person who is not named and is not condemned by this report, but at the very back, at the conclusions, is acknowledged for, you need to also acknowledge the progress and effort that has been made to address these things which are historical. Now, I don't want to split hairs over this report. What I do want to see is a credible, capable woman who has been appointed in the most meritorious way to a role, given the fair go she deserves.
And thank you. I just, in light of those comments, that the importance of the entire document, yes, I could take you to the entire document. I've taken you to the section, page 71, which deals with the question about how the HR department, human resources, which Ms Farrell was head of,
Sheldon,
and the performance of the HR department during this period. I mean, there's been assaults, there's been rapes during this period. You know, it does go to this serious questions in this report, and don't try to say that they're not serious or they're not important, or there hasn't been a miscarriage of justice against so many workers at Rio Tinto these last number of years, whilst the head has been Ms Farrell.
Well, I don't think that's a fair characterisation. You have absolutely no evidence whatsoever that either the time or the location or the conduct correlates with her involvement whatsoever. And furthermore, she is neither named nor criticised nor mentioned nor the subject of any adverse finding. And I hope that you will give her the procedural fairness that she deserves as she goes into this job.
On time too, so thank you very much, senators. Thank you, officials. Of course, the officials from Safe Work Australia are released, and that concludes today's proceedings. The committee is due to recommence its examination of additional estimates tomorrow, Thursday the 17th of February. Once again, I thank the Minister, the Attorney General's Department and all witnesses who have given evidence to the committee today. Also, of course, thank you to Hansard and Broadcasting and the Secretary for the work they've done. I will suspend, is that what we do? No, adjourn the hearing. Thank you.
Thanks, Chair.
Thank you.